Good evening, students. Let's start with the marathon of ECIPL, that is Economic, Commercial, and Intellectual Property Right Laws, which is one of the paper of your module 2, which is being divided into two parts. The first one is Part A, which is dealing with economic laws, which includes like FAMA, FICRA, Foreign Contribution Regulation Act, right? It includes SEZ, it includes consumer protection laws. So many laws are there when it comes to ECIPL, Economic, Commercial, and Intellectual Property Right Law, Part A. Part A is being carrying 60 marks ka weightage, and Part B is carrying 40 mark ka weightage, which is nothing more than intellectual property right laws, right? Total number of chapters are 20 chapters, out of which 14 chapter belongs to Part A and 6 chapter belongs to Part B. Okay. The most important chapter, if I'll divide the syllabus, I can divide the syllabus into certain parts. If I'll go ahead with the foreign exchange related laws in Part A, chapter number 1, chapter number 2, chapter number 3, 4, 5, 6, 7. These first seven chapters are related with foreign exchange. First seven chapters are dealing with foreign exchange. Okay, carrying a weightage of around 30 to 40 marks of your syllabus. Next three chapters are related with money, economic offenses. Okay, economic offenses, and they are carrying on an average weightage of around 5 to 10 marks. Okay, and next remaining four chapters are related with consumer protection laws, carrying around an weightage of 20 marks, 10 to 20 marks. Okay, so if we'll divide the Part A would be divided into first seven chapters. First seven chapters are dealing with foreign exchange related matters, carrying a weightage of around 30 to 40 marks. Second part of the Part A would be economic offense related laws, which is money laundering, fugitive economic offenses, and Benami Transaction Act, which is carrying on an average weightage of around 5 to 10 marks. Remaining four chapters are consumer protection chapters like competition law, consumer protection law, legal metrology law, and RERA. These are dealing with what consumer protection matters, and they are carrying on an average weightage of 10 to 20 marks. So first seven chapters are the most important chapters. In this marathon, we'll start with the most important chapter, that is FEMA, Foreign Exchange Management Act. So when it comes to Foreign Exchange Management Act, this is an act that has been passed by the Parliament in 1999. When it has been passed, 1999. The procedure of this act was a Foreign Exchange Regulation Act, that is FARA, Foreign Exchange Regulation Act. It was having certain issues, so in order, and such issues could not be managed through amendment, so government has decided to repeal FARA, and they have came up with FEMA, that is Foreign Exchange Management Act. Okay. The power of implementation of this law lies with the Reserve Bank of India. All the provisions of FEMA is going to be implemented through the Reserve Bank of India. All the powers of making rules, making regulations, getting implementation of this act lies with the Reserve Bank of India. Okay. What is the basic objective of this act? To manage the foreign exchange over here in India, means all the transaction which involves foreign exchange, whether it is import, export, emigration, going out for family holidays, going out for employment, is going to be regulated by this act, because every transaction which is a cross-border transaction would involve foreign exchange, and you have to follow FEMA. So it is not going to be applicable only on business operations. Even if I'm going outside India for a family trip, I have to comply with the requirement of FEMA. Got my point, students? Is it clear? They are also going to regulate the trade related payment and personal payment, and to ensure orderly development of foreign exchange market over here in India. There are three objectives of this law. First one is the law related with, to provide for the consolidated law related with foreign exchange, to facilitate external trade and payments. Third one is to promote orderly development of foreign exchange market over here in India, whether it is inbound transaction, that is when a foreigner is coming over here in India and getting into a transaction, it is known as inbound. When we are going outside India and making investment or making transaction, that is called an outbound transaction. Both the transactions are going to be regulated by this act, right? Is it clear? Whether it is overseas investment or current account transactions or capital account transactions, all are going to be regulated by FEMA. We are going to go ahead with all these things. Okay. This is applicable all over India, including state of Jammu and Kashmir, because Article 370 has been removed, right? I'm going to, being a marathoner, I'm going to cover only important aspects. Now I'm going ahead with the very important aspect. What is the difference between foreign exchange and foreign security? Whenever we are talking about foreign exchange, we are talking about actually foreign currency, but it does not only include foreign currency. If any Indian individual has put investment, put money in any kind of bank deposit, which is going to be payable in foreign exchange, that is called resident foreign exchange currency account, exchange under foreign currency account, right? So if a person who is resident of India is holding any foreign exchange in the form of bank deposit, that bank deposit would also come under the definition of what? Foreign exchange. Even it includes traveler's check, letter of credit, and bills of exchange, which is going to be payable in foreign exchange. So three things will be the part of the foreign exchange. Generally, whenever we are talking about a foreign exchange, in ordinary case, we understood foreign exchange only includes foreign currency, but whenever we are talking about foreign exchange in law, it includes foreign security, sorry, foreign currency, I'm so sorry, foreign currency. It includes foreign currency. It includes deposit with the bank, which is going to be payable in foreign exchange, and any banking instrument in the form of traveler's check or letter of credit, which is going to be payable in foreign exchange. Got my point, students? Is it clear? Even if an instrument is expressed in Indian currency, but it is going to be payable in foreign currency, it will be the part of the foreign exchange. Got my point, students? That is the definition of foreign exchange. What is foreign security? Foreign security includes any share, debentures, bonds, stocks that has been issued and represented in foreign exchange. Even if their interest, dividend, or redemption is going to be payable in Indian currency, but if they are being represented in foreign exchange, they would come under the definition of foreign security. And whenever we are talking about foreign security would always be a capital account transaction. It would not be a current account transaction. Now, what is capital account transaction, student? If you are getting into a transaction which is going to lead to create any asset or liability cross border, means if I'm buying any property or making any investment outside India, I'm creating an asset outside India, it will be a capital account transaction. If I'm taking any loan from outside bank, I'm creating a liability outside India, that is a capital account transaction. If a foreign person is buying any flat or property over here in India or taking any loan from Indian bank, it is creating an asset or liability inside India belonging to a person resident outside India, so it will be a capital account transaction. So whenever you are making investment in foreign security, what you are creating is asset outside India, right? So it will be classified as a foreign security and capital account transaction. Got my point, students? Is it clear? So whenever we are talking about foreign exchange, it includes three things. First one is foreign security, is the first one is foreign currency, the second one is deposits, the third one is banking instrument. Whenever we are talking about security, foreign security includes share, debenture, bonds, anything which is represented in terms of foreign currency, right? Right, students? In foreign currency is going to be involved in both capital and current account transaction, but security would always involve capital account transactions, right? Right, students? I have in my notes, even I have written an answer in my own language that will help you to understand that how to write an answer in exams. Got my point, students? What I'm teaching you is Foreign Exchange Management Act, right? Now, what is authorized person? I'll teach you about authorized person thoroughly in this topic itself. Whenever we are talking about authorized person is nothing more than the bank. It is nothing more than a bank or a money changer who has been duly authorized by Reserve Bank of India to buy, sell, or deal in foreign exchange. Means any bank or any institution or any individual who has been duly authorized by Reserve Bank of India to buy, sell, or deal in foreign exchange would come under the definition of authorized person. So, like when it comes to capital market intermediary, if we are talking about capital market intermediary, they are nothing more than the intermediary approved by the SEBI or authorized by SEBI to buy, sell, deal in security instrument over here in India, right? In the same way, if I want to buy foreign exchange, I have to approach authorized person. If I want to surrender my foreign exchange, I have to approach the authorized person. If I'm planning to go outside India and I want to have foreign exchange, I have to approach the authorized person. If I want to invest outside India and I need foreign exchange, I have to approach the authorized person. So the person who is authorized by Reserve Bank of India to buy, hold and sell or deal in foreign exchange is being classified foreign exchange or in foreign security will be treated as what? Authorized person. When it comes to authorized person, section 10, 11, 12 is dealing with the same. I'm teaching you the basic thing. When it comes to authorized person, remember students, the authorized person have to get himself registered with a Reserve Bank of India by making due application as provided under this act. Section 10 clearly states that no person over here in India can act as an authorized person until and unless they are being registered with the Reserve Bank of India as an authorized person. So registration is the primary requirement to act as an authorized person. First thing. Second, they are saying that once you will be registered, you would be subject matter of certain terms and condition. Your registration certificate would carry certain terms based on which registration has been given. So in order to continue your registration, you have to satisfy all the rules and regulation that has been made by Reserve Bank of India, all the circulars and notification which is coming out from Reserve Bank of India. You can continue as an authorized person only with the will and wish of the Reserve Bank of India. If at any point of time Reserve Bank of India find that you are not good for the foreign exchange health of this nation, you are not good for foreign exchange matters, they'll terminate your registration after giving you a reasonable opportunity of being heard. Got my point? So registration is essential. After registration, you have to comply with all the circular notification rules, regulations and terms and conditions based on which registration has been given to you. Section 11 clearly states that Reserve Bank of India is having all authority to pass any directions to the authorized person. At any point of time, if Reserve Bank of India is passing any directional order to you, you are under a foundation that you have to comply with the requirement of the directions issued by the Reserve Bank of India. Now, section 12 is stating that Reserve Bank of India is having all the right to conduct supervision, inspection, inquiry and investigation over the affairs of the authorized person. At any point of time, Reserve Bank of India can send a team of officers who can conduct inspection over the affairs of the authorized person. They can check any documents, detail information that has been held by the authorized person, and if they find it like they're not working in the benefit of foreign exchange over here in India, their registration is subject matter of termination. But whether it is suspension, that is called temporary cancellation of the registration, or when it comes to termination, that is a permanent cancellation of your registration, in any situation, Reserve Bank of India is under an obligation to provide appropriate opportunity of hearing, reasonable opportunity of being heard to the concerned authorized person. Is it clear? And no cancellation of retrospective registration is possible. Cancellation can only be done with the prospective effect, whether it is suspension or it is cancellation. Got my point, students? Is it clear? That was authorized person. It will come in the later part of the chapter, but everything I have, being a marathon, I have covered everything in this stage itself. Got my point? Is it clear? Is it clear, students? Currency includes everything. It can be in the form of coins, it can be in the form of banknotes, right? Got my point? Now, when it comes to residence or resident of India, now residential status does matter for the foreign exchange management act. Nationality doesn't matter. Residential status means the concerned person to whom you are dealing with is a resident of India or he is a non-resident of India. So when it comes to a residential status, it is going to be applicable on individuals as well as artificial person as well, right? For an individual, they are clearly stating that if any person who has stayed more than 182 days, means minimum 183 days during the preceding financial year. So in which financial year we are standing as students? As of now, we are standing in 24-25, right? We are into 24-25, right? So 24-25, in order to calculate the residential status, we'll take base year as a 23-24. So any person, we are standing in 24-25, we'll see the residential status of 23-24, right? So if any person who have stayed for not less than 183 days during the preceding financial year, he would be treated as classified as a person resident in India, right? You have to stay minimum period of 183 days. You have to stay minimum period of 183 days in the preceding financial year. In the preceding financial year, then you will be classified as a person resident of India. But there are three exceptions over here in India. If some person who is not a resident of this nation but came over here in India, any person who is not a resident of this nation but who has came over here in India in the preceding financial year for employment purpose, for an assignment for business or vocation, for any assignment where he is going to stay over here in India for an uncertain period of time. If a person who is resident outside India is coming over here in India for an uncertain period for employment or for business or vocation, it doesn't matter whether he has stayed for 183 days or not, he will be classified as a person resident of India from the preceding financial year. Is it clear? So if a foreigner is coming over here in India for conducting business or operations, or if he has came over here in India for job, or if he has came over here in India for uncertain period of time, in spite of having the fact he could manage to stay over here in India in the preceding financial year for less than 183 days, he'll be treated as resident of India. And inversely, it is also applicable if a person who is resident of India left India for employment outside India, left India for business or vocation, left India for an uncertain period of time, even left India for education purpose, because generally those who are leaving India as per RBI notification for education purpose are getting settled outside India only. So it will be treated as if he is leaving India for the higher education, so he is going to settle outside India for an uncertain period of time. So even if he could manage to stay over here in India for more than 183 days, still for more than 182 days, still he will be treated as non-resident of India. Is it clear? So there are 3 and 3 6 exception for foreigners and exceptions for residents. Okay, is it clear? That is individual's residential status. Got my point? Got my point, students? Now for artificial person, there is a clear criteria. If a company has been registered inside India, it will always be a resident of India. If any office, branch or agency is located inside India but being controlled by outside India, it doesn't matter, as it stays over here in India, it has been established over here in India, it will be treated as resident of India. And any branch, subsidiary or agency of resident of India located outside India is going to be controlled by resident of India, so it will be treated as resident of India. So 3 companies will always be treated as, 3 artificial entity will always be treated as person resident of India. A company or entity which has been registered over here in India, irrespective of the fact whether they are having business over here in India or not, they would always be treated as resident of India. Second one is, if an entity is being located over here in India, but it is going to be controlled by person resident outside India, it doesn't matter, as it is located over here in India, it will always be treated as what? Person resident of India. The third thing is what? If an entity of person resident of India is located outside India, but controlled by person resident in India, would always be treated as what? Resident in India. Although when it comes to CS Executive Institute, hardly ask question from person resident of India, but I have covered person resident of India in the beginning itself, right? So we have done with FEMA ka objective, we have done with residential status, and we have done with authorized person, right? Right, students. And even we have done with foreign exchange and foreign security mein difference, right? That was the important point, right? Now starting further, so we have done with few topics. Now I am proceeding further with the most important topic. No, not Hawala transactions or and all is not very from the point of view of exam. So let's go ahead with current account transaction. So whenever we are talking about current account transaction, the term current account transaction has been defined in section 2 of FEMA. Whenever we are talking about current account transaction is nothing more than a transaction which is not a capital account transaction. Means a cross-border transaction which is not lead to create any asset or liability outside India, belonging to person resident of India, or any transaction which is not lead to create any asset or liability located over here in India and belonging to person resident outside India. Remember, in FEMA, all transactions are going to be a cross-border transaction. So a cross-border transaction which is creating asset or liability outside India or inside India, dependent on belonging to whom, right? So it will be a capital account transaction. So if it is not creating any asset or liability outside India belonging to person resident in India, or it is not creating any asset or liability located over here in India and belonging to person resident outside India, it will be a current account transaction. So if I'm going outside India for medical treatment, or they are coming inside India for medical treatment, it is not going to create any asset or liability, right? So it is a current account transaction. If they are coming out in India for education, or we are going outside India for education or trip or for business consultancy, it will not create any asset or liability outside or inside India. So definitely it will not be a capital account transaction, it will be a current account transaction. Normal business transaction like export and import will not create any asset or liability, long-term asset, long-term liability. So it will be a current account transaction, right? Immigration would also be treated as what? Current account transactions, right? So these all are the current account transactions. Now there is a list of prohibited current account transaction. Remember, even if you're importing or exporting machinery, machinery may be treated as a capital account, capital asset, but machine say related payment will not create any long-term asset or liability. So even import or export of technology will be treated as what? Current account transaction. Got my point, students? So almost all current account transactions are permissible, but there are certain current account transactions which are prohibited. Okay. So let's go ahead with the current account transaction which are prohibited. So first is, if you're traveling to Nepal and Bhutan, you are not been allowed to withdraw any kind of foreign exchange. You have to go ahead with Indian currency and get it exchanged over there. If you're dealing going outside India, that is Nepal and Bhutan, or if you're dealing with Nepal and Bhutan ke resident, you are not going to get any amount for current account transactions. Okay, if you have won any lottery inside India, being a person resident outside India, if you want to take that money outside India, you are not allowed to take foreign exchange outside India, because lottery winnings, any casual income generated out of racing and riding, or any kind of business income that has been generated out of lottery ticket business or band magazine business, you are not allowed to send casual business or business, a prohibited category of businesses kind income outside India. You are not going to get any kind of amount for the same. For a dividend balancing requirement, you cannot make payment. For export commission on equity investment, you cannot make cash outside India. For callback services, for NRI account interest, for export commission under rupee state credit route, I am giving you a quick explanation. Remember, 6 to 7 transaction for which withdrawal of foreign exchange is prohibited. What I am teaching you is schedule 1 transactions for which withdrawal of foreign exchange is prohibited. So if you are going outside India, that is Nepal and Bhutan, for traveling or for any other purpose, you cannot withdraw any foreign exchange. If you are dealing with the resident of Nepal and Bhutan, you are not allowed to withdraw any kind of foreign exchange. You cannot remit lottery winning outside India, right? You cannot remit lottery winning outside India. Withdrawal for lottery winning is not allowed. You cannot send any kind of casual income earned by a non-resident over here in India in foreign exchange outside India. Withdrawal is not allowed. It may be through racing, riding, or racing, riding, or gambling, or betting whatsoever. Now you cannot send any income that has been generated by sale of lottery ticket or band magazine over here in India. Such income cannot be sent outside India. You cannot make payment of callback services outside India. At this point, understanding callback services is not at all important. You are preparing for your exam. So remember, for callback services, you cannot withdraw even a single foreign currency over here in India, right? For dividend equalization requirement, you cannot get it done, right? For any commission payable on state rupee credit rule, if you have export something outside India, in which for which you are going to get the payment in Indian currency, so it is known as export under state rupee credit route. So for that, you can pay commission on tea and tobacco maximum up to 10%. For other commodities, you cannot pay any kind of commission for the same, because you are not going to generate any foreign exchange. You are going to get the payment in Indian currency. So remember these 6-7 points. These are more than sufficient. These are the list of prohibited current account transaction, and institute used to ask about the same so many times. Is it clear? Got my point, students? Now, there are certain transactions for which prior approval of certain ministries are required, but that is not at all important from the point of view of your exam. Now, there are certain transactions which does require approval of Reserve Bank of India, that is known as liberalized remittance scheme. This is very, very important, and this is being provided in Schedule 3 of current account transactions rules. Okay. So they are saying that if you are withdrawing, any individual who is the person resident of India can withdraw, whether he's any individual who is resident of India, whether he is minor or he is major, it doesn't matter. He can withdraw up to 2,50,000 US dollar. He can exchange up to 2,50,000 US dollar per financial year. That is the limit applicable on every individual who is resident of India. Okay. So if I'm going outside for medical treatment, or if I'm going outside for education, if I'm going for a family trip, I can withdraw, get exchange maximum up to 2,50,000 US dollar per individual per financial year, per individual per financial year. So if my family is consisting 3%, we are being the nuclear family, we can withdraw up to 7,50,000 US dollar for foreign trip, for investment in foreign countries, right? For certain capital and current account transaction, we can utilize it, and this is known as liberalized remittance scheme. Why it is known as liberalized remittance scheme? Because RBI has given you a liberty that you can withdraw this amount of cash, you can get it exchanged through authorized person without taking the approval of Reserve Bank of India. But the limit of 2,50,000 is not going to be applicable if you have balance in your RFC account. Now, what is RFC account? Resident Foreign Currency Account. If you have earned your own foreign exchange through exports by getting into job outside India, and you have came up with that foreign exchange, you can hold it in your RFC account, and that limit of 2,50,000 will not be applicable for spending through RFC account. Is it clear? So this is the standard limit. Okay, you can use it for private visit except Nepal and Bhutan. You can use it for gift and donation. You can go use it for employment abroad. You can use it for emigration. You can use it for maintenance of your relative, for business travel, for medical treatment, for education, and for other current account transaction. But remember, in case of emigration, in case of medical treatment, and in case of education, this limit is not going to be applicable. Limit will be 2,50,000 US dollar or actual expenses, whichever is higher. You can withdraw that much amount for emigration, education, and medical treatment. Got my point, students? Is it clear? This limit is only available for resident of India, not for the foreign resident. Even minor can get that amount, but with the declaration form to be signed by whom? The parent, right? There are certain capital account transactions. This is very important question. There are certain capital account transaction for which even LRS can be used. LRS amount can be used for open of foreign bank account. You can use it for acquiring immovable property outside India. You can use it for overseas direct investment and overseas portfolio investment. Although all current account transactions are permissible by using the liberalized remittance scheme amount, but for capital account, you can use it only for 4 transactions. For opening bank account, for making investment in property abroad, you can use it for OPI, overseas portfolio investment. You can use it for overseas direct investment. Got my point, students? Even you can give loan to your relative by using LRS fund. This is very important. What I'm teaching you is liberalized remittance scheme. Getting my point, students? Is it clear? Now we'll go ahead with liberalized remittance scheme for non-individual. We have done with liberalized remittance scheme for individuals, right? Now proceeding further for liberalized remittance scheme for non-individual, that is for companies or for body corporates, right? So when it comes to liberalized remittance scheme, we know that you can withdraw the funds from authorized person without taking the approval of Reserve Bank of India, right? This is being liberty provided to any individual who is being associated with withdrawing of funds from outside India, right? Got my point, students? Is it clear? So whenever we are talking about facilities for persons other than individuals, remember there are 4 limits, 4 or 5 limits being applicable. You have to learn all those limits. Okay. So if any non-individual is willing to make any kind of donations, if any individual being, if any person other than individual is willing to make any kind of education related donation, they are allowed to make donation outside India, and for that they can withdraw fund. Only they can withdraw fund if they are being involved in foreign exchange earning. If they are not being involved in foreign exchange earning, withdrawal is not allowed. Remember, maximum amount of withdrawal can be 1% of last 3 years average foreign exchange earning, or 50 lakh US dollar. What? 50 lakh US dollar, whichever is higher. That is 50 lakh US dollar is nothing more than 5 million US dollar, right? So if they have earned 5 million, they have earned whatever they have earned, 1% of the last 3 years total foreign exchange earning, or 5 million US dollar, whichever is lower, they can make donation of the same. But donation should be only educational donation. They should be involved in foreign exchange earning for minimum period of 3 years. They can make spending maximum up to 1% of total earning of last 3 years foreign exchange, or 5 million US dollar, whichever is lower, right? Now if a non individual is willing to give any kind of commission to the person who has sold out their flats over here in India, they can pay maximum up to 5% of inward remittance, or 25,000 US dollar, whichever is higher. Okay. If you have taken a services of a foreign broker who has arranged a foreign client for your flat located over here in India, then whatever inward remittance you have received, uska 5% or 25,000 US dollar, whichever is higher, can be paid as a commission. If you are taking any kind of consultancy services, if it is infrastructure consultancy services, you can pay 10 million US dollar per project, and if it is non-infrastructure project, you can pay 1 million US dollar per project. Is it clear? If you have incorporated a company outside India, so for pre-incorporation expenses, you can remit amount which is equivalent to 5% of the investment brought over here in India through the such company, or 100k US dollar, whichever is higher. Is it clear? So 5 limits are there. You can make educational donation. If you are involved in the foreign exchange earning, only 1% of the total foreign exchange earning of last 3 years, or 5 million US dollar, whichever is lower. You can make payment of commission to the agent who is located outside India, who have sold out certain immovable property located over here in India. Inward remittance ka 5% or 25,000 US dollar, whichever is higher. The third one is for foreign exchange, for consultancy, infrastructure consultancy, you can pay up to 10 million US dollar. For non-infrastructure consultancy, you can pay up to 1 million US dollar. And for pre-incorporation expenses, you can pay 5% of investment brought in, or 1k US dollar, whichever is lower, right? Whichever is higher. I'm sorry. Now, what is capital account transaction? I told you capital account transactions are nothing more than the transaction which is creating any kind of asset or liability located outside India belonging to person resident of India, and it includes creation of any asset or liability, or alteration of any asset or liability located in India but belonging to person resident of India, resident outside India, right? Right, students. For two capital account transaction, the Reserve Bank of India is not authorized to put any ceiling limit when it comes to capital account transaction. For two transactions, they cannot put any restriction. For repayment of loan outside India, that is, they are saying that amortization of loan, which is nothing more than repayment of loan, and depreciation or loss due to a loss in foreign direct investment. Okay, for two things, they cannot put any ceiling limit. For depreciation on the direct investment outside India, and the second one is for amortization of loan. Is it clear? Almost all transactions are allowed. This list, sometimes institute has asked, like, what kind of transactions you can do. You can make investment in foreign security, you can extend foreign currency loan, you can acquire immovable property as outside India, you can get into guarantee related transaction, you can buy insurance policy from abroad. Okay, you can get into derivative contracts. So all kinds of contracts are allowed. But there are certain prohibited capital account transaction. You have to learn this. This is very important. Okay, you cannot get into chit funds related transaction. You cannot get into, there are certain sectors where the capital account transactions are absolutely prohibited by Reserve Bank of India, investment in chit fund from by the foreigners, investment in Nidhi company by the foreigners. They cannot make investment in agriculture or plantation activities over here in India. They cannot make in certain real estate over here in India, which is being directly connected with farmhouses and all. They cannot make investment in trading in transferable development rights. What is transferable development right? That is not important. You have to learn at this point of time, right? Right. So there are certain transactions in which they cannot make investment, means capital account transaction is prohibited in Nidhi company, in chit funds, in real estate sector, in agriculture and plantation sector, and in transferable development right. Even you cannot accept investment from certain prohibited countries like North Korea and all. Lease up to 5 years are not going to be regulated by Reserve Bank of India. Up to 5 years lease will be classified as a current account transaction. Beyond 5 years lease will be counted as what? Capital account transactions. Getting my point, students? What we are doing, we are going ahead with the marathon of what? ECIPL, right? Now, what do you mean by repatriation of to India? If you are depositing the foreign exchange in a bank, foreign subsidiary of Indian bank, if you are repaying your loans or settling your debt outside India, okay, or if you're putting it in your bank account, surrendering the foreign exchange with the Indian bank, getting it deposited in your RFC account, or settling your debt outside India will be treated as what? Repatriation over here in India. It will be treated as you have sent your money back over here in India. Got my point, students? Is it clear? Now the next topic will be currency related provisions, and once we have done with currency related provision, a lot of part of the FEMA has been done. The most important part we have done is definitions. We have done with residential status, we have done with current account transactions, we have done with capital account transactions. Now we are going to start with what? Currency related provisions, right? Right, students? Now let's start with the next topic, that is currency related provision. Whenever we are talking about currency related provision, they are talking about realization, repatriation, and surrender. So whenever it comes to realization, FEMA clearly specifies that it is the duty as per section 8, it is the statutory duty of every person who is resident of India to get whatever foreign exchange due realized as soon as possible without unnecessary delay. If he is causing any kind of delay on realizing the foreign exchange, and there would be any loss of foreign exchange, in that case he would be answerable to the authority, because it is his statutory duty to get it realized as soon as possible. Now whatever foreign exchange he has realized, it is his duty to get it surrender. When it comes to surrender it to the authorized person. If he has realized it, if it is a non-individual person, and if you are being a non-individual person, have realized a certain foreign exchange due to certain foreign exchange due to export or some other kind of settlement of business payments, you have to get it surrendered within the period of 7 days from the date of receipt. In other cases, other than self-realization, if you have taken any kind of foreign exchange in any form like loan or something, you have to get it surrendered within the period of 90 days from the date of receipt of such foreign exchange. This timeline is only applicable on non-individual. They are saying that if it is self-earned foreign exchange, surrender it within the period of 7 days. If it is other than self-earned foreign exchange, surrender it within the period of 90 days, right? If being a non-individual, if you have withdrawn any foreign exchange for any specific purpose, say for import of technology or something, you have to, if you haven't utilized it, surrender it within the period of 60 days from the date of such withdrawal. If you have sent your directors or business delegates outside India, and you have withdraw certain foreign exchange for their foreign travel, once they came back over here in India, surrender it within the period of 90 days. And if it is in the form of traveler's check, surrender it within the period of 180 days. So self-earned 7 days, right? Self-earned 7 days, other than self-earned 90 days. Then if you have withdrawn it for a particular purpose but could not utilize, then within 60 days. If you have withdrawn it for foreign travel, then within 60 days from the returning to India, within 90 days from the returning to India, and if it is in the form of traveler's check, within 180 days. But when it comes to an individual would have, for all the purposes, whatever foreign exchange they have received, they have to get it surrendered to the authorized person within 180 days. For them, there is a flat timeline, that is 180 days. For non-individual, these timelines are being applicable, right? Now section 9, this is section 8. Section 9 is dealing with the possession of foreign currency, how much currency you can keep in your possession. If you are an authorized person, you can hold any amount of foreign exchange. There is no ceiling limit that how much foreign exchange you can hold upon. But when it comes to any person being an individual or artificial person, there is no such limit on coins. But when it comes to foreign currency, banknotes or traveler's check, maximum a resident individual can hold up to 2000 US dollar. Maximum up to 2000 US dollar. But no such limit is applicable on a person who is resident of India but not a permanent resident of India. If a person has came over here in India for an assignment where the term of assignment is up to 3 years, it will be treated as non-permanent resident of India, and non-permanent resident of India can hold any amount of foreign exchange with him. That 2000 US dollar ka limit is not applicable upon him. Is it clear? So we have done with so many topics of FEMA. Now we will proceed further tomorrow. Done, students? Let's start with a quick revision of FEMA. We have done with the basics of objective of FEMA. We are well equipped with that. After that, we have done with the distinguish between foreign exchange and foreign security. And I told you very clearly that when it comes to foreign exchange and foreign security, it is an important question. And it does cover, I have made my own written answer for the same question in order to give you a guide that how to write a proper answer when it comes to your exams, right? This yellow marking part is carrying the exam oriented answer written by me, right? After that, we have in detail done with section 10, 11, 12 of authorized person, right? We have done with residential status of an individual as well as a body corporate, right? Which is not that much important from the point of view of exam, because C Institute used to ask questions on residential status, CS Institute is not. Then I have skipped with section 3 and 4, which is nothing more than dealing with Hawala transactions on or. But we have done with current account transaction, that is section 5, in which we have done with prohibited current account transactions. We have done with permissible capital current account transactions. We have done with LRS for individual and LRS for corporates, right? That is schedule 3, which is very, very important, right? After that, we have done with capital account transactions, and capital account transaction is very, very important. List of permissible capital account transaction provided in schedule 1 part 1 and part 2 of the schedule, and what is capital account transaction has been done, right? And even we have done with section 8 and 9, which is related with surrender, repatriation and of foreign exchange, right students, and holding of foreign exchange as well, right? This has been done. Now proceeding further with the next topic, that is remittance of assets. Now what is remittance of assets? Suppose some foreigner came over here in India for education purpose, for business purpose. They have settled their branch office over here in India. They have settled their project office over here in India, but now they are just willing to liquidate their investment and willing to go abroad. So logically, if they are going abroad in their own country, they would ask their assets that is being held over here in the form of bank deposit, in the form of FD, in the form of assets, right? Fixed assets. It can be in the form of a provident fund, pension fund. So logically, what they want, they would want to have that liquidated over here in India, and money belonging to those all assets they want at their bank account in their local country, right? In their destination country, in their own country, right? So if you are liquidating the assets belonging to foreign national or belonging to person resident outside India, or belonging to any corporate body or body corporate which is going to close down over here in India, and after closing down, whatever asset is balanced with them, they'll get it, transferred there in their nation. So logically, it has to be done through the authorized person. Think logically, no transfer of cash and currency can be done without the involvement of the authorized person. And for the satisfaction of authorized person, you have to make sure certain things, that there is no dues belonging to Indian employees. Means you have to file a declaration that nothing is being left to be paid to the Indian creditors or the employees, right? So you need to have a no due certificate like that. Along with that, and that declaration is going to be signed by the auditor of the company. They'll check that all establishment related, all approval documents are on place. They'll check that there is no dues belonging to Indian creditors. They'll check that all Indian taxes and duties are duly paid, right? If they would be satisfied with these all norms based on auditor certificate, then only authorized person will allow you to transfer your cash overseas, right? And that is what is known as a remittance of assets. So I told you, liquidating bank deposit, PF, insurance policies, right? Liquidating bank deposit, PF, insurance policy, or sale proceeds of investment, transferring over there will be treated as what? Remittance of assets, right? So it can be done for a retirement person who has been retired from India and got settled outside India. It may be related with inheritance, right? It may be related with widow or widower's inheritance, right? In all these three cases, maximum amount of transfer that can be made per financial year can be 1 million US dollar, not more than that, right? But this is only for repatriation wala investment, non-repatriation wala investment. For repatriation basis, this limit is not applicable. Now, what is investment on repatriation and non-repatriation basis? If you are making investment on the equity, it will be treated as non-repatriation basis. If you are making investment in other than equity, it will be treated as non-repatriation basis further. So this is the first criteria for remittance of assets. Second criteria is, if you are a foreign student who came over here in India for education, you came up with certain balances, you got some scholarship and stipend from here in India. Now you are willing to get it transferred, because now after completing your education, you are going back to your nation, you can get it transferred and the same limit will be applicable, maximum 1 million US dollar per financial year. But do you think that and student will have that kind of fund? Answer would be no. So with normal banking channel, you can get it done, right? Right, students. A remittance by company, this is very, very important. And remittance of branch office, I told you, if the company is willing to liquidate its operation, it does require due compliance of Companies Act 2013. So auditor have to make sure that Companies Act 2013 has been duly complied with. They have discharged all the Indian liabilities, right? And all there is no legal proceeding going on over here in India. All the employees' dues, provident fund, pension fund has been released. If four certifications has been given by the auditor, the first one is no dues to Indian liabilities. No cases, legal cases going on over here in India. Third one is all employee dues are being clear. And fourth one is Companies Act has been duly complied with. Then only a company after winding up can take their money outside India. That is called remittance of assets by companies. Then remittance of assets by branch office does require everything, but along with that, it does require copy of approval letter of opening branch office over here in India over here in India by RBI when you have opened the branch office over here in India. Along with that, all the relevant provisions of Companies Act has to be satisfied, and we no dues to the liabilities, no dues to the employees. These all certifications has to be submitted, taken up by the auditor. Means you cannot transfer money without involvement, active involvement of your chartered accountant, right? If you're transferring the amount more than 1 million US dollar, it does require prior approval of RBI. Done. So we have done with remittance of assets. I have given you the crux of remittance of assets, and generally they are asking for remittance of assets by corporates. Okay, got my point, students? So two questions are too much important over here. That is remittance by company and then remittance of by the branch office. Got my point, students? Authorized person I have taught you in the beginning itself, right? Right, students, section 10, 11, 12. I have taught you very properly, right? Now, exports are not that much important. Generally, you are being provided with, if you can remember, section 8 clearly states that export dues should be recovered as soon as possible without unnecessary delay. If there would be a delay and loss of recovery of exports, you would be answerable to the Reserve Bank of India, that is authorized person, right? According to the FEMA, when it comes to export related procedures, it is going to be regulated by Director General of Foreign Trade under import export policy, that is foreign trade policy of this nation. But whenever you are exporting from outside India, it is going to be a current account transaction to be regulated by section 5, and recovery has to be done according to the requirement of section 8. But what you'll have to do, you have to show what value of export you have created, what value of exports you have done from India, so that they can check out the expectation that how much recovery of foreign exchange is going to be held in this year, because it is all about foreign exchange management, right? So they need to know the estimated recovery. So you have to in declaration tell them the full actual value of the export. If it cannot be full value or full export value, you have to declare the expected value, right? Got my point, students? Is it clear? So only value of export does matter for declaration. Realization period is, I guess, 10 days. Maximum 7-month credit you can get into through, exports. When it comes to project export, when you are exporting not just the goods, you are exporting the entire services and goods ka combination, that is known as what? Project exports, right? Done. So export is not that much important, but still I have covered the basic. What you have to declare is actual value of the exports to the authority, or if you are not well aware about the actual value of the export, you have to focus on expected value of export. And in case of even project exports, you have to tell them what is going to be the full amount of recovery, right? Got my point? And this is the last topic, that is adjudication and appeal, and this thing, compounding of offenses, then FEMA would be over. Okay. So when it comes to FEMA, there is a special authority that has been established to take care of the enforcement of FEMA, that is called Directorate of Enforcement. And the second one would be the adjudicating authority, which is nothing more than the court of FEMA. So I would say that there are two authorities established under the FEMA, that is admin authority, that is called Directorate of Enforcement. We can say that it is going to be the police of FEMA. Okay, and the second one is the adjudicating authority, that is nothing more than the court of FEMA. Got my point, students? So if you have committed any contravention pertaining to the FEMA, who is going to investigate your matter is going to be the Directorate of Enforcement, and based on the investigation report of Directorate of Enforcement, the court, FEMA court, is going to adjudge your case. Got my point? So as being the central laws, as per section 16, the adjudicating authority is going to be constituted by the central government, right? The adjudicating authority ka jurisdiction is going to be determined by the central government. They will conduct inquiry, investigation and inspection pertaining to what? Inquiry and judicial proceeding pertaining to FEMA related contravention. Investigation would be done by Directorate of Enforcement, right? They can even demand for bond and guarantee if the person, if there is a risk that the person who has contravened the provision of FEMA can abscond the country or evade the payment. Got my point? That is adjudicating authority. If you are unhappy with the order of adjudicating authority, within 45 days you can file an appeal with the special director. If you are unhappy with the special director, you can prefer an appeal to the appellate tribunal within the period of 60 days. Got my point, students? Is it clear? So within the period of 45 days, sorry. So first case, the lowest possible authority under FEMA, adjudicating authority, is the adjudicating officer, who is going to be appointed by the central government. If the Directorate of Enforcement got someone contravening the provision of FEMA Act, rules, regulations, circulars, direction, etc., they will investigate the matter. Investigation report is going to be first submitted with the adjudicating officer. Just a minute. I have rotated only, no. I think there is some resolution problem. Yeah, now it's okay. Thank you. So the first authority would be the adjudicating officer. If you are unhappy with the adjudicating officer, you guys can go ahead with the go ahead with the appeal to the special director's appeal within the period of 45 days. And if you're not happy with the special director's appeal, you may prefer an appeal to the appellate tribunal, and the appellate tribunal के पास भी appeal you guys can file within the period of 45 days, and appellate tribunal would under an obligation to resolve the matter within the period of 180 days. And if you are unhappy with the order of appellate tribunal, you can prefer an appeal to the high court within the period of 60 days. And this 60 days, 45 days, all are condonable if you are having sufficient cause behind your delay. And a very important thing to remember, students, if the appeal is pertaining to question of fact, that is question of evidences, it would be resolved by the appellate tribunal itself, because high court is going to only entertain the cases of question of law. They would not going to entertain the cases related with facts. Got my point? So with high court, you can only file an appeal pertaining to what? You can file only an appeal pertaining to question of law, not question of facts. Got my point? Is it clear? Now, what is Directorate of Enforcement? I told you Directorate of Enforcement is nothing more than the FEMA police. It is going to be appointed by the central government. When it comes to investigation matters related with FEMA, when you have contravened any provision of FEMA, who is going to investigate the matter is the Directorate of Enforcement, and they are the person who is going to prefer an application or judicial proceeding initiation will be done by the Directorate of Enforcement. I told you very clearly, right? Now, what would be the penalty pertaining to FEMA? If you have committed any offenses where the amount of contravention can be computed, then penalty would be 3 times of the amount involved. Otherwise, it will be 2 lakh. And in case of continuing offense, it will be 5,000 per day. Okay. Whatever currency you'll caught with, it is going to be confiscated. A criminal action can be taken against you, and the imprisonment for contravention of FEMA can be up to 5 years. The court will take cognizance of the cases only if the complaint has been filed by the Directorate of Enforcement. No cognizance of any complaint will be taken until and unless the due complaint has been filed by the Assistant Director, who is nothing more than Directorate of Enforcement. So repeating, when it comes to FEMA related penalty, quantifiable penalty will be 3 times of the quantified amount. Non-quantifiable penalty would be 2 lakh rupees. Along with that, your property or currency acquired wrongfully can be detained, and then a criminal complaint can also be registered, in which you will have to face an imprisonment up to 5 years. And offenses are going to be taken care by the court only if the complaint has been filed by the Directorate of Enforcement. Right, students. In case of company, case will be filed against officer in default. Now teaching you compounding of offenses, which is very, very important, and it is very simple. See, students, what is compounding of offenses? Suppose if you have contravened any provision of FEMA, rules, regulations, directions, circular, notification, it will lead to contravention of FEMA, and you will have to bear the monetary penalty, that is nothing more than less than 2 lakh rupees or actual amount ka 3 times, along with that your currency is going to be seized, right? Along with that, you may have to bear the imprisonment of 5 years. But if you have committed something where there is no criminal offense has been committed, means you are not a subject matter of imprisonment. If you are not a subject matter of imprisonment, if you have not committed something that is called criminal offense with mens rea or guilty intention, you can demand the Directorate of Enforcement or RBI officers for compounding. Compounding is nothing more than settlement of offenses, where you are confronting the authorities and you are telling them that you have convicted, you have committed contravention of the FEMA provisions, and it was not an intentional act, it was not a deliberate act, it was an accidental act, and you are accepting your contravention and you are willing to get it rectified, you just wanted to get it settled, you're not willing to pay huge penalty, you're willing to pay just the nominal compounding charges because it was very first time you have done it and it was done unintentionally. If all with your presentation the authority will be satisfied, they will compound the offense, and once the offense will be compounded, you will have to pay just the compounding charges, and once the compounding charges has been paid, it will be treated as your offense has been settled down. Now again this file would not be opened, the prosecution cannot be started. But remember, for similar nature of offenses, minimum gap of 3 years are required for compounding application. Means if similar nature of offense, say currency related offense, say remittance of asset related offense, is being committed by me in the preceding in the preceding 3 years, then it requires minimum gap of 3 years between compounding of two similar offenses. Got my point, students? Is it clear? So this is what compounding of offenses. RBI officers and a Directorate of Enforcement is having authority for compounding. Compounding can only be done for the monetary penalty related offense. Criminal offenses cannot be compounded. If you have made an application for compounding, you have to pay the nominal compounding charges and it will be sorted out. It is totally dependent upon the Directorate of Enforcement whether to accept application for compounding or not, right? Fifth one is, once the compounding and settlement is done, your file is not going to be open, and there should be a minimum gap of 3 years between two compounding of similar offense. Done. So this is what compounding, and this is what, when it comes to compounding, no students, compounding is all about, compounding is the provision of compounding is similar, same to same in all the laws. Got my point, students? Is it clear? So we have done with what? We have done with compounding of offenses, right? So we have done with almost FEMA. Only acquisition of immovable property is pending, that even I'm going to cover up today. And with that, we have done with FEMA, right? Taking a 2 minutes pause, then I'll continue with the same. One of the more topic that has been covered in your syllabus is about Reserve Bank of India. So whenever we are talking about Reserve Bank of India, we know certain functions that has been performed by Reserve Bank of India. When it comes to Reserve Bank of India, I can say that Reserve Bank of India is regulating all the banks working over here in India, right? So it is a regulator of the bank. When it comes to regulating the monetary policy of this nation, that is to control inflation and deflation, it is going to be taken care by Reserve Bank of India, right? By increasing the interest rate or decreasing the interest rate, they are controlling inflation and deflation over here in India, right? Along with that, when it comes to printing of the currency, it totally depends on Reserve Bank of India. They are maintaining the adequate amount of currency whenever it comes to India, right? Along with that, all the payment and settlement systems are going to be regulated by Reserve Bank of India, right? Like whether it is UPI, NEFT, RTGS, all. And along with that, I would say that even foreign exchange and authorized persons are going to be regulated by Reserve Bank of India, right? For my point, students, organization structure doesn't matter. Monetary authority, regulator of financial system, manager of foreign exchange, issuer of currency, playing developmental role, right? Managing or supervising payment and settlement system. These all are the functions that has been performed by Reserve Bank of India, right? Got my point, students? Now starting with the last topic, that is acquisition of transfer of immovable property. So logically we can say that if a person who is non-resident of India is acquiring, if a person who is a non-resident of India is acquiring immovable property over here in India, or taking a lease of immovable property where the term of the lease is more than 5 years, they are getting into a capital account transaction. It is going to be regulated by Section 6 of FEMA, right? If a person who is resident of India is willing to acquire property outside India, he can acquire it. But if he is acquiring property outside India, it will lead to alter or create asset outside India. So definitely even it would attract a capital account transaction regulated by Section 6, right? So, and we know that if even a person who is a resident of India can use LRS money, that is up to 2,50,000 US dollar withdrawal for acquiring immovable property outside India. It was under permissible capital account transaction through LRS, right? We know that, right? So, a person resident of India can hold, own, transfer, or invest in immovable property in India. Person resident outside India. Now they are saying that if a person who is resident outside India is willing to hold, acquire, or transfer any property that he has acquired when he was a resident of India, or he got it in inheritance, there is no problem. There is no RBI involvement on two properties. If NRI is planning to continue with holding the property that he has acquired when he was a resident of India, or he got it on inheritance, there would be no limitation applicable. Now there are three persons involved. First one is NRI, non-resident of India. The person who is citizen of India but who is not the resident of India. OCI is overseas citizen of India as per citizenship law. Now OCI, overseas citizen of India, and NRI can purchase any movable property, but they cannot purchase agriculture land, plantation land, and farmhouse over here in India. Got my point? What they cannot acquire? Agriculture land, plantation land, and farmhouse over here in India. Even they can acquire immovable property in gift, but other than agriculture land, plantation land, and farmhouse. Got my point, students? All the payment should be made through the banking channel, means cash should coming from there. Now, if they want to go ahead with the joint acquisition of property, they can acquire, but joint acquisition is allowed when their marriage should be survive for minimum period of 2 years. Means they have into a registered marriage agreement and their marriage is at least 2 years old. Okay. So then they can acquire joint property. Got my point, students? So what they are saying that an NRI or OCI is allowed to acquire the property, but they cannot accept gift when the property is of agriculture nature, agriculture land, plantation land, or farmhouse. And if they want to acquire property, all the funds should come through normal banking channel, right? Traveler's check payments are not allowed, and if they are willing to acquire property with the joint name of their spouse, their marriage should be survival for minimum period of 2 years, right? Now, if a long-term visa holder is willing to acquire property over here in India, it is allowed. They can acquire two properties. One is residential and one is commercial. But whenever they want to sell out that property, it does require approval of certain authorities. Got my point? So long-term visa holder can acquire two properties, one residential, second commercial. They have to disclose from where they got the fund. Third, whenever they want to transfer, they can transfer it by taking the approval of the authority. Foreign embassies and diplomats can acquire property, but if they are willing to acquire property, all the money should come from normal banking channel. They have to require report of acquisition of property with RBI within 90 days. Okay. So the acquisition of property by NRI can be classified into three parts. The first one is NRI and OCI. They can acquire any property. They can accept gift of any property, but the property should not be farmhouse, plantation land, and agriculture land. All the money should come through banking channel. Traveler's check would not work, and if they are willing to acquire the property with the joint name of the spouse, the marriage should be minimum 2 years old, right? Long-term visa holder can acquire property in one residential, one commercial. Source should be clear, and whenever they want to transfer, they have to disclose, they have to take approval. And here the long-term visa holder may be Afghanistani, Bangladeshi, Pakistani, right, belonging to minority community, that is Hindu, Sikh, Jain, Buddhist, etc., who is staying in a detention center or a specified locality over here in India, notified by government. Next, foreign embassies and diplomats can acquire property and except restricted property. All funding should come from there, and 90 days के अंदर you have to report it to Reserve Bank of India that you have acquired the property. Got my point? That is section 6, acquisition of immovable property by non-resident of India, divided into three parts. If you guys can remember, three parts are there: by NRI and OCI. Second one is long-term visa holder, and then last one is embassies, right? Got my point, students? Manageable. Now we have to shift to the another part, that is now we are going to acquire the property, right? When resident individual is willing to acquire property outside India, you can acquire. I told you, even you can use what beta, your LRS funds, right? You can accept if you are getting in on inheritance, if you are purchasing by using your RFC fund, right? For business purpose you can acquire. So when it comes to acquisition of property by resident individual, it is not going to be primarily regulated by Reserve Bank of India. We would not ask them, a resident individual, not to acquire property outside India. We can acquire, right? But with subject to certain limitations like LRS limitations and all, right? But inheritance and gift is not going to be regulated. It is primarily being regulated by whom beta? The authority located in their country, right? Like we are controlling their holding, they are controlling our holding, right? Manageable, students. Done. So we have done with what? FEMA. We have done with one chapter, that is first chapter FEMA. All the questions has been done. Past year questions, I don't find it like very relevant to cover, but although I would cover certain past year questions which I would find like is required to be covered. Done. Now I am going to cover FDI, foreign direct investment. That is the second chapter. Okay, second chapter is foreign direct investment, and we are going to cover certain important aspect of foreign direct investment. See students, it is huge when it comes to foreign direct investment. It is huge, but the weightage from the point of view of exam is quite very low. So we are going to cover foreign direct investment, but logically we are going to cover it from the point of view of exam. Done. Starting with chapter number 2, that is foreign direct investment. First, try and understand the meaning of foreign direct investment. Whenever we are talking about foreign direct investment, it is nothing more than an investment that has been made by a person resident outside India or an entity resident outside India, and they are making investment over here in Indian business entities. So whenever we are talking about foreign direct investment, it is a business investment. It is not a personal investment. It is an investment that has been made by a person resident outside India or entity located outside India into an Indian business. And remember, whenever we are talking about foreign direct investment, it is a long-term oriented investment, means they are making an investment in order to seek the control over Indian entity. They are willing to seek control over an Indian entity. They are willing to create a lasting interest in an Indian entity. It is not a portfolio investment where the investment is made in order to make short-term profits, in order to make tactical profits, in order to make profits by sale of shares, debentures, bonds, and security. It is being made with an intention to create a lasting interest over here in Indian entity. Got my point? So they are classifying it in such a manner that if a foreign person, including entity and individual, is making investment in Indian unlisted entity, if they are making investment in an Indian unlisted entity, it will be classified as a foreign direct investment. If they are making investment in an Indian unlisted entity, means whatever amount of investment they are making, it will be treated as it is for creating a lasting interest. But if they are making investment in Indian listed entity, they must make minimum 10% of investment. If they are acquiring 10% of the post issue paid up share capital on fully diluted basis, it will be treated as foreign direct investment. So for unlisted entity, any amount of investment, right? For unlisted entity, any amount of investment, right? And for listed entity, minimum how much investment? Minimum 10% of post issue paid up share capital, right? Post issue paid up share capital on fully diluted basis. So what is fully diluted basis, students? It's just if all the convertible instrument in the balance sheet of the company would be converted into equity, what would be the total equity share capital? So if suppose company is having 1 lakh equity shares, 50,000 convertible debt, 10,000 convertible preference shares. So equity share on fully diluted basis would be 1,60,000 shares. Got my point? Is it clear? So any investment in unlisted entity will be an FDI. Investment in a listed entity where the value of the investment is not less than 10% or more on a post-issue paid up share capital on fully diluted basis, it will be a foreign direct investment, right? Now you can raise that foreign direct investment in such a manner that they would come over here in India with their fund and they'll buy equity share or convertible instrument of Indian entity. That is called Indian investment, right? They're making investment by coming over here in India. Or even if the Indian company is going abroad, like Infosys, like Wipro, and they are issuing their ADR, GDR, or FCCB or FCCB, FCEB in overseas territory, if they are issuing their depository receipt or convertible notes outside India, even that will be counted as what? Foreign direct investment. Got my point, students? So again, repeating, foreign direct investment is nothing more than acquisition of controlling interest by a foreign entity over here in Indian entity. Indian entity may be firm, company, doesn't matter, but they are willing to acquire the controlling interest in an Indian entity. I'm sorry. And if the Indian entity is unlisted entity, any amount of investment will be classified as a foreign direct investment. If it is a listed entity, minimum 10% investment on for 10% on post-issue paid up equity capital on fully diluted basis will be counted as foreign direct investment. Investment can be raised by making investment. They can come over here in India and can make investment over equity or convertible debt, or we can go in their territory and can issue ADR, GDR outside India. And when it comes to FDI, this is the growth indicator. If you want to check whether a country is growing or not, first check their GDP, then check their FDI. If we are attracting foreigners to make investment over here in India, then we can say that we are growing as a country because we are becoming attractive for the foreigners to make investment in our territory. Got my point? Now, what is governing authority? DPIIT is coming out with the policy and regulating the FDI norms over here in India. Got my point, students? Is it clear? Is it clear? This is the first and a very important question. What is FDI? It is going to be regulated by FEMA and FEMA related rules and regulation because it will lead to inflow and outflow of cash, right? Cross-border transaction, right? You guys need not to cover all this. There is no need at all. Now, this is very important question where FDI is prohibited. So FDI is prohibited in lottery business. Means if any Indian business entity is being involved in lottery business, they cannot accept FDI. If they are involved in gambling and betting business, they cannot accept FDI. Chit fund, Nidhi company, we have done it in FEMA, right? Cannot accept FDI. Real estate businesses or construction of farmhouses cannot, right? Any entity which has been involved in manufacturing of cigarette, etc. cannot accept FDI. And company dealing with transferable development right cannot accept FDI. So these are there in FEMA. If you can remember, this is something new, cigarette manufacturing company. And second, sector which is not open for private investment, like still in atomic sector, government is owning everything, right? Even in railway operations, it is being owned by government. So railway industry, that is IRCTC, and atomic energy associated enterprise cannot accept foreign direct investment. So it is new. So lottery business, gambling, betting, atomic energy, railway sector, real estate sector with certain exceptions, trading in transferable development right, Nidhi company and chit funds, they cannot accept foreign direct investment This is very important question. Now, what kind of instrument you guys can issue? Um, what kind of foreign direct investment you can accept? You can issue equity shares to them. You can issue convertible instrument to them. You can issue depository receipt to them. You can issue warrants to them, which is going to be convertible. Got my point? Partially convertible debentures will also be treated as equity. Two-way fungibility scheme and a sponsored ADR GDR is very important for CMSL, not over here, but still I am telling you, two-way fungibility scheme is nothing more than if an Indian company has come out with the issue of ADR and they are also issued their equity shares over here in India to public. Will it be possible that their equity shares can be convertible into their ADR and their ADR would be convertible into equity share? Means suppose there is a resident of US, John, who bought 100 ADRs of Wipro and he just wanted to get it converted over. Example, I'm giving you just an example. Now he's been settled over here in India and he's willing to get it convertible into Indian equity share. So will it be possible? So convertibility of ADR into Indian shares or Indian shares into ADR is known as two-way fungibility scheme, and that is known as what? Two-way convertibility scheme. Limited two-way convertibility or fungibility is being permissible. That is up to I think 25% of total value of the issue of ADR and GDR. But it's not that much important for this subject particularly. It is very much important for CMSL. Now, sponsored ADR and GDR. Sponsored ADR and GDR is nothing more than company can come out with a fresh issue of ADR and GDR in order to raise. That is called capital raising transaction. Company is issuing ADR, GDR, raising funds and going to invest it into business. And company can offer exit opportunity to their existing shareholder, where the existing shareholder will convert their equity into ADR and GDR and issue in overseas territory. Then whatever fund would be raised, company after deducting all issue related expenses will give it back to the existing shareholders, the selling shareholders. So it is known as sponsored issue. So sponsored issue is nothing more than offer for sale. Okay, when the promoters are deloading their holding by issuing ADR and GDR, by getting it convertible into ADR, GDR and issuing it to the foreign people. Got my point, students? Is it clear? Is it clear? This is something little technical, so I'm not going ahead with that. I'll cover certain interesting topic in this lecture, so that an important topic too, so that you guys will be capable enough to write the answers. Now there are two routes of foreign direct investment. One is automatic route and then another is government route. Whenever we are talking about automatic route, you can accept investment in the form of foreign direct investment without taking the approval of any authority. So that is known as automatic route. If before accepting an investment from overseas, you have to take the approval of FIPB, that is called Foreign Investment Promotion Board working under RBI, it is known as approval route. Remember, if you belongs to 100% sectoral cap, now every sector is having the maximum permissible limit till what they can accept foreign direct investment. Like if insurance sector is having 24% sectoral cap, means they can accept maximum 24% of their total paid up share capital in the form of foreign direct investment. Remaining 76% they have to raise from Indian investors. Okay, so only the sectors in which 100% free FDI is permissible, means if 100% of the total investment can be accepted by the Indian entities in the form of foreign direct investment, they can seek for automatic route, otherwise they have to go ahead with approval route. Got my point? Process will be faster in automatic route, it will be slower in approval route. RBI is involved, FIPB is involved, right? I told you 100% fee sector will be eligible for automatic route, other sectors will be covered under governmental route. Even if you are accepting investment from Pakistani, Bangladeshi, even it does require approval route to be followed. Got my point? You cannot accept investment without approval. In case of governmental route, you can accept it, right? If now approval route is not just required when it comes to less than 100% fee free sectoral cap. If a exclusive company is being established over here in India, registered over here in India with full investment by a foreigner, then even it does require what? It does require what? Approval route. Okay. If an Indian company has been established over here in India with the full and substantial control of NRI, if an Indian company is transferring substantial ownership or control to a foreign entity, even it does require approval of RBI, approval of FIPB. Got my point, students? Is it clear? This is very important question. Now, one more topic, downstream investment I have to cover, but along with that, I have to cover just a minute, okay? Startups. This topic I'm going to cover in today's lecture, and then only two topics of foreign direct investment will be pending, right? Issue and transfer of shares and reporting requirement, right? And downstream investments, right? Downstream investment, reporting requirement, and downstream investment, and transfer related provisions, right? So today I'm going to cover one more relevant topic, and that would be done. Okay. Now, starting with foreign direct investment related certain aspects I have to cover. Just a minute, students. Okay. So, can a partnership or a proprietorship firm can accept foreign direct investment? First, remember that when it comes to foreign direct investment, they are allowed to make accept investment. If they are willing to make investment in our proprietorship firm and partnership firm, we would stop them not to make investment over here, right? Now they are saying that NRI can invest in capital of a firm or a proprietorship concern on non-repatriation basis. Remember, beta, there are few things that is very common when it comes to foreign direct investment. One is sectoral cap, that every sector is being provided with the maximum cap limit up till what they can accept foreign direct investment. Is it clear? That is called sectoral cap. Non-repatriation basis means you cannot sell out your investments. You cannot sell out your investment and take your money back, because if you are making controlling stake over here in India, you can sell it out in secondary market, but you cannot demand fund back from your company where you have made the equity investment. So it is generally on non-repatriation basis. All the foreign direct investment would be on non-repatriation basis, whereas foreign portfolio investment would be on repatriation basis. Fund should come from a normal banking channel. This is the third common point. You cannot come up with the cash in order to make investment over here in Indian entity. The entity should not belong to agriculture sector, plantation sector, real estate business, print media sector, and those prohibited sector. That is the fourth point. Okay. With the approval of RBI, you can make investment through repatriation basis. So 4 or 5 points would be the common point. First point is, remember, I'll make the list of those points. Okay. Remember, in all entities, you guys can write it. Investment can be made by using two routes, approval route or automatic route, as the case may be applicable, right? Payment should be come through banking channel, FCNR account or NRI account, and etc. Right? Third, you have to remember the sectoral cap, right? Sectoral cap need not to be breached. Remember, you should not belong to a prohibited sector, right? Means the entity should not belong to prohibited sector. Investment should be made on non-repatriation basis, right? but repatriation is possible with the approval of RBI. Got my point, students? So these all are the common points that you have to cover. Remember, whenever it comes to accepting foreign direct investment, you can accept foreign direct investment through approval or automatic route. Remember, all the payment pertaining to foreign direct investment should be received through through banking channel, not through hard cash. You have to remember that you should not reach the sectoral cap without taking the approval of relevant authority. You should remember that there are certain prohibited sector where FDI is not permissible, so your entity should not belong to that sector. And the last one is all investment should be on non-repatriation basis. It should not be through repatriation basis. And sixth one is you have to license through authorized person. You need to open a designated bank account with the authorized bank who is going to license on your behalf. So same is going to be applicable for company, same is going to be applicable for proprietorship firm. Okay, got my point, students? Is it clear? Can a trust accept foreign direct investment? Yes, if it is a venture capital trust. Other trusts are not allowed to accept what foreign direct investment. Can a limited liability partnership firm accept foreign direct investment? Yes, they can accept foreign direct investment, and they can if they belongs to 100% free sector, they can accept it through automatic route, otherwise through approval route, right? They can accept even downstream investments. Okay, and in for LLP even you guys can write those 5 points. Remember, investment vehicle can also accept funds through this. In case of startup, there is a clear requirement. They can only issue convertible notes. They cannot issue non-convertible notes or direct equity. They cannot accept funds from Pakistan and Bangladesh. Even any entity accepting investment from Pakistan and Bangladesh requires approval route to follow. Minimum value of the convertible note should be 25 lakh rupees or a multiple thereof. Okay, that is the specific rule applicable on startup. Banking channel, common point. Non-repatriation basis, common point. Governmental approval will be applicable if startups belong to that. So only three specific things are there when it comes to startups. Startups are not permissible to accept issue direct equity. They have to issue convertible note. Value of the convertible note, each investor should not be less than 25 lakh rupees. It should be in the multiple of 25 lakh rupees. And next one is remaining all the things are same, right? Done, students. So we have done with foreign direct investment. Now what all topics are pending? I am putting star. Remember this. Downstream investment is pending, right? After downstream investment, just a minute, it's stuck. Just a minute. Downstream investment is one topic that is pending. I think reporting is the another. Eligible investors is the second topic, right? Transfer of share is third topic, right? Reporting requirement is the fourth topic, right? And portfolio investment. So portfolio investment is pending, right? Portfolio is pending. Downstream investment is pending. Reporting requirement is pending, right, students? Then after reporting requirement, what is pending, students? Reporting requirement के बाद what is pending? Transfer of share is pending, right? Transfer of share is pending, and one more thing is being pending, right? Along with transfer of shares, eligible investors are pending, right? Eligible investors are pending, right? So we have done with eligible investee entities, right, in which the investment can be accepted. We know that they can make investment in Indian companies, they can make investment in Indian firms, they can make investment in LLP, they can make investment in investment vehicle, they can make investment in startups, right, students. So these are the eligible investee entities and eligible investors are pending, right? So only 5 points are pending. Remember, students. Portfolio investment, downstream investment, reporting requirement, transfer, and eligible entities. And after that, we have done with what? We have done with the foreign direct investment. So tomorrow we'll finish with foreign direct investment and we'll go ahead with overseas direct investment too. Done. We know what is foreign direct investment. It is nothing more than an equity investment that has been made by a foreign person to an Indian business entity. If a foreign person is making investment in Indian unlisted entity, it will always be classified as a foreign direct investment. But if they are making investment in Indian listed company, minimum investment size should be 10% of the 10% of the post issue paid up share capital on fully diluted basis, right? Means if you'll take all together all the entire equity and all convertible instrument, minimum 10% of the same will constitute what? Foreign direct investment, right? You can issue, if you are accepting equity capital or convertible instrument you are issuing, it will be classified as what? FDA. Non-convertible instrument will be classified as an ECB, right? You have to comply with the requirement of FEMA because it is going to be a capital account transaction. You cannot accept FDI if you are into a lottery business, gambling business, chit fund, nidhi company, trading in transferable development, right? Certain real estate entity cannot accept FDI. This is something new. Cigarette manufacturing entities and entities in which private investments are not allowed, they cannot accept ECB, right? They cannot accept FDI. I'm sorry. You can issue equity, non-convertible instrument, convertible instrument. Two-way fungibility and sponsored issue is very important from the point of view of CMSL, right? You can accept foreign portfolio investment. Foreign portfolio investment is nothing more than an investment which is made on repatriation basis. When it comes to foreign portfolio investment, it is totally different from foreign direct investment. Both are equity investment, or when it comes to FDI, it should only be in the form of equity instruments, or it must be in the form of convertible debt instrument. But when it comes to foreign portfolio investment, it can be in the form of equity instruments, or it can be in the form of non-equity instrument, non-convertible instruments too, right? When it comes to foreign portfolio investment, the investment should be, in case of a listed entity, should be less than 10%. When it comes to foreign direct investment, it should be minimum 10%, right? If an FPI, you are making an FPI, foreign portfolio investment, maximum 24% investment you can make. An individual can make a foreign portfolio investment, an individual entity can make foreign portfolio investment maximum up to 5%, or altogether in individual entity. An individual entity, they can accept maximum 5%, and collectively they can make investment up to 10%. Maximum 5% of the paid up equity capital, debentures and preference share, and maximum 10% of what? In any entity, the NRI and OCI cannot make more than 10% as a foreign portfolio investor. That must is more than sufficient to understand foreign portfolio investment. Just try to figure out difference between, I have told you although, of foreign portfolio investment versus foreign direct investment. All the cash and currency should come through what beta banking channel, we know that. And when it comes to reporting requirement, that is something FCGPR form you have to file if you are accepting what foreign direct investment. You have to file on every 15th July every year. You have to file the list of foreign asset and liability statement. If you are involved in transfer of security, you have to file within 60 days FCTRS form. If you have issued ESOP, you have to file ESOP form within 30 days. If you have issued depository receipt, you have to file within 30 days depository receipt form. If you have accepted foreign direct investment as an LLP, within 30 days you have to file LLP1 form, and if you are withdrawing that a foreign direct investment from LLP, you have to file disinvestment form within the period of 60 days, that is LLP2 form. LLP1 is for accepting FDI, LLP2 is for disinvestment of FDI. In V form and other forms has to be filed within the period of 30 days. So repeating, when it comes to reporting requirement, whenever it comes to accepting an FDI, all the reporting should be filed through ED category 1 bank with the RBI. You cannot directly coordinate, or liaison with RBI. First of all, you have to file FCGPR form within the period of 30 days from the date of acceptance of proceeds of FDI. Within 30 days, right? Second, you have to every year file 15 July ko, that is asset foreign liability and asset statement. You have to file FCTRS form within the period of 60 days if you are being involved in transfer of FDI instruments. There is a transfer of FDI. Then if you have issued ESOP depository receipt, you have to file ESOP form or DRR form within 30 days from the date of transaction. If you are an LLP, you have accepted FDI, file within the period of 30 days LLP1 form. If you are the LLP and you are disinvesting the FDI, file within the period of 60 days the LLP2 form. That's it. That is more than enough. What is downstream investment, beta? If you are accepting investment not directly from a foreigner, foreigners are making investment in mutual funds, or they are making investment in venture capital funds, or they are making investment in alternate investment fund, and you are getting funds from Indian alternate investment funds or Indian venture capital fund, that is called downstream investment. That is indirect investment is known as downstream investment. Foreign direct investment means foreign entities directly acquiring, controlling stake in an Indian entity, that is called foreign direct investment. Foreign portfolio investment means foreign entities making investment in Indian entity not in order to acquire the controlling interest, just in order to make profits or portfolio transactions. And the third one is foreign indirect investment, when they are not directly making investment in Indian company, they are making investment in venture capital fund, Indian venture capital fund, Indian alternative investment funds, and they are making investment in Indian entities. Got my point, students? So investment through investment vehicle is known as what? Downstream investment. You have to report downstream investment within 30 days, and form number DI or some other forms need to be filed. Okay. Even startups can accept foreign direct investment. They need to report within the period of 30 days CN form, that is called convertible note form. If the foreigner has made investment in your company, you can offer them bonus issue and right issue, but subject matter of sectoral cap. Merger, amalgamation and demerger per, you can offer securities to their equity shareholders, but subject to sectoral cap. ESOP can be offered, but subject to sectoral cap. Pledge of shares are permissible, but if there would be invocation of pledge, it should not breach the sectoral cap. So remember, you can get into all kinds of transaction with foreign equity holder who has made FDI investment in your company. You can offer him ESOP, you can offer him bonus shares, right issue, you can offer them pledging of shares. Everything is allowed, but remember that in whatever transactions they are getting into, your sectoral cap limit should not be breached at all. Got my point, student? Transfer is not that much important. Just remember, whenever you are getting into transfer of instruments, what you'll have to do, you have to report about the transfer within the period of 60 days through ED category 1 bank, right? Right, students. Now the another topic, eligible investor who can make investment in Indian business entities as an FDI. Non-resident entities can do, but if the entities belonging to certain territories like Pakistan, Bangladesh, they need to come through approval route, right? If there is a change in ownership and you are transferring US investments to an Pakistani investor, means US person who has made FDI investment in Indian entities, transferring it to Pakistani, even it does require governmental approval. We know that when it comes to Nepal and Bhutan, you can accept investment in only in terms of foreign exchange, and they can make investment in repatriation basis. Generally, all foreign direct investments are being made on non-repatriation basis, but they can make it in a repatriation basis. They can make it in a repatriation basis with the approval of RBI, right? Inward remittance should be through banking channel only, right? I have taught you what is repatriation basis and non-repatriation basis, right? Overseas corporate bodies are nothing more than the corporate bodies in which more than 60% investment or 60% investment is of foreigners. They can also make. Foreign portfolio investors, NRI investors can make, foreign venture capital fund can make investment in Indian entities, right? Who can accept? We have studied already, right? Remember, and I have given you 5 common points as well, right? Automatic approval route we have studied, right? Downstream investment I taught you, right? These calculations and all. FDI is carrying on an average weightage of 5 marks, and so much has been given in FDI, that is foreign direct investment. I don't find it like very relevant to go through with the same means to cover each and every aspect. Is it clear? Got my point, students? What we have done is foreign direct investment, right? And direct questions generally they are asking, they're not asking any kind of case study based question. Is it clear? Is it clear, students? Good evening, students. Today's topic would be ECB, that is external commercial borrowing. And now, what is external commercial borrowing? You should think about it, and it's a very simple concept when it comes to external commercial borrowing. When you are borrowing money from outside India, whenever you are borrowing money from outside India, and the purpose of borrowing is not a personal borrowing, the purpose of borrowing is commercial borrowing. Means whenever you are borrowing money for your own business operations, not from a bank located in India, but you are borrowing money from a bank which is located outside India, or a public financial institution, or an NBFC, or an institution, or a creditor, or an indigenous lender that has been located outside India. So if you are borrowing money from him in order to invest it, or in order to finance your reconstruction, or in order to finance your business operations, or in order to finance your expansion, in order to meet out your working capital requirement for any purpose, right? So if you are borrowing money from outside India for commercial purpose, it will be treated as external commercial borrowing. And as external commercial borrowing is a cross border transaction, and it is going to be a capital account transaction logically. If you can remember section 6 of FEMA, section 6 of FEMA clearly states that if any transaction, that is a cross border transaction, creating asset or liability outside India, or altering asset or liability located outside India and belonging to person resident of India, will be classified as what? Capital account transaction. So if you are taking money as a borrowing, if you are taking loan as a loan or a borrowing from outside India, it is going to create a long-term liability outside India. So definitely it is going to be a capital account transaction, and it is going to be regulated by section 6 of FEMA. And section 6 of FEMA clearly states that all the capital account transactions are going to be regulated by Reserve Bank of India. So definitely external commercial borrowing is going to be regulated by Reserve Bank of India, right? So if you are willing to raise capital, if you are willing to raise capital or funds from outside India, you will have two options, right? Option number one is you can issue your equity, right? You can issue your equity and can raise fund, and that is known as FDI. Or you can loan from them, that is called ECB. Got my point, students? You will have two options. You can dilute your equity, you can offer your ownership, and can issue depository receipt outside India, or can issue them equity shares over here in India. So if you are diluting your equity by issuing original instruments or convertible instruments, what you are doing, you are accepting FDI, that is foreign direct investment, right? But if you're not willing to dilute your equity and you are issuing them pure debt instruments, or you are offering them preference shares, or you are offering them any instrument that cannot be convertible into equity into future, that is called non-convertible instrument, or you are directly taking loan or a credit from them, it will be classified as an external commercial borrowing. So external commercial borrowing can be in the form of non-convertible debt instrument. It can be in the form of preference share. It can be in the form of it can be in the form of bank loan or PFI loans, or it can be in the form of trade credit, where the term of credit should not be less than 3 years. Average maturity period of ECB should be generally and commonly 3 years. That is the thumb rule, but there are certain situations where the average maturity period of ECB can be even less than 3 years. We are going to cover it in the class only. Okay, so now when it comes to external commercial borrowing, they are saying that every Indian entity cannot accept external commercial borrowing. According to the Reserve Bank of India, if any Indian entity will satisfy the eligibility criteria to become a borrower of ECB, they can only be eligible to accept external commercial borrowing. So there would be a definition of definitely an eligible borrower, right? There would be a definition of eligible borrower, right? And you can accept a borrowing only from the recognized lender. Means two terms are going to be defined in ECB guideline. Term number one would be the eligible borrower, means the person who, according to the Reserve Bank of India's guideline, is eligible to raise funds by raising ECB. And the second one would be the recognized lender, the person to whom you can take a loan. But remember, when it comes to recognized lender should be the lender of a territory which should be the part of FATF, that is Financial Action Task Force, or which should be the part of IOSCO, that is International Organization of Securities Commission. See, internationally all countries are the part of financial cooperation. If a country is a part of financial corporation, they must have signed a I can say the multilateral agreement known as FATF, or a multilateral agreement that is known as IOSCO. So if they are the part of FATF or IOSCO, then only they would be classified as a recognized lender. Means you cannot accept ECB from a country which is not the part of International Financial Corporation, which is not the part of FATF and IOSCO, that we are going to cover in the definition of recognized lender. So three things are there. When it comes to an external commercial borrowing, they are nothing more than a loan that has been taken by Indian business unit for their business reasons, not from India, from outside India. It can be in the form of bank loan, PFI loan. It can be in the form of issue of non-convertible debt instrument, or issue of non-convertible debt instruments, or it can be in the form of issue of preference share, or it can be in the form of issue of any kind of non-convertible instruments, right? Now when it comes to ECB, it can only be raised by the eligible entity as defined in the guidelines, and it can only be taken up from the recognized lender who should be the part of FATF or IOSCO territory, right? So they are going to define eligible borrower, they are going to define a recognized lender, they are going to define minimum maturity period, and I told you the minimum maturity period is going to be regulated by Reserve Bank of India, and commonly it should be minimum 3 years. Even they are going to regulate the all-in ceiling cost, means how much amount you can spend as processing fees or other charges that is going to be charged by the lender in order to raise the ECB. It should be also under the cap limit, means you cannot pay any amount like a brokerage or a like commission or processing fees in order to raise ECB. There would be permitted end usage. Logically, if someone is giving you a loan would always be a purpose oriented, means you need to tell him for what purposes you are borrowing money from him, right? And you should specifically use that money in that purposes only, right? So if you have taken money for buying a property, or if you have taken a money for reconstruction, or you have borrowed money for any particular business purpose, you have to spend it on that only. But along with that, you cannot put it over gambling business, betting business over here in India. You cannot put it over stock market, you cannot put it over here in real estate. So there would be certain end use restriction, that will be a common end use restriction, and specific end use restriction would be determined by the terms of loan. Remember, there would be two end restrictions. The common end restrictions are going, end use restrictions are going to be provided in the guidelines, and the specific end use restrictions are going to be determined by the agreement, the terms and condition based on which you have obtained the loan, right? Got my point, students? Permitted use and non-permitted use, right? There are two category, one is specific and the second one is common. Common will be given in the guidelines, specific will be given in the terms and condition of loan. I told you ultimately it is going to be regulated by Reserve Bank of India under FEMA section 6, right? Now, who can accept loan? Now they are talking about eligible borrower. Who would be the eligible borrower? All entities that are eligible to accept FDI can raise ECB. Means if I would be eligible to accept FDI, foreign direct investment, I can accept ECB as well. Additionally, port trust units in SEZ, Small Industrial Development Corporation and Exim Bank can raise ECB. So when it comes to eligible borrower, 5 people are the eligible borrower, 4 are specific, 1 is common. Any entity, Indian entity which is eligible to accept FDI can accept ECB. A port trust can accept ECB. Units located in SEZ can accept ECB. Other than that, 2 very specific names are there, SIDBI and Exim Bank, right? You can raise ECB in foreign exchange or you can raise ECB in Indian currency. In Indian currency, even registered NPOs, registered society trust, and NGOs which are involved in microfinance activity can also accept ECB. So now they are dividing eligible borrower into 2 categories. One, those who can raise funds in foreign exchange, which includes 5 persons. The first one is entities eligible to accept FDI, port trust units located in SEZ, Exim Bank and SIDBI. These are the 5 people they can accept ECB in foreign exchange. But ECB in Indian currency can also be accepted by, along with these 5, the 6th person, that would be NGO, trust and society or NPO, which has been involved in microfinance activity. Is it clear? So 6 people can accept in Indian currency, 5 people can accept in foreign currency. Got my point, students? What I am teaching you is ECB, external commercial borrowing, right? Now there are certain frequently asked questions about, no, you need not to go ahead with this. Can service sector accept ECB? Yes, a service sector can also accept ECB. NGOs, NPO and microfinance activities are into service sector only, right? Now we are going ahead with the third concept. We know what is ECB very clearly, right? And what can be the forms of ECB, right? We know what is recognized, we know what is eligible borrower. Now we are going to know who is the recognized lender. The first condition to be a recognized lender is the lender should belongs to a territory which should be either the part of FATF territory or it should be the part of IUSCO territory, right? Now whether you are taking money or you are transferring ECB, means if you have taken loan from any country, any person, now you're not willing, you are not capable enough to repay the same, and he is asking for transfer of ECB. You can transfer ECB, means a new lender will come into the picture. Even if the new lender is coming into the picture, that lender should be the part of IUSCO treaty or should be the part of FATF territory, right? Any multilateral and regional institution can lend money to you if they are the part of FATF and IUSCO. Even individual who is the foreign equity holder foreign equity holder or who is the bond or a debenture holder listed abroad can also lend money to you. So 2 people can be the recognized lender. Any bank or PFI located outside India, any individual, if he is a equity shareholder of the borrowing entity, or if he is a bond or a debenture holder of the borrowing entity, but such bond or debenture should be listed in his territory. Okay, means logically is what yaar beta. Logical is like if the company is coming out with a public issue of bonds and debenture overseas, it can be bought by even individual, then individual would become what beta? Lender of lender of the company, right? Now these entity can foreign branch subsidiary of Indian bank, these entities can recognize lender only for foreign currency ECB. Additionally, they can participant or arranger, underwriter, market maker or trader for rupee denominated bond issued overseas. Underwriting by foreign branch subsidiaries of Indian bank for issuance by Indian bank is not allowed. Now 2 things they are saying, that 3 people can act as a recognized lender. First condition is the recognized lender should belong to a territory which should be the part of FATF treaty or which should be the part of the IUSCO treaty. Second, a bank or public financial institution located in that territory can lend money easily, there is no problem. Second, a individual can lend money to a Indian borrowing entity if he is the equity shareholder of Indian borrowing entity. Third condition is he can participate in the public issue of bonds and debentures that is gonna be listed in their territory. So if you are coming out with the public issue of bond and debenture overseas, in that case individual can be the lender. Then they are saying that any branch or a subsidiary of Indian bank that is being located outside India can also be the lender. They can also be the lender, recognized lender, but they can extend ECB only in foreign exchange. They cannot extend ECB in Indian currency. First condition. Second condition is they can also act as a arranger or underwriter or a market maker or a trader if you are issuing rupee denominated bonds issued overseas. So they can act as even underwriter, arranger, or market maker for your rupee denominated bond issued outside India. And rupee denominated bond issued outside India is known as masala bonds. Okay, when you are coming out with issue of bonds outside India, they should be represented in their local currency, but if they are being represented in Indian currency and issued overseas, it will be treated as masala bonds. Got my point, students? And Indian foreign branch or a subsidiary of Indian bank cannot underwrite the public issue of security by an Indian bank overseas. Got my point? So giving you a quick review, when it comes to recognized lender is nothing more than a person which may be a artificial person or a natural person who is being located in a territory which should be the part of FATF or IUSCO. First condition is it can be a bank or PFI. It can be an Indian bank foreign branch or subsidiary. They can lend only in foreign exchange, but they if want to act as an underwriter, arranger, or a market maker for any issue that has been made outside India, public issue of Indian bonds made outside India, that is going to be rupee denominated bonds, that is masala bonds. Overseas they can act as underwriter, arranger, or the market maker for the same. Then you can even borrow from the bank or public financial institution of outside India. Then you can also borrow from individual if he is your foreign equity holder, and you can borrow from individual if you are coming out with the public issue of debentures that is gonna be listed outside India, right? Then even individual can be the lender. Got my point? So third important aspect, that is recognized lender, is done. I have made certain FAQs, you guys can go through with the same. Now minimum average maturity period, when it comes to minimum average maturity period means you are free to determine the average maturity period, but it should not be less than minimum average maturity period. Here the average maturity period means the maturity period of all ECB taken by the foreign by the Indian entity. Is it clear? So they are saying that general rule is MAMP should not be less than 3 years. MAMP should not be less than 3 years. MAMP should not be less than 3 years. Even if you are putting a put and call option, put option is nothing more than an option in which the lender can demand for repayment of money anytime, and call option is nothing more than an option that can be exercised by the borrower, that if he got money early he can prepay the ECB loan, but any put and call option cannot be exercised before 3 years. Got my point? Is it clear? If you are a manufacturing company, and if you are taking ECB where the value of the ECB up to 50 million US dollar per financial year, minimum average maturity period should be 1 year. What they are saying that I told you in certain situation it can be less than 3 years as well. If you are a company which is an Indian company involved in manufacturing, and if you are raising ECB where the value of the ECB is up to 50 million US dollar per financial year, minimum average maturity period should be 1 year. If you are raising funds, if you are an Indian business unit which is raising fund for working capital purpose, for general corporate purpose, or repayment of rupee loan, and you are raising funds from foreign equity holder, then minimum average maturity period should be minimum 5 years. So if you are an Indian entity and you are raising funds for working capital purpose or for general corporate purpose, means for your administration, or you are raising funds to repay your rupee denominated loan, means your Indian loans, and you are raising funds from foreign equity holder, the minimum average maturity period should be 5 years. If you are raising for general corporate purpose, working capital, and rupee loan repayment from non-capital expenditure, it should be 10 years. What they are saying that If you're taking money, I would divide it. That would be very easy for you students. The first condition is, if you are taking for these purposes from foreign equity holder, it should be 5 years. If you are taking it from other than foreign equity holders, then it should be minimum 10 years, right? And if you are taking loan for making the capital expenditure related repayment of rupee loan, then it should be minimum 7 years. Is it clear? So let's draft a chart, that would be better. What is minimum average maturity period? MAMP should be generally 3 years, but there are certain specification. If it is a manufacturing company taking up to 50 million USD per financial year, then it would be 5 years, right? Then if you are taking it for three purposes, for general corporate purposes, or for working capital purposes, or for rupee loan repayment. Rupee loan repayment means you have taken loan from India, now you are raising ECB in order to get it repaid. Okay, so if you are taking it from foreign equity holder, it should be a minimum 5 years, right? And if you are taking it from other than foreign equity holder, right, foreign equity holder, there will be two options. If you are taking it for general corporate purpose, working capital purpose, or working capital repayment of loan, it should be 10 years. And if it is for capital expenditure related loan, it should be 7 years, right? Got my point, students? What I'm teaching you is MAMP, that is minimum average maturity period. Got my point? Is it clear? Is it clear, students? You guys can copy this chart, then we'll proceed further. So we have done with four aspects. We have done with minimum average maturity period too, right? So we know four things about ECB. What is ECB and what category of ECB you guys can raise from outside India? You know what is recognized lender, you know what is eligible borrower, the 5 and 6 categories, right? Then when it comes to recognized lender, there are three recognized lenders, right, with common condition. And when it comes to MP, it is 4 MAMP, right? I told you there are common negative lists. You cannot use the ECB money for real estate activity. You cannot use it for making equity investment or investment in capital market. You cannot use it for general corporate purpose or working capital purpose until and unless you have taken it specifically for the same. You cannot use it for repayment of your rupee loan until and unless you have taken it for specifically for the same purpose, and you cannot use it for lending to others. So now you know the fifth thing as well, that is the negative list, that is end use restriction. Common end use restriction is you cannot make investment of ECB proceeds into real estate, into equity investment, on stock market, on lending to others, and you cannot use it for general corporate purpose or working capital purpose until and unless it has been specifically specified in your terms of arrangement of ECB. And you cannot use it for repayment of Indian rupees loan until and unless it has been specified like that, right? Right, students? Now exchange rate for ECB, there is a thumb rule for exchange rate. Generally while raising the fund, it would be the rate that has been agreed between lender and borrower, and in case of settlement it would be the rate that has been prevailing on the settlement date. Is it clear? So the common rule is what, if you are borrowing money, then the exchange rate will be applicable, the rate that has been agreed between lender and borrower, or the market rate, whichever is lower. But at the time of settlement or repayment of ECB, it would be the rate that has been the prevailing on the settlement date. Got my point? How much ECB you guys can raise per financial year? Through automatic route. You know what is automatic route, where you need not to take approval of any authority or officer, that is called FIPB, Foreign Investment Promotion Board, to raise ECB, that is called automatic route. So under automatic route you can raise maximum per financial year maximum up to 750 million US dollar. But if you are raising it from your equity holder, that is you are raising it from the person who is the equity investor in your company, you can raise maximum up to 7 times of the equity investment made by him. So suppose if he has made 1 million US dollar ka equity investment in your company, you can raise maximum up to 7 million US dollar. But this 7 times ka ratio is not applicable for ECB up to 5 million. So three conditions is that: can you raise ECB from automatic route? Yes, without taking approval of any authority, you can raise ECB from automatic route. Maximum permissible ECB through automatic route can be 750 million US dollar. Third condition is if you are raising ECB from foreign equity holder, it can be 7 times of the equity investment made by him, but that 7 times the condition is not been applicable if the value of ECB is 5 million, up to 5 million US dollar, right? We know that Indian bank cannot support Indian bank to raise ECB outside India, right? Even they cannot acquire Indian company के foreign currency convertible bond or foreign currency exchangeable bonds. Okay. Three things they cannot do: they cannot support any Indian bank to raise ECB from outside India, means they cannot get into any kind of support. They cannot guarantee ECB raised outside India by an Indian company. Third, they cannot invest in FCCB and FCB. This is the three restriction, right? Got my point, students? So we have done with the sixth topic, uh, that is end use restriction. Fifth topic is done. Then ECB through automatic route is done, right? Right, students? Now parking of ECB and ECB by startup. Conversion of ECB for oil marketing company, and few more topics are pending. Okay, what I'm teaching you, students, I'm teaching you ECB, right? Getting everything, students? Taking a pause of 2 minutes, then I'll continue. Okay. Now proceeding further, we have done with almost 5-6 topics of ECB. Now going ahead with parking abroad. Now what is parking abroad? Parking abroad means you have to put that money abroad in the form of bank FD or something, because if you are not having any usage over here in India, immediately you can put it or park over there outside India. Parking is what? Nothing more than temporary putting your asset in a particular location, right? It is a temporary arrangement, it is not a permanent arrangement, right? So if you are having if you have raised ECB only for foreign currency expenditure and you are not having immediate usage of the same, right? If you are not having immediate usage of the same, you can put it in parking over treasury bill of outside India with the Indian bank branch, or you can put it in a bank deposit that has been rated at least AA minus. Okay, if you have raised that ECB for Indian rupees expenditure, you have to brought it over here in India as soon as possible. Repatriation need to be taken care over here in India through AD category bank, and maximum up to 12 months you can park it up over here in India. So parking is even divided into two parts. If you have raised ECB for foreign exchange expenditure, you have to get it parked outside India with any bank or PFIFD ranking AA minus, or with the treasury bill located outside India. But in any case, maximum period of parking can be 12 months. And in case you have raised it for Indian expenditure, you have to bring it on over here in India. Like you have to bring it on over here in India. That is called repatriation over here in India as soon as possible. Maximum 12 months you can do it. Parking ka task. And the third thing they are saying that it should be through AD category 1 bank, right? Now, what is startup? We know that startups are what? Whenever we are talking about a startup, startups can be a private company, it can be an LLP, it can be a proprietor, it can be a registered partnership firm, but a proprietorship firm and a public company cannot be a startup. Second thing, they haven't completed 10 years from the date of their incorporation. Third, their annual turnover should not exceed 100 CR. Their turnover should, overall turnover should not exceed 100 CR, and they should be either involved in employment generation, or they are involved in innovation, or they are involved in wealth creation. Either of the three objective has to be satisfied, right? And a new entity, it should not be created out of splitting up or reconstruction, right? They can even raise ECB. Minimum average maturity period should be 3 years. They can raise it from FATF compliant country only, not even IUSCO countries, right? They cannot raise it from Indian bank ka foreign branch or subsidiary. They can take loan. They can issue even preference shares. They can raise both in Indian currency and foreign exchange. Maximum limit is 3 million US dollar. Two limits came, I guess. Three limits came. एक 50 million वाला limit. The second one is 750 million US dollar वाला limit, and this is third 3 million US dollar. That is the maximum limit. Cost is going to be mutually determined, and use only, you can use it for business related expenses, not for other things. You can get it converted over equity. Security or guarantee would be associated. Now, what is hedging of ECB? See, ECB requires regular payment of interest. So sometimes foreign exchange rate may increase, and in that case you have to pay the big amount on interest. Suppose you have borrowed ECB in US dollar where the dollar price was 70, but now the dollar price is 80. So you have to pay interest uh, at which is going to be calculated with the rate of 80. So in order to in order to hedge your upside risk, that if in future exchange rate will increase, it will create a burden to risk, like repayment amount will be increased and interest payment amount will be increased. So in order to hedge the upside risk, you guys can get into derivative contract. For some ECB it is optional, but for startups it is mandatory. Okay, it's advised, not mandatory, sorry. Other condition like parking, reporting and everything is similar. So what they are saying, that when it comes to ECB, startups can raise ECB. So first define the term startup. Minimum average maturity period should be 3 years. They can even raise from FATF compliant country. They can raise it in Indian rupees or foreign exchange. Main is 3 million US dollar, and the second one is minimum average maturity period, right? Other things are simple, and hedging is advised, right? Got my point, students? Is it clear? What we have done with this next question, that is what startup ECB, right? We have done with startup ECB, and we have done with parking as well, right? We have done with parking, right? After parking, what they are teaching us in ECB, conversion of ECB into equity. So what would happen if the ECB is going to be convertible into equity? It will lead to conversion of ECB into FDI. What is equity, students? It is nothing more than you are raising equity investment from foreigners, right? If you are converting ECB into equity, now you are converting loan into debt into equity. So it will lead to what? Conversion of ECB into FDI, right? Two routes are available, automatic and approval route. It totally depends upon which sector you belongs to, right? If you are belonging to a 100% free sectoral cap sector, then you can get it done through automatic route. Otherwise you have to follow what? Approval route, right? It does require consent of the lender. No extra cost you can charge for such conversion. You have to comply with FDI rules. You have to follow a pricing guidelines, and you have to report about the conversion. If you are making partial conversion of ECB For convertible part, you have to file FCGPR form. For non-convertible part, you have to continue filing monthly return on ECB2. If you are making it fully converted, then you have to finally file ECB2 that your entire ECB is being converted into equity. Now you are going to file FCGPR form only. Okay, and ECB2 is the monthly return. This is the important point. Now, repeating, when it comes to conversion of ECB into equity, it is nothing more than conversion of debt into equity. It is going to conversion of ECB into FDI. So you have to follow FDI guidelines as well. You need to check that your company belongs to which kind of sector. If your company belongs to 100% free sectoral cap sector, in that situation, the ECB is going to be convertible. ECB is going to be convertible into equity with automatic route, otherwise approval route. First condition. Second condition is no extra cost you can take. Consent of lender is very necessary. You have to comply with FDI rules. Now, when it comes to report filing, if you are converting the full amount into equity, then you have to file two forms. First one is FCGPR, showing that now you have taken equity from foreigners. Second, ECB2, that your entire equity is being converted, ECB is being convertible into equity. Now you are not going to continue with ECB2. If you are converting partially, then for the conversion part, FCGPR form has to be filed, and regularly you have to continue with the ECB2 form, right? Even oil marketing companies, that is governmental companies involved in oil marketing like BPCL and all, can get into ECB. They can raise ECB for operational expenses. Minimum average maturity period should be 3 years, same like startups. They can go ahead with automatic route. Hedging is not mandatory, it is advisable, right? All the oil marketing company together can raise up to 10 billion US dollar, up to 10 billion US dollar. Got my point, students? Maximum permissible limit is 10 billion US dollar. It is not for individual oil marketing company, it is all together for all oil marketing companies. Is it clear? A startup individual limit is 3 million US dollar. For them, 10 billion US dollar altogether, right? Got my point? So now what they are saying, that when it comes to oil marketing company, all oil marketing company can opt for automatic route. Minimum average maturity period should be 3 years. Hedging is optional, and there is no individual cap limit. Altogether they can raise up to 10 billion US dollar, right? So we have done with oil marketing company too, right? Can an entity which is under investigation can get into raising ECB? They can raise if they are satisfying general eligibility criteria. It should not affect their ongoing legal case, but before raising such equity, such ECB, they need to report it to the Reserve Bank of India that they are raising. That is it. So entities into investigation can raise, but they need to first intimate whom? RBI and the concerned sectoral authorities. If you are raising ECB, you will get an loan registration number, that is the identity number of your ECB. Any change in terms and condition of ECB need to be reported in ECB form to the RBI through authorized dealer category 1 bank. Then every month you have to file within the period of 7th or of the next month ECB returns, that you are continuously serving your ECB. Delay in submission will lead to late submission fees. So 3 filings you have to done. Once ECB has been taken, file ECB form with the detailed terms and condition. If there is any change in the terms and condition of ECB, again file ECB form within the period of 7 days from the date of raising ECB, and monthly you have to file ECB2 form showing that you are regularly paying interest, right? What we are studying is ECB external commercial borrowing, right? Return requirement, right? Return requirement. Now the last part, untraceable entities are pending, and after that your ECB is over, right? Now starting with the last topic of ECB, that is untraceable entities. Now what is untraceable entity? Logically, if any Indian entity has raised fund in the form of ECB, now their promoter, director, KMP officers are not available for communication. They are not filing regular ECB2 form, that is return of ECB for a particular period of time. They would be classified as untraceable entity, and that will create an adverse impact over the reputation of Indian entities, because logically if you have taken loan from them and you are defaulting and you are completely vanished, it's not good at all, right? So that is what untraceable entity. So there are certain criteria for classifying an entity as an untraceable entity. They are saying that once an entity is being classified as untraceable, the following steps should be taken. Just a minute. What is untraceable entity? Communication failure. The entity along with auditor, director or promoter is untraceable or unresponsive over email, letter, phone for 2 consecutive quarters despite at least 6 documented attempts. So there are two conditions. There should be, you have to wait for minimum period of 2 quarters, and minimum number of attempts or reminder that need to be documented or sent to them should be 6, right? The entity is not found to be operating at its registered office or address during a visit by the AD bank officers. So they should not be available at operating place, and the entity has not submitted a statutory audited certificate for the last 2 years or more. So if any one of the condition has been satisfied, entity will be classified as an untraceable entity. It's been 2 quarters, you're not filing, you're not documenting anything, and it's been 6 reminder has been sent to you, and your promoter, director, KMP officer and statutory auditors are unreachable. Second, if you are not working in a place that has been mentioned as your proper address, right, in the ECB documents. And the third one is, it's been 2 years, you are not submitting a statutory auditor's certificate, you will be classified as an untraceable entity, right? Now AD category 1 bank will file ECB2 return marking it as an untraceable entity. Okay, that is the return that is not going to be filed by the entity, it is going to be filed by whom? Um, the ED bank, right? Their ECB is going to be written off, means now the recovery proceeding can be taken by the lender, but RBI will not release any kind of foreign exchange for the same. Now no ECB application will be proceeds for him. Logically, if you have defaulted Indian loan, you are not eligible to get the new Indian loan. So how you can expect to get a new loan if you are an untraceable entity, right? It will be classified as an untraceable. Now you cannot use automatic route at all. These are the consequences. Got my point, students? We have done with what? ECB is over. Okay, done. ECIPL chapter number 3, overseas direct investment. So what is exactly overseas direct investment? Whenever we are talking about overseas direct investment, it is just reverse to foreign direct investment. What is foreign direct investment? When we have done with the concept, right? When we are talking about foreign direct investment, we do talk about they are making, means person resident outside India is making investment over here in India. That is called foreign direct investment, which is also economic growth indicator for Indian economy, right? And overseas direct investment is what we call a lot of money, right? Means Indians, person resident of India is making investment outside India. And whenever we are talking about direct investment, student, the basic objective of direct investment is always one single basic objective: to acquire the control of the investee entity. Means you are willing, being an investor, you are seeking for long time control over the investee entity, you are not seeking for tactical investment. So whenever I would talk about overseas direct investment, I do talk about overseas investment that has been made by a resident entity or resident individual outside India, where the sole purpose of making investment in overseas entity or investee entity is to acquire controlling interest in that entity. So that will be an overseas direct investment, right? That is Indian person making investment outside India. And if it is being made for the tactical purpose means for buying, selling or dealing in security to book the profits, it will be, I guess, what I guess I know, will be overseas portfolio investment. We have done with thorough concept of difference between foreign portfolio investment and foreign direct investment. The same difference would be there when it comes to overseas portfolio investment and overseas direct investment. As you are going to create an asset outside India, belonging to person resident of India, it is going to be a capital account transaction. Being the capital account transaction, it is going to be regulated by Reserve Bank of India, right, under section 6 of FEMA, right? So FEMA has to be complied with, right? FEMA overseas direct investment rule, overseas investment rule has to be followed with, overseas investment regulation has to be followed with, and overseas investment directions has to be followed with. So four regulations are going to be regulated. The first one is FEMA 1999, then direction regulations and rule 2022, right? Got my point, students? Is it clear? Now whenever we are talking about overseas investment, overseas investment is a wider term which includes overseas direct investment, it includes financial commitment, and it includes overseas direct investment, financial commitment, and overseas portfolio investment. So OI is a wider term which includes OPI, which includes ODI, and which includes financial commitment. Is it clear? It is a wider term, right? So what is overseas direct investment? If you are now there are three methods of making overseas direct investment. If you are becoming promoter or founder of a overseas entity, there will be an overseas direct investment. If you are acquiring equity stake in an unlisted overseas entity, it will be overseas direct investment. And if you are acquiring minimum 10%, not less than 10%, minimum 10% or more of the paid up equity capital of foreign entity, same to same, right? So there are three methods of making foreign direct investment. Either become founder of them, become the subscriber to the memorandum of association of an overseas entity, acquire any stake in unlisted overseas entity, or third, acquire minimum 10% in a listed overseas entity. Is it clear? Three methods are there. So ultimately you are control seeker, right? Even if you are making investment or becoming partner in LLP, it will be treated as what? Overseas LLP. It will be treated as what? Overseas direct investment. Term overseas investment is a wider term which includes financial commitment and overseas portfolio investment, right? What is financial commitment? Financial commitment is a wider term which includes ODI, which includes long-term debt investment, and which includes non-fund based facility. Means whenever we are talking about overseas direct investment, we are looking for equity investment or investment in convertible instruments, right, students? But the company in which you have made investment in equity or convertible instrument, if looking for further fund, you can offer them long term debt, or you can arrange fund for them by giving guarantee, right, by giving guarantee to the lender, right? So whenever we are talking about overseas investment, it can be divided into two parts. The first one is financial commitment, or it can be OPI. OPI is an operational investment, right, where you are bothered about short term profitability, you are not looking for any long term commitment, right? But when it comes to financial commitment, first it will be in the form of ODI, overseas direct investment. That is in three form it can be done, right? You can become subscriber. Second, you can make investment of not less than 10% of listed entity. Third, you can acquire any amount in unlisted entity, right? These are the three methods. Once you have done, you can provide them long term debt. If you are providing them long term debt, even it would come under financial commitment. And if you are providing them guarantee, corporate guarantee to acquire further funds from overseas market, it will come under financial commitment. Got my point, students? Is it clear? So ODI is a part of financial commitment. So if you have made ODI, you are going to arrange fund for them, you are going to give them long term debt. Is it clear? Got my point, students? And giving guarantee is known as non-fund based commitment, because you are not going to give the fund, you are going to arrange the fund for them, right? Indian entity can be a company, it can be body corporate, it can be LLP, it can be firm. Even individual is allowed to make overseas portfolio investment, right? Right, students? Is it clear? That instrument can be, you can make investment in governmental bond, corporate bond, securitized bond, it doesn't matter at all. What is important in the marathon, I'm going to cover that aspect only. The most important question over here is one, regulatory framework you guys have to go ahead with. Okay, the regulatory framework institute can ask. And second one is, what is ODI, OPI and financial commitment? This is the most important part of this chapter. Okay, now, if you are willing to make investment, there are two methods to make investment. We know that automatic route, approval route. If you can make investment without taking approval of Reserve Bank of India, it is called automatic route. Otherwise, it will be approval route, right? You can make investment in a foreign entity who should be in bona fide business activity, right? It should be, the investment can be made by creating step down subsidiary or through a special purpose vehicle. Investment can be made by two manner. The first one is you can create a step down subsidiary over there, or second one is you can make investment through a special purpose vehicle. Okay, when it requires approval of Reserve Bank of India, when you are making investment in Pakistan, Bangladesh, or you are making investment in strategic sector or specific geographies. So if you are making investment in Pakistan or Bangladesh, it does require approval of Reserve Bank of India. If you are making investment in strategic sector, then it does require approval of RBI. Okay, if the financial commitment is more than 1 billion US dollar, it does require approval. Okay, three approvals are required. One, if you are making in particular territories, that is Pakistan and Bangladesh. If you are making investment in strategic sectors, okay, like power or transportation kind of sectors. And third, if you are making investment where the amount of investment is more than 1 million US dollar, it does require RBI ka approval. Is it clear? If you have taken any loan from bank or public financial institution over here in India, and they have classified your bank loan into a non-performing asset, it does require NOC from bank or public financial institution who has given loan to you, because you are not repaying their loan and you are making investment outside India. And if any investigation, inspection, inquiry is going on with any investigating agency or regulatory body, you have to take approval of that as well. Is it clear? For guarantee, there is no need to take approval. What is strategic sector? I told you transportation, oil, gas, coal, mineral ores will be a strategic sector. And if you are even willing to make investment in startup, it will be classified as strategic sector. In a strategic sector, you can make investment only through approval route, not through automatic route, right? Like you can issue FCEB only through approval route. You cannot go ahead with automatic route, right? Even if the company which is being involved, the firm which is being involved in strategic sector can be an unregistered entity as well. Generally you should make investment in registered entity, but if they are being involved in a strategic sector, you can make investment in unincorporated entity as well. So when it comes to strategic sector, only approval route is allowed. When it comes to strategic sector, it includes marine, submarine cables, mineral ores, oil, gas, right, power, coal, etc. Even you can make investment in unlimited liability entities, that is unincorporated entities, right? Submarine cable and all. You should not get into so much detail on a strategic sector. That much is more than sufficient to know that not automatic route, approval route, the entity can have unlimited liability, and unregistered entity can also be eligible for taking the investment, right? You can send money through ordinary banking channel. You can use the fund that has been kept in your EFC account or RFC account. You can go for swap of security. You can go for swap of depository assets. So there are 4-5 methods of funding. If you are willing to send money to them, you can go ahead with normal banking channel. Second, you can use the fund that has been kept in your RFC account or EFC account, that is resident foreign currency account or exchange or foreign currency account. Or you can go for swap of securities, right? Or you can convert ADR GDR into or ECB into equity. Okay, cash cannot be taken away. Only through normal banking channel you can transfer the fund, right? No need, no need. If you are making any investment, pricing guidelines has to be followed. If you are making investment in overseas entity which is unlisted, you have to get it valued from a registered valuer. Got my point? So fair market valuation should be taken away. Okay, and if it is a listed entity, you have to take the quoted price, not more than the price laid down there. Is it clear? Got my point, students? What we have started with overseas direct investment, this is the third chapter. On an average, weightage is going to be 4 to 5 mark of your syllabus. So we have done with many chapters, like we have done with FAMA, we have done with we have done with FDI, right? And we have done with ECB as well. Now I have picked the chapter related with foreign exchange only, right? If the company is going to be liquidated, you can disinvest, you can take back your money, that's not a problem. If your company will get into reconstruction, reconstruction is permissive, means where you have made the investment, now the company is facing losses, then you can go ahead with compromising your overseas direct investment in the restructuring process, but company should be minimum losses minimum for a period of 2 years. Okay, and maximum permissible compromise can be 10 million US dollar or 20% of your total investment, whichever is lower. Okay, so what they are saying that if the company in which you have made investment, you got a hard luck, the company is not performing good, so now you are in opinion, means the company is in opinion to go for a restructuring, means they are asking you to compromise your investment, you can get it done. You can get it done, but the maximum value of such amount can be 10 billion US dollar or 20% of your total outstanding use, whichever is lower. And if it is that amount, it does require registered valuer ka certificate on valuation. Is it clear? Latest certificate, not carrying a period more than 6 months, should be taken. You have to submit the detailed of accumulated losses with RBI, the proportionate amount belonging to you, how much diminution you are taking care. Okay, these everything has to be submitted. This restructuring, I would say, that is important because it is something that is being added. Is it clear? You have to open a foreign currency account overseas in order to transmit your money. Once you have made investment within the period of 6 months, you have to submit through AD Bank the certificate of equity or certificate of investment. Okay. You can subscribe their shares, you can acquire in the bidding, you can acquire right issue or bonus issue, it can be capitalization of your exports, it can be swap of securities, we have done, right? You can even acquire during amalgamation, merger, etc. Now, can you make an overseas direct investment in financial service activity? So yes, you can take investment in financial service activities, but the condition is your company should always be involved in financial service activity. You should have continuous profitability of last 3 years, means you should be in existence for minimum period of 3 years, and all 3 years you have earned profit only, right? You should be registered with the financial regulator over here in India, and they should also be registered with the financial regulator over there, right? And the further thing is, like, you need to comply with the sectoral regulator norms as well. Four things you guys have to write. Two things I have done with little speed. When how you can make investment in the form of overseas direct investment, you can become subscriber to their memorandum, you can subscribe in their public offer, etc. You can go ahead with right issue or allotment in bonus issue, you can go ahead with capitalization of your exports, or you can go ahead with swap of securities, right? Or you can participate in merger, amalgamation, or acquisitions, right? Now, can a financial service entity can make investment outside India? Financial service entity is nothing more than bank, insurance company, etc. Yes, yes, they should also involved in financial service sector over here in India, registered with the sectoral regulator. Along with complying the requirement of FEMA, they have to comply with the requirement of sectoral regulator, and the entity in which you are making investment should also be registered with sectoral regulator. How much maximum financial commitment you can make? For 400% of your net worth, means whatever your Indian net worth is, maximum permissible limit of commitment would be 4 times of your net worth, but maximum up to 1 billion US dollar, beyond which it does require approval of RBI, right? But if you are deploying your ADR GDR proceed or ECB proceeds, it does not cover under 400%. Okay, this is very important point. Maximum permissible investment limit without approval is 4% of the net worth or 1 billion US dollar, whichever is lower. But this 400% does not include what? ADR GDR proceeds usage and ECB proceeds usage, right? And if you are making investment in strategic sector, this 400% ka limit is not applicable at all. Now, can a registered trust and society can make ODI? Yes, they can. This is very important question. Institute used to ask this question. Can a registered trust or society can make investment outside India? Yes, there should be express provision in their bylaws, then only they can. They should be involved in education sector or hospital sector, otherwise they cannot. Third, they should be in existence for minimum period of 3 years, right? Minimum existence of 3 years is required. It does require approval of the trustee or the governing body. Okay, got my point, students? So what they are saying that a registered trust and society can make overseas direct investment. They should be in existence for minimum period of 3 years over here in India. They should be registered under proper regulation or laws. Further, they must be in education sector or hospital sector, means not open for all sectoral societies and trusts. And further, there should be an express provision in their bylaws, and internal approval of governing body is essential, right? Got my point, students? Can you make investment in IFSC, International Financial Service Center? Answer would be yes, but only through approval route. Financial regulator ka approval is required. If you will make an application, your application is going to be sorted out within the period of 45 days. You should be part of the financial service industry, and you should be registered with the financial regulator. Same. You can make direct investment or you can make downstream investment through investment vehicle. Done, students. We have done with certain questions are very important. What is overseas direct investment? What is financial commitment? What is overseas investment? And what is overseas portfolio investment, right? Second question that is very important is strategic sector. Okay, along with strategic sector, the next question is trust and society is very important. Okay. Investment in financial service sector is also important. Now, reporting requirement is very important. If you are made overseas direct investment or a financial commitment within 30 days from the date of disinvestment or making commitment or restructuring, you have to report everything to the Reserve Bank of India through AD category 1 bank. Okay. In case of overseas portfolio investment, you have to report every 6 months within 60 days from the end of 6 months. In case of IDR and all, reporting is required. Annual performance report has to be filed. Annual performance report is mandatory. Is it clear? So what all reports are there? If you are making financial commitment, disinvestment, restructuring, within 30 days you have to report. If you have made foreign portfolio investment, every 6 months within 60 days you have to report. ESOP and IDR need to be reported within the period of 30 days from the date of issue, and along with that annual performance report you have to file, right? Through, and all filing would be done through authorized dealer category 1 bank, right? If you are delayed in reporting, you have to file late submission fees. Along with, you will not be allowed to go ahead with the financial commitment, a new financial commitment. Okay. Maximum 2 layers of subsidiaries are allowed. You know that Indian companies cannot maintain, as per section 186 of Companies Act, they cannot maintain more than 2 layers of subsidiaries, right? Even if it is being located outside India. But it is not going to be applicable on banking company, NBFCs, insurance company and government company. More than 2 layers of subsidiary can be maintained even outside India if it is a banking company, NBFC, insurance company and government company. Done. So we have done with one more chapter, that is what ODI. So successfully we have done with four big chapters. The first one is FEMA, the second one is FDI, the third one is ODI, and the fourth one is ECB. Right? Done, students. Starting with FCRA, which is the seventh chapter of your ECIPL. When it comes to FCRA, what is FCRA? Foreign Contribution and Regulation Act. See, students, when it comes to bilateral payment, means if you are getting into a commercial transaction with overseas entities, means a cross-border transaction, it is going to be regulated by FEMA, right? But if you are getting into unilateral transaction, means you are an Indian NGO, NPO, or an Indian person who is accepting any kind of contribution, kind of donation or unilateral payments from outside India, that will create a doubt why they are donating in your activities. So a lot of educational institutions are taking, Catholic institutions are taking foreign donations from outside India. So they need registration under FICRA. So they have to get themselves registered with FICRA, and they have to open a separate bank account for accepting such contribution, and they have to make sure that entire such contribution is going to be used in an optimum manner, in a specified manner that has been specified in accepting donation terms. Got my point? So when it comes to foreign contribution and foreign hospitality, when it comes to foreign contribution, it is nothing more than a cash donation or a kind donation that has been received by Indian source, that is Indian person, from a foreign source, and that foreign source can be an Indian foreign company, it can be a foreign individual, it can be a foreign government, it can be a multinational institution, it can be a foreign corporation, it can be any entity in which majority of the stake is being owned and controlled by the foreigner, even if it is an Indian entity. Is it clear? So that is the definition of foreign source. And foreign contribution can be received in cash or it can be received in kind. Even if you'll put investment of foreign contribution in any FD or something, interest earned out of that foreign investment will, or foreign contribution will also be treated as what? Foreign contribution. Got my point? These all norms need not to be considered. Earlier, permissible expenses in out of foreign contribution was 50%. Means if you are receiving foreign contribution, you can spend up to 50% of the foreign contribution in general corporate purpose, but now you can spend maximum 20%, 20% on administrative expenses. Okay, I told you foreign contribution can be in the form of an article, it can be in the form of currency, it can be in the form of even security. Okay, it will be given to an Indian source by a foreign source, right? Even if you are earning any interest on the same, it will be treated as what, beta? A foreign contribution. Foreign source, I told you, it can be a foreign government, it can be an international agencies, it can be foreign company, foreign corporation, multinational corporation, or an Indian company in which not less than 50%, more than 50% should be invested by foreign person. Even citizen of foreign trade union, foreign trust and society would also come under the definition of, in the definition of what? Foreign source, right? Who can receive foreign contribution? Any person, but it requires FICRA registration, right? Now there are certain persons, this is the most important aspect of this chapter, section 3, which persons are not being allowed to accept foreign contribution. If you are a person who is having political connection over here in India, or you are in a position of influence, political influence or governmental influence, you are not at all allowed to accept foreign contribution. So you can divide it into some political connection, right? Now who would be in a political connection? Logically, a person who is a candidate of election, a political party, an organization of political nature. Remember, when it comes to P, political, it includes candidate for election, it includes political party, it includes office bearer of political parties, it includes organization of political nature, and it includes MP and MLA. These five people cannot accept foreign contribution. Candidate for election, political party, office bearer of political party, organization of political nature notified under section 5 of this act, and MP and MLA. Then second, when it comes to government related organization, it includes governmental employee cannot accept foreign contribution, judges cannot accept foreign contribution. Is it clear? Then the next one is media agencies like newspaper agencies, key managerial person, or news media agencies, key managerial person cannot accept what? foreign contribution. Your government employee include employee of governmental corporation as well. Got my point, students? Is it clear? I taught you everything. I have divided it into P, G, M. P for political party, G for government, M for media agencies, right? And how many peoples are there? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 people cannot accept what? Foreign contribution. It is extremely prohibited. If you accept foreign contribution, that will lead to contravention of provision of this act and you would be in trouble. Okay? Whatever foreign contribution that has been received directly or indirectly, remember it is going to be spent on a specific purpose. I told you, right? Got my point? This you guys can leave restriction 3.2 and 3.3. If you are the person belonging to category of section 3 but you are accepting it as a bilateral payment, that is business related payments, okay, or you are accepting it as an agent of government or delegation member, or if you are getting it from your relative, or if it is in the form of scholarship or stipend, so bilateral payment, relative gifts and gifts from relatives, and a gift as a foreign delegate of Indian government, okay, and any scholarship and stipend is permissible. That is exception to section 3. That is very important. Got my point, students? Is it clear? Now, how an organization will be declared as an organization of political nature? It is a very simple thing. That is section 5. Section 5 is clearly stating that if an organization is propagating the political idea of any political party, by seeing or observing their activity, central government can under this act can under this act can ask the concerned organization to justify within the period of 30 days why they should not be classified as what? Organization of
what you mean by cessation of political.
It will be classified as what? Organization of political nature, but they have to make a representation within the period of 120 days. If they could not justify, they will be classified as a organization of political nature, and once they will be classified as an organization of political nature, they cannot accept foreign contribution, right? There is no need to learn the definition of political party. Any party which has been eligible to contest election as per Election Commission of India will be classified as a political party, right? What is foreign hospitality? It is nothing more than a casual offer where the foreign person is offering you cost of travel, medical treatment, and stay arrangement in overseas. Okay, that is called what? Foreign hospitality. Is it clear? He'll take care of your local transportation, foreign traveling, medical treatment, or stay, lodging and boarding expenses overseas. Okay, got my point? Certain person are restricted to accept, not prohibited. Foreign contribution is prohibited, but foreign hospitality is restricted. MP and MLA, office bearer of political party, they cannot accept foreign hospitality until and unless they'll take the approval of Ministry of Home Affairs. Judges and government servant and servant of the governmental entity cannot accept it. So only 5 persons are there. First one is MP and MLA. Second one is office bearer of political party. Third is related with government, that is government servant, that is servant of the governmentally owned corporation, and judges. They cannot accept foreign hospitality until and unless they'll take the approval of Ministry of Home Affairs. But in case of medical emergency, they need to report it to the Ministry of Home Affairs within the period of 1 month. There were one case study came long back in the exam. If I am a director of a public company, can I accept foreign hospitality? Yes, I am a part of the public company. I am not the employee of governmental corporation. Public company is ordinary company. If they would mention that I am a director of a governmentally owned corporation, in that case, even I can accept in case of medical emergency. I have to report it within the period of 1 month from the date of accepting hospitality, right? In case of medical emergency, right? It should be a casual offer. Foreign hospitality, it cannot be a planned offer. Okay, now section 7 is clearly stating that if you have received any foreign contribution, it is not transferable. Okay, And 8 is saying that maximum 20% can be spent on what? General corporate purposes or administrative expenses. Remaining 80% should be spent on specific purposes only, right? Central government can add names in section 3. Okay, they can add name in section 6. They may require any person to go ahead with registration under this act and all. So prohibitory list can be enhanced by central government by adding new entries. Section 6 ka list, that is foreign hospitality ka list, can be added under section 9 by the central government. If even central government want any person to take any kind of approval, permission or registration under this act, they can demand that person to get it done, but they can do it only for the national interest or for larger public interest, or for any interest which is related with what? National interest. This section 9 is very important. Remember, section 3 which is talking about prohibition on accepting foreign contributions, section 4 which is related with exclusions or exceptions, section 5 that is organization of political nature, section 6 that is foreign contribution, and section 9 which is dealing with what? Power of central government is very very important. Okay, got my point, students? If you are going to get foreign contribution for the very first time, okay, you have to take the permission, but if it is going to be a regular task, you have to go for registration. So two things are there. If you are going to get it for one time only, you need to take permission. If you are going to get it regularly, you have to take a registration. Trust, society or section 8 company can go for registration. They must be for minimum existence of 3 years. Okay, they have spent minimum 15 lakh rupees over last 3 years over their specified objective, then only they can register, they can get the permission or they can register under this act. Is it clear? For registration, if you are willing to get a foreign contribution, you can accept it, but you require, for frequent foreign contribution, it does require registration. You must be a society, trust or a section 8 company. You should be in existence for minimum period of 3 years, and over a period of 3 years you must have spent 15 lakh rupees on your principal object, then only you will be eligible to register under this act. Okay, this 15 lakh include capital expenditure as well. Got my point? But if you are willing to take just one time of permission, not registration, then in that case also you should be society, trust or section 5 section 8 company, that is NPO. You have to bring commitment letter from a foreign source who is willing to give you a kind of such contribution, one time contribution. And the chief functionary of both the organization should be independent, and majority member of both the organization should be independent. Although it is a technical point, but remember that two things are that the chief functionary of Indian recipient organization should not be the chief functionary of that organization and should not be related to the chief functionary of that organization. So the chief functionary should be independent, and minimum 75% members should be independent of both the organization. Then only you will be eligible to accept what? Foreign contribution from, one time foreign contribution from them. Is it clear? Got my point? Permission granted to you or registration granted to you can be terminated if you have falsified information, if you have done something which is contradictory to the sovereignty, integrity of nation and all. But a reasonable opportunity of being heard will be provided if an action against you will be taken by the government. Okay, if there is certain doubts on your certificate, then for 180 days it can be suspended. That is temporary suspension of your registration. For the period of 180 days you cannot utilize your foreign contribution until unless matter has been sorted out. Cancellation is also permissible on certain ground, but reasonable opportunity of being heard will be provided to you, right? And if your license has been terminated under this act, for the period of next 3 years you cannot demand for FICRA registration. Got my point? You have to maintain it in a separate bank account. Certificate remains valid for a period of 5 years, and within 6 months before the expiry you have to get it renewed, otherwise late fees will be applicable. You can surrender this certificate as well if you are not willing to take any kind of contribution. You means you just you have discontinued that contribution. You have to open a fikra account with State Bank of India Delhi branch. There is an imprisonment of 1 year, 5 year, 3 year and 6 months in case of contravention of this act. Only investigating officer appointed by central government can take action against you. Compounding is possible. I have taught you compounding in FEMA, and the same rule will be applicable. Gap of minimum 3 years. Only unintentional matters can be compounded or settled for. If you are subject matter of imprisonment, compounding is not possible. If the compounding or settlement has been done, you have to pay the minimum compounding charges and you will be out from that offense. Is it clear? So done with what, students? Done with one more chapter, that is FCRA, Foreign Contribution and Regulation Act, right? Done with 5 chapters of what? ECIPL, right? Hey students, continuing with ECIPL, if you can remember, we have done with FEMA, quick revision, which is important chapter. We have done with FDI, we have done with ODI, we have done with external commercial borrowing, and I guess even we have done with FICRA, right? Foreign Contribution Regulation Act, right? Now in today's lecture, I am trying to finish money laundering, fugitive economic offense and Benami Property Act. Okay, so starting with 8th, money laundering. So have you ever heard about money laundering, students? What is money laundering exactly? Whenever we do talk about money laundering, we do talk about converting the money that has been earned from illegal sources and showing it over the paper that it is being earned from legal sources. So it is nothing more than converting the illegal money into legal money, or converting the black money into white money is known as what? Money laundering. Is it clear? And when it comes to money laundering, being the part of FATF, that is Financial Action Task Force, India as a country has promulgated a law dealing with money laundering, that is called Money Laundering Act 2002. And along with that, whenever there would be any amendment in Money Laundering Act, understand that this is because of the pressure, this is because of the guideline, this is because of the recommendation given by FATF, because we are the part of Financial Action Task Force. Is it clear, students? Just a minute. Oh, I'm so sorry. Just a minute. We are starting with Money Laundering Act. Okay. Only few questions are important when it comes to Money Laundering Act. Remember, when it comes to Money Laundering Act, Fugitive Economic Offender Act and Benami Property Act, we can give on an average weightage of 5 to 10 marks, 5 to 10 marks to this chapters. Okay. There is some problem. And all the 3 laws will talk about attachment of property, confiscation of property, because these are the severe economic offenses. Which kind of offenses, as students? It is severe economic offenses, because all the terrorism financing, all the crime required financial support, right? So as it does require financial support, it is being provided through money laundering only, right? By what you are doing, you are converting your black money into white money in order to use it for some illegal activities, right? This is the most important question of this chapter. What all are the three steps of money laundering? Remember, when it comes to money laundering, it is an economic offense, and generally it is a cross-border offenses where the money is coming from outside India. When the person who is a resident outside India is trying to get the illegal money introduced to the Indian economy, that introduction phase is known as placement. Means they are using the financial intermediaries because hard cash they cannot come up with, right? Over here in India, they'll be caught in customs, right? So logically, what they are doing, they are using bank, public financial institutions, stock brokers in a way that it shows that they are getting into an illegitimate transaction. So the bank and PFIs and capital market intermediaries are the biggest victim of money laundering. So if they are, by using the financial system of this nation, are entering into the economy, that is called the placement phase. Once they'll place their money, illegal money over here in an economy, in order to create a distance of it from them, that is from illegal sources, they'll get into multiple transactions in those money or those amount that has been deposited in bank or invested in demat account. Multiple transactions, getting into multiple transaction would lead to layering, and once the layering has been done and an appropriate distance is being created between the source and the money deposited in the account, they'll integrate that money so that they can make big economic investment in the nation and can acquire economic control. That is called integration. So there are three stages of money laundering: placement, layering, integration. Placement is introduction of illegal money to the Indian economy. Layering is getting into multiple transactions to create distance. Integration is summing up to create big economic power, right? It will adversely affect the national fabric, because you can see Pakistan, they are the victim of money laundering. They took money from illegal sources. Now the government is not controlling the nation, those people are going to control the nation. And logically, yeah, if they are putting money in your economy, they will create a bad influence in your economy, right? Your economy. And I can say that Pakistan is a kind of vulnerable economy which requires funding, because they are having an attitude of revenge, right? So the government has came up with Prevention of Money Laundering Act, where severe punishment would be definitely there, because it's a severe criminal offense, right? Along with that, all the property that is being associated with money laundering is going to be confiscated. Okay, confiscated. It will be taken over from him and is going to be deposited in governmental treasury. Okay. And it has been inspired from what, beta? I told you FATF recommendation. What is regulated entity? Over here we know very well when who is going to be the victim of this money laundering phase would be the scheduled commercial banks, right? Regional rural bank, local area bank, cooperative bank, all PFIs, right? Payment and settlement system providers. So they are primarily be the regulated entity over here in this act, and they have to maintain proper records and transactions, and they have to submit certain reports with the Reserve Bank of India. They need to have a strict customer acceptance policy, customer identification policy, monitoring of transaction policy, and risk assessment policy as recommended by Reserve Bank of India. So this question institute has asked, what do you mean by regulated entity? You have to prepare it. Okay. Reserve Bank of India has developed a financial intelligence unit, which is nothing more than a kind of CBI for economic offenses. Every quarter, the bank, PFI, and regulated entity has to file two reports with them: CTR and STR. CTR is cash transaction report, where the value of the transaction in client account is more than 10 lakh. Records of all such transactions need to be reported to FIU, that is Financial Intelligence Unit. And if there is suspicious transaction going on in the account of the client of the bank or PFI, that suspicious transaction report has to be filed with the FIU. Directorate of Enforcement has been established under this act in order to investigate the matter related with money laundering. Okay. And your assets can be freeze under UPA if you are being involved in UPA. The UPA is a severe law, that is Unlawful Activities Act 1967, which is anti-national activities. Okay, freezing of asset means your assets are going to be taken over by the government, and it is going to be, you will have no right to transfer your asset. FATF पे short note you guys can prepare. It is nothing more than the body which is fighting against, terrorism financing and money laundering. Okay, money laundering and terrorist financing. If you're engaging in any kind of process of money laundering, concealing, possessing, acquiring, using any money which is a part of money laundering, it will be treated as you are the offender of money laundering. Minimum term of imprisonment is 3 years, maximum term of imprisonment is 7 years, and if you are involved in narcotic drugs, the imprisonment would be of 10 years. Is it clear? This is important. They will have, if a case has been filed against you about money laundering, your property is subject matter of attachment. Attachment means it is a temporary attachment for a period of 180 days that can be extended by the competent court. During that period, you can use your property, possession remains with you, but you cannot transfer or create any right over your property. Remember, attachment is temporary, period of attachment is 180 days. It can be extended by the competent court. Investigation once started against you of the money laundering, your properties are subject matter of attachment when it is being treated as this property has been created out of the money laundering money. And after attachment, if the offense will be proved, it is subject matter of what beta? Confiscation. Is it clear? Once the property has been confiscated, it will be vested on government. Now no one can take it back from the government. Every bank and PFI has to maintain all their records for a period of 5 years. Is it clear? Of all the clients and transactions, in order to make sure that they would not become the victim of what? Money laundering. Is it clear? During the investigation, your records can be subject matter of seizure and they can be seized for a period of 180 days. If you're not happy with the order of competent court under this act, although the activities under this act are cognizable and non-bailable. Cognizable means police officer can arrest you without warrant, that is called cognizable offense, and non-bailable means you are not going to get the bail. But if you are unsatisfied, you can prefer an appeal to the appellate tribunal under this act. Okay. Action under this act will only be taken once the police complaint has been filed, or police investigation report has been filed with the competent court. We are into a part of foreign arrangement in order to globally fight against money laundering. Freezing of asset, I taught you that if you are being involved in illegal activities, which is anti-national activity, you would be subject matter of UPA. Two cases will simultaneously go on against you. One would be of money laundering, because money laundering is also a kind of anti-national activity. Is it clear? So even case can be registered under UPA. Done, students. We have done with money laundering. It took hardly 10 minutes. What questions you guys have to focus on? Go ahead with first question, that is stages of money laundering. Go ahead with the second question, that is first question is money laundering, that is stages of money laundering. Go ahead with FATF. Go ahead with attachment and confiscation of property. Go ahead with regulated entities and KYC norms. That 4 things they have to maintain policy for, that is customer acquisition, customer identification, monitoring of transaction related policies, and KYC norms. And after that, go ahead with UPACA question. Okay, that is important. Is it clear, students? FATF you can do. Okay, done with money laundering. It took hardly 12-13 minutes to finish money laundering. Is it clear? Now starting with the another topic, that is chapter number 9, that is fugitive economic offender. What is fugitive economic offender? It is nothing more than the person who run away from India, who has committed an economic offense where the value of the economic offenses is 100 crore rupees or more. So any individual can only be classified as a fugitive economic offender because only individual can run away from India, right? So if you are committed any default by taking a loan where the value of the loan is 100 crore or more, so if you have made any default of 100 crore rupees or more, and you have already run away from India and you are not willing to come back to India to face criminal prosecution, you know, Nirav Modi, Vijay Mallya, or all what? Fugitive economic offender. You have created a very big loss to the Indian economy, so you are subject matter of what? Criminal action, right? because it is ultimately harming or injuring whom? The Indian economy, right? Bank and PFI are the major, victim of these activities of both money laundering and fugitive economic offender, right? A special law it has been passed in which the government has been provided with take a fast track action against the fugitive economic offender, get into a contract with the contracting country to sort it out that matter, and along with that, attachment and confiscation power has been given to the government to any property belonging to the fugitive economic offender and their relatives. Okay, so this act has been passed in order to provide for certain measures strictly to be taken against fugitive economic offender, right? I told you, you have committed scheduled offense, warrant of arrest has been issued against you, and you left India and not willing to come back to India, right? And the value of the offense involved is 100 crore rupees, right? If you have committed any offense under IPC, Negotiable Instrument Act, Reserve Bank of India Act, Custom Act, Benami Property Act, Prevention of Corruption Act, where the value of the transaction is 100 CR or more, and a warrant of arrest has been issued against you, and you are not willing to come back to India, right? Only whether it is money laundering or it is fugitive economic offense action, investigation action would be taken up by the director. They will prepare the report, they will submit the report with the special court, then the special court will take action. Remember here, whenever you have committed any offense, you will file, someone will file FIR against you, the police officer will investigate your matter, after that they will submit the report with the criminal court, then the criminal court can take cognizance of the case. So complaint would always be filed, complaint with the court will always be filed by the director or the police officer in the criminal cases. Okay, so in his application he has to make sure he'll satisfy the court what are the reason he is treating you as a fugitive economic offender, what all properties are belonging to you, which is proceeds of crime, information about your whereabouts, information about your Benami properties and all. These all documents will be submitted by the director, and accordingly the special court will take action. Special court will issue a notice of 6 weeks to you, stating that you have to present to the court within the period of 2 weeks from the date of serving of the notice. Okay, contracting state will also be forwarded with the notice that please make sure that the concerned contracting state is a foreign country where he has been settled. So to submit the reply, contracting state will also be served with the notice of 2 weeks that uh, he has been summoned. Okay, electronic service of notice is permissible, there is no problem on that. You can present your case directly by yourself, or you can present your case through your attorney. You know that very well, Vijay Mallya never came back to India, right? He is presenting his case only through his attorney, right? Once a person has been declared as a fugitive economic offender, right, it will be published, and you would have all the right to file an appeal against the order within 90 days. And this is a very important question, disallowance of civil claims. This has been asked by the institute. Remember, once you have been declared as a fugitive economic offender, you would have no right to file any civil case in Indian court. Means if you are having certain dues to be taken from anyone, it will be recovered by the government and settle down the dues. You would have no right to file any civil case over here in India in for recovery of your dues. If you are individual, you cannot file. If it belongs to a company or firm, they cannot even file any civil case. So that is disallowance of civil claim is very, very important question. Okay, attachment of property will be there. Property will be attached by the director, but he has to submit the attachment detail with the special court. A special court can attach your property for up to 180 days, and you know very well that during attachment you can use the property, but you cannot transfer the property, right? Power of survey, the officer can search, seize and conduct survey in your properties or about your whereabout. You have to prove why he is a fugitive economic offender, those who are filing the claim. If you are unhappy with any order of the special court, you may prefer an appeal within the period of 30 days to the High Court. Okay, but maximum up to 90 days. Is it clear? And this act is having overriding effect over all the other laws that has been applicable over here in India. So just giving you a quick review, if you are a fugitive economic offender, you will be treated as fugitive economic offender. If you have committed, an individual can only be classified as a fugitive economic offender if you have committed any offence that has been laid down in the schedule 1 to this act, where the value of the default is 100 crore or more, and a warrant of arrest has been issued against you, means a criminal action has already been initiated against you and you are not willing to come back to India, right? The case can only be filed by the investigating officer, that is called Director General, with the special court. He can even attach your property for the period of 30 days, but within 30 days he has to make an application to the court so that he can get extension of attachment of property up to 180 days, right? Once an application has been filed, along with application he'll file your details about your whereabout, reason to satisfy the court why you are to be classified as a fugitive economic offender, list of all your property which is proceeds of crime, and list of all your binami properties, and list of all property which is held by your relatives, right? Once the special court will get the application, it will serve a notice of up to 6 weeks to the concerned person. He has to come up with the reply. This 6 weeks can be extended by 1 week if you are being presented your case through attorney. Now further they are saying that even contracting state where you are being settled, that is the country, even they will be provided with the notice, serving of the notice within the period of 2 weeks, right? Now they are saying that once a court will declare you as a fugitive economic offender, you will have right to file an appeal within the period of 90 days, right? Then you would have no, your properties are going to be attached and confiscated, and you would have no right to file any civil claim over here in India, right? Right, students, they can conduct surveys, search and seizure, even they can retain your records, right? Right, students, if you are anybody who is claiming that you are a fugitive economic offender, he has to prove the facts, right? If you are unhappy with the order of the special court, you can prefer an appeal to the High Court within the period of 30 days, that can be extended up to 90 days. And as a special court has already been established under this act, ordinary court would have no right to file, right to accept the cases under this act. And if there would be any clash between ordinary law or fugitive economic offences, this act is going to prevail, right? Done, students. We have done with two topics. One is fugitive economic offender, and the second one is what? We have done with second one, that is money laundering act, right? Right, students. Let's go ahead with the competition act. So students, have you this is going to be the marathon topic, so I'm going to cover all the important topic when it comes to competition act. So whenever we are talking about competition, remember, when it comes to Indian economy, it can be classified into two parts. First one is regulated segment, like when it comes to petroleum, when it comes to gas, the prices of petroleum and gas are going to be determined by the government, right? There would be a public policy, there would be governmental intervention when it comes to determination of the prices of petrol. The government is going to determine the price of the petrol. So we could say that these entire section of regulated commodities, the government will take care of the interest of the public in large, right? Although whether they are taking or not, it is a different angle. But when it comes to IRCTC ticket prices, who is the price regulator of those tickets are government, right? But when it comes to other products, unregulated products or services, the prices are going to be determined by the market. So when the prices are going to be determined by the market, there is a very logical thing that market will try to exploit the consumer. So in order to make sure that there should be a free and fair competition between the competitors in the industry, Competition Act 2002 is being applicable. It is not trying to regulate the competition, because competition cannot be regulated. It need to be free and fair, right? In order to make sure that all factors that will directly or indirectly affect the fairness of the competition in the marketplace of the unregulated commodities, the Competition Act 2002 is being applicable. Under this act, there are three important provisions. One is anti-competitive agreement. that has been defined in section 3. Second one is abuse of dominant position, that has been defined in section 4. And the third one is combination, that has been defined in section 5 and regulated by section 6. Okay, so if you'll go through with the Competition Act, you will get to know that there are certain definitions. So I'll start my explanation with the definitions, and accordingly I'll go ahead with the other aspects. Okay, so the entire chapter is going to be divided into 5 parts. In the first part, I'm going to cover all the definition quickly. Then I'll cover anti-competitive agreement. Then I'll cover abuse of dominant position. Then I'll cover combination, and at last I'll cover the miscellaneous matters. Okay, so let's go ahead with the first part of the chapter. That is what is enterprise. So when it comes to economic law, we are not just talking about company, we talk about every business organization, be it partnership firm, proprietorship firm, companies, limited liability partnership firm, even governmental enterprises, even LIC, that is called Life Insurance Corporation, GIC, that is called General Insurance Corporation, ONGC, that is Oil and Natural Gas Corporation. They are being owned by the government, but they are into economic activities. They are not into sovereign government function, right? They are not like Ministry of Corporate Affairs. They are not like, you know, any governmental department which is just involved in providing public service, that is called sovereign functions. So even governmental enterprises involving into economic activity will come under the definition of enterprises, and if they are getting into any kind of anti-competitive activity, they are subject matter of action under this act. So enterprise term has been widely defined. Even it includes department of government which is being involved in economic activity. Only that department or institution of government will be excluded from the definition of enterprise which are exclusively involved in what? Sovereign functions. Got my point? Sovereign functions. Now when it comes to an agreement, the term agreement has been defined in context of anti-competitive agreement. What is exactly agreement over here? See, if you are getting into any kind of activity which is prohibited over here in India, you are not going to get it formally, right? So agreement over here means and includes any written agreement. It includes even oral arrangement between parties or enterprises. Even it includes act in concert, means when they are not under any written or oral arrangement, but their activities showing that somewhere and somehow they are acting in concert, means they are acting in combination, means they are acting uniformly, right? Means they are having a kind of understanding between them. So that is called what? An agreement. So agreement can be oral, agreement can be written, agreement can be an act in concert or understanding. Is it clear? Got my point, students? Now the third definition they have defined is consumer. When it comes to the consumer, under Consumer Protection Act, any person who bought the goods or availed the services for consideration would come under the definition of customer if he bought or availed the services for two purposes: for self-usage, right? Self-usage or usage of his relative, right? Or for the purpose of self-usage or usage of their relative, or for the purpose of earning their livelihood, right? So whenever we are talking about consumer, we are just talking about consuming consumer, right? We are just talking about the person who is ultimately going to consume the goods and services, right? But when it comes to Competition Act, under Competition Act, consumer is widely defined. It includes any person who bought the goods or availed the services for consideration, who bought and availed bought the goods or availed the services for resale, for commercial purpose, even for personal purpose, or even to earn his livelihood. So even here, if you are buying the goods for reselling, or if you are buying the goods for commercial, large commercial purpose, you would come under the definition of consumer. So that is the difference. Okay. For example, when it comes to, if I am buying any particular ACs, like for my commercial establishment, I would not get any relief under Consumer Protection Act. If I am unhappy with those ACs, I would have a right to file a civil case against the supplier, but I cannot file case as a consumer under Consumer Protection Councils, right? But if I bought something for earning my livelihood, like I bought a taxi in order to run it in Ola, right, to earn my livelihood, I would come under the definition of consumer, and I'll get consumer relief under Consumer Protection Act. Got my point? But here the term consumer includes, it matters that you bought the goods or availed the services for consideration for whatever purpose you bought it. If you are the buyer of the goods, buyer would come under the definition of consumer. Is it clear? So buyer will be, every buyer will be consumer. It doesn't matter for what purpose they are buying the goods or availing the services. The next definition is cartel, which is very important, students. When it comes to cartel is nothing more than association of person. Cartel is nothing more than association of person or body of individual, which is nothing more than a group of producer, distributor, manufacturers, service providers, suppliers, or trader. Whatever parties are being involved in the supply chain, it may be manufacturer, producer, distributor, wholesaler, retailer, service provider, right? So whomsoever are being the part of the supply chain, if they are getting into an agreement, arrangement, understanding, act in concert, by virtue of which they are trying to determine the price, quantity, quality, potency, or purity of the goods, means they are trying to determine something that should be logically determined by the market forces, that is called demand and supply. Okay, whenever it comes to the quality of the goods, the technical development of the product, when it comes to the prices of the goods, when it comes to the terms and condition on selling the goods, everything should be determined according to the market forces, right? That is demand and supply. But if they are getting into any kind of arrangement, agreement, and they have formed an association in order to exploit market, in order to determine everything that need to be, in order to determine something that need to be determined by the market forces, they would come under the definition of cartel. And cartelization is actionable under this act. Even a criminal action can be taken against cartel. So if you have seen any industry, like we can say that telecommunication industry somewhere and somehow is showing cartelization. See, because of Anant Ambani's marriage, you have seen that Jio has increased their package values, right, for recharge, right? Simultaneously, the Vodafone Idea and Airtel has came out with their new packages, right? So it indicates somewhere and somehow they are acting in concert, they are acting in association, they are acting, to support each other. We can say that it is an indication of what, cartelization. So you can file a complaint against them, and complaint would definitely must have been filed against them under this act. Okay. So when it comes to cartelization is punishable offense over here in this act, and further they are saying that there are two categories of cartelization: international, national. If it is a national cartelization, it is going to be actionable over here in India. But when it comes to international cartelization, if it is an export cartelization, means you are exporting from India and you are trying to exploit other people located outside India, it is not going to be regulated by this act. It is going to be regulated by the law of that nation. But if it is import cartel is going to impact Indian economy, so it is going to be regulated by Indian government, that is called Consumer Competition Act. Now, where you will find cartelization, where there would be few competitors like oligopoly market, duopoly market. When there are very few supplier of any particular goods and services, there would be a cartelization, means in high concentration industries there may be a cartelization, like telecommunication industries having very less players, right? Film industries having very less players, so you can find cartelization over there. When there is high entry and exit barrier, whether it is regulatory barrier or whatsoever, if there would be high entry barrier, there would be very less player, there is a possibility of having cartelization. If the production cost of the product is quite similar, there would be a possibility of having cartelization. If the industry is having excess capacity, there would be chances of having cartelization. If the consumer is totally dependent on the goods like milk production, there may be a cartelization. Is it clear? Got my point? So we have done with first part of the chapter, that is definitions. In definition, we have done with definition of agreement, we have done with definition of consumer, we have done with the definition of cartel, and we have done with the definition of enterprise. So 4 definitions we have done. These are important definitions. Got my point, students? Now going ahead with the another part, that is anti-competitive agreement. Going ahead with the another part, that is anti-competitive agreement. Now cartel is a kind of an anti-competitive agreement. Anti-competitive agreement is again nothing more than an agreement. The association knows as cartel, and the agreement between them is known as what? Anti-competitive agreement. Now whenever we are talking about the term anti-competitive agreement, anti-competitive agreement is nothing more than a kind of agreement, arrangement, understanding, act and concert executed between manufacturer, distributor, supplier, producer, retailers, wholesalers, or you know between the service provider, that by virtue of their agreement or understanding or act in concert is trying to determine same the price, quantity, quality, potency, purity of the goods and services in which they are dealing. And here there is a condition: if they are getting into that arrangement, it is likely to cause, or it is causing an appreciable adverse effect in competition over relevant market. So first let me teach you the definition of relevant market, students, so that you will have clear idea, because whenever we are talking about non-permissible activities under this act, it is always associated with the relevant market. So there are two category of commodities you will find in the market. A commodity having national market means branded commodities, like if I am going to buy a dairy milk chocolate, it is going to cost me 10 rupees over here in Chennai, 10 rupees over there in Mumbai, 10 rupees over there in Nagpur, right? So can I say that the quality, quantity, potency, purity and price of the dairy milk is not going to be changed irrespective of in whatever territory they are being selling out, right? So I can say that dairy milk, or Maggi or Parle G is having what relevant product market. They are having what relevant product market, because the terms and condition of their sale are not going to be changed according to the geography. But when it comes to milk over here is costing me around 60 rupees liter, but in Mumbai it is costing me 55 rupees liter. So can I say that when it comes to the goods of when it comes to the market of services, like if I'm going for a haircut over here in Chennai, I'm getting it at 200 rupees, but in Mumbai I'm getting it in 100 rupees, right? So the service market and market of the perishable goods are having geographical market. They do not have any kind of national market. They are not into product market. Their competition ka conditions are going to be varied from geography to geography. Their terms of sales will differ from geography to geography. Their quality, quantity, potency, purity and price is going to be changed geography wise. So they are having geographical market. Okay. So there are two market: relevant product market, market of branded goods, or market of durable goods, right? When it comes to relevant geographical market, market of service, and market of service and market of perishable goods. Okay. So if you are filing a case against any person that the people are involved in anti-competitive agreement or abuse of dominant position or combination, you have to mention that your complaint is related with which market. It is related with relevant geographical market, or it is related with relevant product market. Got my point, students? Like telecommunication services are having almost relevant product market, so you will file a complaint of anti-competitive agreement in terms of relevant product market. Got my point, students? Is it clear? So whenever you are filing a case of anti-competitive agreement or matter of anti-competitive agreement to be determined by Competition Commission of India, you have to mention that with which market it is being connected. It is being connected with geographical market, or it is being connected with the product market. Got my point? So anti-competitive agreement is something that is trying to determine something that need to be determined by the market forces, right? The association will call cartelization. The arrangement between them will called as anti-competitive agreement. Now they are saying that, but anti-competitive agreement ka suit, if you are filing a case of anti-competitive agreement with Competition Commission of India, you have to prove in front of the Competition Commission of India that how your activities is causing or likely to cause an appreciable adverse effect in the competition. See here, this act is running behind promoting free and fair competition. If you will get into that kind of agreement, it will dilute competition from the market. So if the dilution is causing impactful effect over the competition, it will treat it as what it is causing an appreciable adverse effect in the competition. And if it is not causing any kind of impact or significant impact or negligible impact over the competition, you would say that it is not causing an appreciable adverse effect in competition. So appreciable adverse effect in competition is nothing adverse to the competition, means it will make the competition unfair, it will make the competition exploitative, it will make the competition not at all available fairly in the marketplace. Got my point? Relevant geographical market or relevant product market. So if you will get into horizontal agreement, okay, like if you are trying to limit the quantity of production, if the suppose in relevant geographical market there are 4 milk suppliers, they are getting into an agreement by virtue of that they are determining how much quantity of the milk should be delivered or produced in a day, so that the prices of the milk would become high because of low supply. Okay, so if they are determining the quantity of supply, if they are determining the prices of the supply, if they are determining by virtue of their agreement market share, that you are going to supply the milk in this locality, I am going to supply milk in that locality, we are not going to clash in two localities. Okay, so if you are getting into such kind of agreement, five agreements are there, they are called horizontal agreements. Okay, and horizontal agreement will be classified as what, beta? Horizontal agreement will be classified as what? Anti-competitive agreement. Horizontal agreements are to be treated as anti-competitive agreement. You need not to prove their appreciable adverse effect in front of the Competition Commission of India. It will be treated as they are causing appreciable adverse effect without any doubt. Price fixing agreement, market share agreement, price fixing agreement, market share agreement, quantity determination agreement, or bid rigging or collusive bidding agreement. What? Bid rigging and collusive bidding agreement. Got my point, students? Now what is bid rigging and collusive bidding, beta? Still now the government and many companies are inviting bid or inviting quotation before accepting the supplier. So if government is inviting tenders, they are expecting most competitive prices by the participants of the tenders, right? The bidders. Now if the bidder will get into an agreement by virtue of which they are determining the terms of bidding, they are deciding who is going to cast the highest bid, who is going to cast the lowest bid, we are not going to cast bid against each other. These kind of arrangement will ultimately exploit the basic idea of inviting bidding. So it is known as bid rigging. So bid rigging arrangements are also deemed anti-competitive agreement because they are horizontal agreement. Got my point? And a horizontal agreement is nothing more than an agreement that has been executed between the firms of one industry which are involved in the same services or same product. For example, if I would talk about film industry, I would talk about Bollywood. In Bollywood, Dharma Production and Balaji Telefilms both are doing the same thing, that is called content creation. So if they are getting into agreement, that is called what? Horizontal agreement. Is it clear? Now when it comes to vertical agreement is nothing more than an agreement like tie-in agreement, in which you are selling one goods by attaching the another goods with it. Like if I am going and buying for an LPG connection, they are asking me that, Rahul, you have to buy the cylinder as well as you have to buy the stove from us. So they are selling me stoves along with LPG connection, that is called tie-in arrangement. Okay, if I'm buying the vehicle from a supplier, they are saying that along with buying the vehicle, you have to buy the service coupon of this vehicle from us, and servicing should be done by our authorized showroom only or authorized service center only. That is a tie-in agreement. So tie-in agreement may or may not be an anti-competitive agreement. If you are alleging that tie-in agreements are anti-competitive, you have to prove in front of the CCI, that is called Competition Commission of India, how they are causing or likely to cause an appreciable adverse effect. Same like exclusive distribution agreement. If Domino's are giving you a franchisee and asking you that you can sell only in this area, so that is called exclusive distribution agreement. They are also not deemed anti-competitive. You have to prove exclusive supply. In licensing, in franchising, there is an exclusive supply agreement that you can sell out only our goods, you cannot sell out any other good. Okay, so even that is not an anti-competitive. Like resale price maintenance, refusal to deal, these agreements are vertical agreements, and vertical agreements are not to be treated as what? Vertical agreements are not to be treated as what, students? Anti-competitive agreement, until and unless you will be capable enough to prove in front of the CCI that how they are causing or appreciable causing or likely to cause an appreciable adverse effect in the marketplace, that is relevant geographical market or relevant product market. Is it clear? Bid rigging, collusive bidding is very important question. I have given you a quick concept. Vertical agreements are very important. Horizontal agreement I taught you, right? Now they are saying that certain agreement, although would carry an anti-competitive clause, but not going to be regulated by this act. One is export cartelization. Export cartelization would not impact Indian relevant market, it would affect the relevant market located outside India. So it is not going to be regulated by our law, it is going to be regulated by their law. And second, if you are getting into anti-competitive agreement to protect intellectual property right, like patent, trademark, copyright, it would not lead to what? Anti-competitive agreement at all. Is it clear? Got my point, students? If you are creating entry barrier for the new entrant, if you are getting into agreement and you are squeezing out the competitors from the market, or if you are trying to foreclose the competition by reducing the number of competitors in the market, that will be treated as what? Appreciable adverse effect. Is it clear? If you got into anti-competitive agreement, investigation about anti-competitive agreement can be initiated by CCI even without complaint. They can take suo motu action against you. Investigation can be started, or investigation can be started if consumer association or central government or state government is making reference to the CCI that please investigate this matter. This is a subject matter of what? Anti-competitive agreement. Is it clear? Done my point? Horizontal agreement I taught you. Vertical agreement is like Netflix is into content distribution, Dharma production is into content creation. If content, but both belongs to the same industry, that is entertainment industry. So if Dharma production is getting into agreement with Netflix, that will called vertical agreement. Okay, but in case of vertical agreement, you have to prove how it is causing an appreciable adverse effect in relevant geographical or a product market. But in case of horizontal agreement, it is deemed to cause an appreciable adverse effect in relevant market. Got my point, students? So we have done with two part of Competition Act. First part is definitions, and second part is anti-competitive agreement. In anti-competitive agreement, three questions are very important. What is anti-competitive agreement, and what is vertical and horizontal agreement? Second, what is appreciable adverse effect? And the third one is what, beta? Third one is bid rigging and collusive bidding. Okay. Now starting with abuse of dominant position. So try and understand what is dominant position. So whenever we are talking about dominant position, it is nothing more than the position of power, right? Can I say that when it comes to Philips, they are into a dominant position when it comes to air fryer or home appliance market, right? Can I say that LG is in a dominant position when it comes to home appliances, right? I can say that, right? So Anchor is in a dominant position when it comes to fixtures like the electricity and other tube lights, bulb, right? These things, Anchor is into a dominant position. So whenever we are talking about dominant position, it is a position of a power which is being occupied by a firm in a particular industry. It's near to monopoly, or they are having the huge market share or huge economic power with them, right? So dominance is something that has been acquired by you because of your consistent performance in terms of the quality or the prices, right? Like Parle G has built a dominant position because of consistent quality they have maintained with the cheap possible prices, right? So the law is not stopping you to use your dominant position, but they are stopping you under section 4 to abuse your dominant position in relevant geographical market or relevant product market. Okay, so there are certain factors that need to be considered in order to determine the dominant position, but the principal factor is like if you are into influential position, means if you are making certain changes in your supply terms, other firms are following you in the industry, and if other firms are changing their terms, you are not following them. So people are following you because you are an influencer, but you are not following the people because they are not influencer for you. Okay, so that position is known as what? You are working independently in the industry without getting affected by your competitors, but your competitors are affecting from you. You are in a dominant position. That is the legal aspect. Okay, even when it comes to Geo, earlier when they enter into the market, they are not getting influenced by other players in the market, so they will be classified as a dominant player. Okay, then market share doesn't matter. But the true indicator of dominance would be market share, the resources available with the firm, the size of the firm, the composition of the industry, that how many competitors are there, dependency of the consumer over your product. So many things will determine your dominant position. Is it clear? So if you are into a dominant position, it is advised that you should not abuse your dominant position. So if you are treating your customer differently, you are putting different terms and condition on sale of same goods and services to different customers, means you are doing discrimination between customers, or you are trying to limit the production quantity of the goods in which you are dealing in, if you are not allowing the new competitor to enter into the market, or you are involved in predatory pricing. Now what is predatory pricing? That is selling below the cost. So if you are involved in the practices of selling below the cost with an intention to squeeze out competitors from the market, so that is called predatory pricing. Two elements are there of predatory pricing. One is charging below the cost plus with an intention to squeeze out competitors, okay, or eliminate competitors from the market. So it is known as abuse of dominant position. So four things are abusing dominant position: discriminatory conditions between buyers, second is limiting the competitions from the market, denial of market access to the newcomers, or predatory pricing. It will be treated as deemed abuse of dominant position. And if you are being caught with deemed abuse of dominant position, CCI can suo motu investigate against you, or they can investigate against you by getting a reference from central or state government, or by consumer association, right? I have put certain example, but at this point of time I don't think there is a logic to proceed about it, okay. Relevant geographic, and all the things need to be connected with what? Relevant geographical market or relevant product market, right? Got my point, students? So done with the second part, that is abuse of dominant position 2, okay. Now what kind of order that can be passed by CCI under section 27 if they found any enterprise to involved in abuse of dominant position or anti-competitive agreement? They can pass an order of cease and desist, that don't continue this kind of activities further and stop it right away. That is called cease and desist. Penalty can be imposed which will be equivalent to 10% of your average annual turnover of last 3 years, okay. This much amount of penalty can be imposed upon you. They can ask you to modify your agreement, okay, or any such order they find it better, they can pass that kind of order. So they can pass cease and desist order, they can pass imposition of penalty which will be equivalent to 10% of the last year average turnover, right, or 3 times of the profit made out of such kind of agreement or abuse of dominant position. They can pass an order of modification of your agreement. They can pass any other compliance or other direct discretionary order as they think fit, okay. Done, students? So we have done with what? We have done with another part of this chapter. Now going ahead with third part of this chapter, that is called combination. So whenever we are talking about combination, we do talk about, whenever we are talking about combination, we are talking about amalgamation, merger, acquisition of shares, voting right, control or assets of one enterprise by another enterprise. So if two enterprises by virtue of amalgamation, merger or acquisition are merging with each other, that is called combination. Such combination may create huge impact in the market. If two Indian individual enterprises are merging together and their asset ka total would become 2000 crore or turnover ka total would become 6000 crore, or if two Indian group enterprise or conglomerates are merging and their asset ka total is 8000 crore rupees or turnover ka total is rupees 24000 crore rupees, these are the limits. Now if one Indian individual enterprise or another non-Indian enterprise are merging and their asset ka total is 1 billion or 3 billion US dollar, asset or turnover is correspondingly 1 billion or 3 billion US dollar, or if they are group enterprise, their asset ka total is 4 billion US dollar or turnover ka total is 12 billion US dollar, okay. Four things are there. If they are Indian individual enterprise, that is 2000 and 6000 crore. If they are group Indian enterprise, 6000, 8000 and 24,000 crore rupees, right? If they are Indian as well as one is overseas, and their asset ka total is individual के case में 1 billion or 3 billion or 4 billion or 12 billion in case of group enterprise, right? Out of which minimum Indian share should be 1000 crore in assets or 3000 crore in turnover. Okay, so they will be classified as an combination, and this combination is not possible. This amalgamation merger is not at all possible. You cannot go ahead with a Companies Act or MC approval or NCLT approval. You have to first take the approval of CCI, that is called Competition Commission of India. Okay, so they have defined the term combination. So I told you combination can be in the form of amalgamation, merger or acquisition. If it is creating such kind of value, it will come under the definition of combination if they are reaching the threshold limit. And if they are reaching the threshold limit, what you'll have to do, you'll have to take the approval of CCI before proceeding further with combination. Is it clear? Now you'll have to make an application with CCI. Once you'll make an application, it can be even horizontal and vertical, the same meaning. Okay, if you'll make an application, you have to file the report or application with the CCI within 30 days from the date of board ka approval or by the date of getting into a primary agreement for the same, and you have to wait for minimum 210 days for the approval of CCI. If within the period of 210 days CCI would not come out with any kind of, CCI would not come out with any kind of recommendation or changes, it will be treated as you got the deemed approval. Now you can proceed with further compliance of Companies Act, SEBI and all, but you have to wait for 210 days, that is 7 months, right? In this case, now notice has to be filed in form number 1 or form number 2. Form number 1 is if you are getting into a combination that will lead to give you a market share of 15% in case of co-generic industry, that is called horizontal combination. In case of vertical combination, if it is giving you 25% ka market share, okay, you have to file intimation in form number 1, otherwise you have to file the intimation in form number 2. So notice need to be served in form number 1. If it is horizontal combination and you guys are going to acquire the market share of 15%, and if it is vertical combination and you guys are going to acquire 25% of the market share after this combination, you have to file form number 1, otherwise form number 2 to CCI. Got my point, students? Form number 2 is a detailed form. Form number 2 is detailed form. Generally, form number 1 has to be filed. Form number 2 has to be filed in these situations. I made a mistake. Form number 2 has to be filed in 15 and 25% ka situation, and form number 1 in ordinary case. 210 days is mandatory waiting period. Right? They can investigate and check whether it is causing an appreciable adverse effect or not. But if a share subscription agreement is there, or there is a conversion of loan into equity because you could not manage to pay the loan, this section is not going to be applicable. If there would be a statutory or regulatory combination ordered by the court, if it is because non-payment of loan you are converting the loan into equity, or if it is a share subscription agreement by venture capital fund, these conditions are not going to be applicable, because here the investment is not being made in order to combine or acquire control of each other. It is by virtue of ordinary business transactions. Got my point? Done. So we have done with combination related requirement 2. Now there are certain combinations in which you need not to, intimate CCI. It is exempted transactions, like if underwriters are acquiring shares of any company due to underwriting obligation. If you are acquiring the stock of a company where the stock is the sole purpose, not the shares is the sole purpose, okay. if you are acquiring any current assets of one another company, if it is an intergroup acquisition, like Tata ka one group is transferring certain shares to Tata ka another group, these transactions will be treated as an exempted transaction for which you need not to take any approval of CCI. Is it clear? Got my point, students? So we have done with three important aspect of Competition Act, that is, I am just covering the important topics. Okay, beta. So we have done with combination 2, we have done with limits of combination, we have done with exempted transaction, we have done with form number 1 and form number 2, which is very important, and 10 days compulsory waiting period. Okay, so now I'll proceed with the miscellaneous matters of Competition Act, and the chapter is going to be over after that. Only 2-3 matters you guys have to focus at this point of time. Okay, now proceeding further with miscellaneous matters. So when it comes to miscellaneous matters, students, just go through with Competition Commission of India. Remember, when it comes to Competition Commission of India, it is a statutory body that has been constituted under this act. It has been registered as a body corporate. Whatever a company can do, the same can be done by the Competition Commission of India. It can get into contract, it can sue and be sued, it can hold property, it will have perpetual succession and all. And when it comes to the Competition Commission of India, they would have all the powers of ordinary civil code. They can investigate. There is a Director General appointed under Competition Commission of India who is responsible to investigate the matter of anti-competitive agreement, abuse of dominant position and combination, and they will submit their investigation report with CCI, and CCI would have all the powers of civil court. Okay. Now, what is competition advocacy? This is very important. Whenever the central or state government will make any policy which is having direct or indirect impact over the competition, they would take the advice of Competition Commission of India. And Competition Commission of India is bound to circulate or submit their advice to CCI within the period of 60 days. But the Competition Commission of India is having just the advisory role. It is up to the central and state government whether to accept their opinion or not to accept their opinion. Is it clear? That is called competition advocacy. CCI is, I told you, is being constituted under this act. It is constituted with three basic objectives: protecting the interest of the consumer, promoting the competition in the market, right, and ensuring freedom of trade in the market, right. Director General is like a police of Competition Commission of India, going to investigate the matters, and even they can impose penalties as well. Okay, if you are unhappy with any act of the Director General, you may prefer an appeal to CCI. Okay, and if you are not happy with CCI, you can prefer an appeal to NCLAT. Okay, NCLAT, National Company Law Appellate Tribunal. And if you are not happy with them, you may prefer an appeal to Supreme Court within the period of 60 days. Okay. Penalties, I guess there is no need at this point of time to cover. So go ahead with the application process. So three things you guys have to do, and one more thing I'll teach you. Wait. First is go ahead with competition advocacy, go ahead with composition of Competition Commission of India, role of Director General and appeal related provision, and last one is extraterritorial jurisdiction of CCI. As per section 32 of Competition Act 2002, if there would be any act or agreement or anti-competitive agreement, abuse of dominant position or combination is going outside India, beyond the territory of India, means two foreign enterprises are getting into merger, amalgamation, that is called combination, or abusing their dominant position, or getting into anti-competitive agreement which is causing an appreciable adverse effect in relevant geographical market or relevant product market located over here in India. Relevant geographical market or relevant product market located over here in India, they would have all the right, right to take action. That is, CCI can take action against overseas agreement, arrangement, understanding, anti-competitive agreement, abuse of dominant position and combination if it is causing an appreciable adverse effect over here in India. Is it clear? That is section 32, which is very important. So in this lecture we have done with what? Competition Act. In the next lecture I am going to finish with Consumer Protection Act. Once the Consumer Protection Act is done, I think hardly SEZ and legal metrology, two topics of part A, important topic of part A, including FTP, foreign trade policy remains pending, right? Then your part A marathon is done. Then part B marathon will not take much time. More important topics will be patent, trademark and copyright, and remaining topic like geographical indication design and basics of IPR does not carry much weightage. Okay, let's start with the another part of consumer protection, another part of ECIPL, that is consumer protection law, which is one of the most important topic. But when it comes to this chapter, generally institute used to ask case study from this chapter. They are not going to ask, direct question, but whatever direct question that may be asked in the chapter, I would cover that. So when it comes to Consumer Protection Act, earlier Consumer Protection Act 1986 was applicable, but now because there are so many change in the consumer environment, like now the consumers are totally dependent on e-commerce. So in order to match up the law with the changing environment, they have come out with Consumer Protection Act 2019. Okay, so it is because of the electronic world, it is because of internet. Okay, so the term of complainant, the person who is filing a complaint under Consumer Protection Act with the consumer authority, that is consumer forum, is being treated as complainant. It can be a consumer, it can be a voluntary consumer association. Means if something wrong has been done against me as a consumer, unfair trade practices or restrictive trade practices, I myself can file a complaint, or I can file a complaint with the consumer forum through voluntary consumer association, because voluntary consumer associations are in the locus standi of my interest, means they are having a common interest in all consumer complaints. Okay, the same question has been asked by the institute in setting up of business subject for trade union, that can a case be filed against an employer by the trade union when the employee is not capable enough to file a case? So answer would be yes. Even central government, state government, a central authority established under this act, multiple consumer having common interest, and in case of death of the consumer, their legal hire can also file the complaint. Okay, so the first is definition of complainant. The second one is definition of complaint. Complaint is nothing more than a written allegation being divided into two parts, a written allegation and relief sought to be achieved. Okay, two things will be considered. So complaint is nothing more than a complaint that has been given by any of the above person, that unfair trade practices has been conducted against me, restrictive trade practices are being conducted against consumer, or defective goods are being supplied to the consumer, or deficient services are being provided to the consumer. Okay, now this is not important how to file a complaint. Now you can file online complaint as well. Who is consumer? I taught you in this competition act very clearly. Consumer over here is having a narrow meaning. Any person, being natural or artificial person, can come under the definition of consumer if he bought the goods or availed the services for price not on free of cost basis. Complementary goods के लिए you are not a consumer in both the act, and you bought the goods or availed the services for self consumption or consumption of your relative or dependent, or you bought or availed the services for earning livelihood, right? You are not a consumer if you bought or availed the services for large commercial purpose, or you have bought the goods or availed the services for resale, right? Right, students. What all are the consumer rights over here in India? 6 rights: right to have window shopping, right to have information about the product, right to be heard, right to seek redressal, right to provide access over the variety of goods and services at competitive prices, right to consumer awareness is your right, not that much important. Defect is a term and deficiency is a term. Defect is a term that has been used for goods if you are not getting the right quantity of goods after paying the right prices, if you are being overcharged with the prices, if the goods is not of the description which is being provided in the package of the goods, it is called defective goods. And deficiency is all about services. Okay, so being a company secretary, if you are not happy with my services, you can file a complaint of deficiency in services. If being a customer of a bank account holder, you're not happy with the banking services, you can file a case of deficiency, but when it comes to defect, it is all about goods. Okay. Restrictive trade practices can be divided only into two parts. Generally, I have seen in many states it happens, in many cities it happens that cold drink is being charged with additional price than MRP, named as pooling charges. So that price manipulation is restrictive trade practices, that is selling above the MRP is a restrictive trade practices. And bundling. Bundling is nothing more than, if you can remember, joint selling. If you're buying the bike, they are asking you to purchase the insurance policy, that is called bundling. Bundling is also restrictive trade practices. Okay, so price manipulation and bundling is restrictive trade practices. Unfair trade practices is false representation, wrong warranty, misleading pricing, deceptive advertisement. These all are what? Unfair trade practices. Okay, remember, restrictive is only two: price manipulation and bundling, right? This is something very important. Under this act, a new authority has been established, that is called Central Consumer Protection Authority, whose headquarters would be there in Delhi. They are specifically taking care of unfair advertisement. Okay, they are specifically taking care of misleading advertisement. If you have heard about frozen dessert, many companies were selling frozen dessert by putting it as an ice cream, right? People has filed a complaint with Central Consumer Protection Authority, and action has been taken. Now entire ice cream market has been divided into two parts. Frozen dessert is different than ice cream, because in frozen dessert milk element is not being present, right? So when you think Bonavita is not a health drink, now it is a flavored drink because of this Central Consumer Protection Authority, because they are tightening the rules related with misleading advertisement. Only not the advertiser is going to be punished, but media is also going to be penalized who is broadcasting such kind of misleading advertisement. No, now people can file a complaint with Central Consumer Protection Authority about Dane Dane Mein Kesar Ka Dam, that is Bimal, right? Because it is also misleading advertisement, right? So specifically for regulating the misleading advertisement and promoting consumer awareness, they have formed what? Central Consumer Protection Authority. Okay. This authority can investigate the matter with the help of district collector too. Okay, they can inquiry, investigate, they can create awareness. Okay, and they can even impose penalty in case of misleading advertisement. Okay, you have to discontinue your advertisement, you have to modify your advertisement, and you are being prohibited to continue with any advertisement. This is something important. Penalty for false advertisement is 10 lakh rupees on the manufacturer and endorser. Okay, and in subsequent contravention it will be 50 lakh. And you would be prohibited for any endorsement for a period of 1 year for initial violation, 3 years for further violation. And the media will be imposed with 10 lakh rupees ka penalty. So if I am involved in misleading advertisement, I am subject matter of 10 lakh rupees tak ka penalty for the first time, 50 lakh rupees ka penalty for further time. I would be debarred from endorsement for a period of 1 year for first, and further 3 years, right? And in case of media agency, they would be penalized with 10 lakh rupees. Okay, done, students. For determining the penalty, they'll check that what kind of population is being affected by your advertisement, how frequently you are broadcasting that advertisement, the vulnerability of customers. So if you are promoting something which is related with kids, parent will be vulnerable for their kids. So vulnerability of the customer, and what revenue you have generated. So 4 things they'll consider before determining the penalty amount. The impact the advertisement has been created, frequency of the advertisement, profit that you have made out of that advertisement, and vulnerability of customer. Okay, this is important. Even if the authority will get into vexatious search, they would be subject matter of imprisonment up to 1 year and 10,000 ka penalty. If you are unhappy with the order of Central Consumer Protection Authority, you can prefer appeal within the period of 30 days with National Commission. Okay. Done with the first part of Consumer Protection Act. Certain definition, that is complainant, complaint and consumer ka definition, and then after central consumer rights of consumer, and then central consumer protection authority. Remember students, central consumer protection authority is very important. Okay, they are having two powers. One is administrative power to investigate the matter and judicial power to pass penalty order, right? Got my point students? Is it clear? Now proceeding further, district consumer redressal commission. This is going to be the district forum, going to be constituted by state government, headed by the district judge. Okay, they can accept the cases up to 1 CR, but the limit has been reduced. I'll tell you the limit later on. But as per law, they can accept cases where the compensation value is up to 1 CR, and they can only take the cases where the cause of action or the event has been happened in the concerned district. Now you can file the complaint with them through e-Dakil as well. Okay. They are having power to review and revise. Even if you are unhappy with the order of the district commission, you may prefer an appeal with the state commission. The state commission can directly take the cases where the value of the compensation is between 1 CR to 10 CR, and they can only accept cases when the event or cause of action has been happened within their jurisdiction. Okay. Now when it comes to state commission, they can also accept review and revision, and if you are unhappy with the order of state commission, you may prefer an appeal to the national commission within the period of 30 days, but you have to file 50% of the amount, ordered by the state commission. Means that appeal ke liye this is the minimum requirement. Whatever order that has been passed by the state commission, you have to deposit 50% of that amount with the national commission for appeal. Is it clear? Whenever it comes to a consumer case, generally consumer cases are being resolved within the period of 3 months, but if it does require laboratory testing, it will take 5 months ka period to resolve the matter. Okay, 3 months and 5 months, remember students. Okay, if you are unhappy with the order of the district commission, you may prefer an appeal within the period of 45 days with the state commission by depositing 50% of the amount. And if you are unhappy with the order of the state commission, you may prefer an appeal with the national commission within the period of 30 days by depositing 50%. Okay. Appeal will be resolved by the national commission or state commission within the period of 90 days. Beyond 90 days, they need to give justification why the time is taking more than 90 days. Okay. National commission can accept any cases where the direct value of the case is more than 10 CR, or they may prefer an appeal against central authority or state commission, right? But only question of law can be filed with national commission. And same Supreme Court, if you are unhappy with the order of the national commission, you may prefer an appeal with the Supreme Court within the period of 30 days, but Supreme Court can only accept question of law. Limitation period for filing the consumer complaint is 2 years. Limitation to file consumer complaint is 2 years. Okay, within 2 years from the date of cause of action, you may prefer an appeal. You may prefer a case of consumer complaint. Okay, so if something wrong has been happened with me in 2024, I would have a time till 2026 November to file a complaint. Right now, the new limits are notified limits are 50 lakh to 2 crore and 2 crore. Okay. Maximum limit provided in the law is 1 CR, 1 to 10 CR and 10 CR and more. But rule ke according to the rules, the new notified limit is you can file with the district forum cases up to 50 lakh, with state commission 50 lakh to 2 crore, with national commission more than 2 crore. Okay. All the power of civil courts are being available with the consumer court. Appeal against district forum 45 days, appeal against state commission and national commission 30 days, right? 50% you have to deposit, right? They have now included mediation, where rather than referring the case for adjudication, you can go ahead with settlement of the consumer cases. Okay. Product liabilities, by using the product, if you got any kind of damage like illness, mental agony, you can claim product liability claim, okay, against the manufacturer or against the trader, dependent upon the fact that who the product defect attributable to the trader or to the manufacturer, but generally manufacturer. Okay. Now to e-commerce entity and all, proper nodal officer appointment has been made mandatory. Okay, they have to respond to the consumer complaint within the period of 48 hours. They need to acknowledge consumer complaint within the period of 48 hours, and within 30 days they need to resolve the complaint. These are the guidelines that has been established. More guidelines has been about disclosure of the product, no variation in the pictures and all has been intricated. Okay. So this much is more than enough, but if you want to get it done thoroughly, I would recommend to go ahead with the past year questions. I'll attach with the notes, so just go through with the past year questions like story, and you guys will be capable enough to do what? Consumer protection. Done, students. So done with consumer protection law as well. This is more than sufficient. Other than that, I would recommend to go ahead with the case studies only. Okay, done, and recent amendments. Okay. Good afternoon, students. Starting with the next topic of ECIPL, which is also a part of consumer protection law, RERA, we are starting. So when it comes to RERA, it stands for Real Estate Regulation Act. Actually, when it comes to real estate sector, it was quite very unregulated sector. Earlier, the complaints related with real estate sector was only taken care by the consumer laws or consumer protection law, but they are not capable enough to provide adequate resolution mechanism, because when it comes to real estate, we can understand it's not like buying a mobile phone or buying a TV. It's all about you're going to put all your savings in your real estate property. So the magnitude of the impact of the complaint over the consumer would be quite very high. So in order to take care of it separately, because of the magnitude of loss that can be caused because of real estate frauds on the customer, the government has came up with a new law that is called Real Estate Regulation Act. It is going to regulate all the complaints pertaining to real estate. They'll require a registration of project, they'll require registration of builders, they'll require registration of agents. So the entire market, which is what not properly regulated before RERA law, is going to be adequately regulated by RERA law. It will build professionalism, it will build standardization, it will bring proper consumer protection in the sector. Okay. So earlier the problem was handled by consumer protection law, but now the problem is being handled by separate law. Okay, basic objective is to protect the right of the consumer in the real estate, promotion of uniformity and standardization, and balancing the interest of the real estate builder as well as consumer. Okay, that is the basic objective. Got my point, students? We know that almost 77% of our assets belongs to real estate, right? Basic objective is to regulate the real estate sector, including promoter, right? To protect the interest of the consumer in real estate sector, right? We know that. I'll go ahead with the important question. This is very important question. This act, salient features of RERA Act. The RERA Act provides for establishment of separate authority that is known as RERA authority. Okay, it will provide transparency to the sales pertaining to real estate. It will provide provision for the protection of consumers in real estate. It will provide proper dispute redressal mechanism pertaining to real estate issues. Okay, all the transactions related with real estates are going to be regulated because of this act. Under this act, the RERA authority is not going to be constituted by central government. It is going to be constituted by state government. So state government authorities are there. all the real estate project after application of this act is going to be registered under RERA authority. Even promoters, agents have to get registered with RERA authority. Okay, and all the project related money need to be kept in a separate bank account. So suppose if builder A is coming out with one project, the project pertaining all the revenue need to be deposited in separate account. Okay, because of RERA, this law, India mein FDI in terms of real estate has been increased, the consumer satisfaction level has been increased, litigation and issues related with real estate has been sorted out. It has built a kind of transparency in the sector and professionalism. Now the projects are being completed on time. Okay, so there are a lot of benefit that has been associated because of RERA law. Got my point? What is allotee? The person who is directly buying the flat or house from the builder, or any person who bought the flat or the apartment or building from allotee would come under the definition of allotee. Even but rent में रहने वाले means the person who have taken the property on rent would not come under the definition of apartment. Now when it comes to a flat, remember students, there are certain areas pertaining to flat. One is known as built up area, the second one is known as carpet area. Okay, built up area, carpet area, and super built up area. So whenever we are talking about carpet area, we are talking about a net usable area excluding balcony and veranda and open terrace. Okay, so carpet area is the net area which is going to be used by the consumer of the flat, excluding veranda, excluding open terrace area, excluding balcony. Okay, net usable area is known as what? Net usable area is known as carpet area. Now what is common area? Whenever we are talking about common area, whenever we are entering into building, there is lift would come under common area, staircase would come under common area, parking area would come under common area, common latrine bathroom available in the building would come under common area. Okay, so they are just defining the element of what? Building. Okay, completion certificate is all about once your project has been completed according to the promise or according to the project report, you will get the completion certificate. But after getting the completion certificate, you cannot do anything. You can allot the flat only after getting the occupancy certificate. Now when your construction is done, you will get completion certificate, but when water facility, electricity facility has been installed in the building, then only you are going to get what? Occupancy certificate. Got my point? Those which are important topic, I am going to teach that only. Now no project can be launched over here in India without getting it registered with RERA authority, point number 1. And point number 2 is very clear when it comes to RERA authorities. When it comes to RERA authorities, they are clearly stating that earlier pre-launch, soft launch has been launched by the builder without getting the project registered with RERA authority, but now without getting the registration with RERA authority, you cannot come out with pre-launch offers, discount launch offer, soft launch offer. Any kind of marketing or advertisement can only be started after registration. Okay, who is promoter? The person who is the builder, including land developer, construction companies, governmental authority like Mahada and all, cooperative housing societies, contractor and builders, even an individual who is working directly under the supervision and control of contractor and builder or a promoter will come under the definition of promoter. And the person who would come under the definition of promoter would be ultimately responsible for whatever promise that has been done through a real estate project. If something would happen with the real estate project, who would be first answerable will be the promoter. So promoter can be an actual person, artificial person, company, governmental bodies, cooperative housing cooperative societies, and even an individual can be a builder. Okay, real estate project is land development project or development of building related project. Okay, now this is very important questions. Which project does not require any registration with RERA authorities? I told you all the real estate project over here in India requires mandatory registration with RERA authorities. But any project where the size of the project or the plot is up to 500 square meter or number of apartment involved are up to 8. Okay, if when it comes to a builder, if it is he is coming out with any project where the land associated with the project is up to 500 square meter, or number of apartment in that case is up to 8, there is no need to go for such small project, need not registration under this activity. Okay, now if you are getting into a completion certificate, means before enactment of this act, if your project has already got the commencement certificate, it does not require registration under this act, so it is all bygones, right? Now if you are getting into any kind of renovation, repair or redevelopment of existing project where you are not going to make any kind of commercial sale, so as there would be no sale purchase of the apartment is being involved, there is no need to register. So three things are there, where the land area is 500 square meter, up to 500 square meter, second number of apartment is up to 8, right? The third one is when the project has already got completion certificate before enactment of this act, and the fourth one is complete renovation, repair and redevelopment related project, right, where no sale, commercial sale is there. Every project need to be registered with the RERA authority. You have to put completion timeline specifically, and that cannot be changed. So whatever completion time that has been committed at the time of registration cannot be changed. Okay, even if your registration has been revoked, registration will be revoked of the promoter, but the project will be assigned to some other builder who has to get it completed on time. Okay, so now because of this act, no project can be delayed at all except natural calamity, and that too maximum up to 1 year. Okay, whenever an action would be taken against you, remember, under any authority, they will give you a reasonable opportunity of being heard, right? I told you, even the registration has been terminated, your matter is going to be assigned to some other competent builder who is going to get it finished within the time, because ultimately consumer should not suffer because of the revocation of registration of the builder, right? Even all real estate agents need to be registered under RERA authority, and only they are allowed to get into real estate market agency. Okay, so RERA registration is mandatory for all real estate agents. Registration is the duty of the promoter, timely completion will be the duty of the promoter. And once you'll get your project registered, now you will get a web page in RERA website of the state authority, where you have to periodically update the progress of your project. Okay, so that web page will be taken away if your registration will be revoked. Otherwise you have to periodically, that is quarterly, I think, update. You have to update the web page about quarterly. You have to update the project, that how many flats has been booked in the previous quarter, how many garages has been booked, or shops has been booked, what or approval has been taken in the previous quarter. So if your builder is saying that their all projects are being, the project is entirely being sold, you guys can go and check the RERA website. You will get to know that how many flats are being constructed under this project and already has been sold out. Is it clear? Whatever commitment that has been done through real estate project, advertisement or marketing, it is the duty of the promoter to get it fulfilled. Whatever plan has been approved, you have to stick with the plan. You cannot make any change in the plan without taking the approval of 2/3 allottees. Okay, and if one particular flat is going to be changed according to the layout, you have to take written approval of that concerned allottee whose flat is going to be changed. Otherwise you cannot change in the sanction plan. Is it clear? 2/3 allottees approval is mandatory. If there would be any structural defect in the flat within the period of 5 years from the date of getting the possession by the allottee can demand to get it rectified by the builder. If the builder or promoter is not getting it done, he can get it done and he can claim reimbursement. Okay, this is important. So this is your right, that structural changes without your approval is not possible. If there would be an overall structural change in the building, it does require approval of 2/3 allottees. And next, if you got any structural defect within the period of 5 years from the date of getting the possession, you can ask the builder to get it repaired, or you will repair it and claim for reimbursement, right? If promoter want to transfer builder right to some other person, it requires 2/3 allottees ka approval. Okay. Insurance will be taken up by the builder till the building has not been given in possession to the allottees. It is the duty of the builder to hand over the possession as soon as possible once the occupancy certificate has been received by him, but he has to get the title documents, that is ownership document, transferred with the name of allottee within the period of 3 months, within the period of 3 months from the date of getting the occupancy certificate. Is it clear? This is very important rule, students. Okay. If you could not manage to complete the project, you are subject matter of payment of monthly interest if the allottee is not demanding for refund, and if allottee is being demanding for refund, you have to get it refund. Okay. Any delay would lead to entitlement of that concerned person, that he would have all right to demand for claim back of his money he has paid to you. You can withdraw, refund, or otherwise pay the interest. Every state will have a separate RERA authority. Being an allottee, it's my duty to pay on time, right? Claim possession. You can claim refund and compensation, right? Interest on delay, even you have to pay. So it's balancing out the interest of the allottee and builder. As builder is under an obligation to give you a possession on time, you are under an obligation to pay your money on time. Otherwise, how the construction can continue, right? Real estate advocacy is nothing more than whenever the state government will come out with any policy which is related with real estate matters, they'll first take the advice of the RERA authority, and RERA authority will provide the advice within the period of 60 days. But to opt for the advice of RERA authority or not, it totally depends on government. Okay. All advisory council under any act will play the role of advisory authority to the government. Remember, there is an RERA appellate tribunal where you can prefer an appeal against the order passed by the RERA authority within the period of 60 days, but you have to pay 30% amount of the penalty ordered by the RERA authority. Okay. And if you are unhappy with the RERA appellate tribunal, you may prefer an appeal to the High Court within the period of 60 days. Done. Remember, bar on jurisdiction like Money Laundering Act, like Benami Property Act. In every enactment, we can say that if there is a special court formed under any enactment, we can say that there would be no right of the civil court to accept cases related with that matter. So even if an ordinary court will accept the case related with real estate, it is any order passed by them is not at all be enforceable, right? Because power to pass an order under this act lies with only civil court, right? Now, cognizance of offense, this is a very common feature whenever we are talking about cognizance of offense. Remember, we do talk about any action under this act will only be taken by the authority if the complaint has been filed. Without suo motu, they cannot take. Okay, suo motu, they cannot take any action. If there would be any inconsistency between any common law or real estate law will prevail. Is it clear? Done with what, students? RERA, done with RERA. that is real estate, real estate authority, right? All important topics. I would say that I have covered everything, right? Important part. Now going ahead with legal metrology law. A legal metrology is carrying on an average weightage of around 4 to 5 mark, which is non-compulsory. Whenever we are talking about legal metrology, remember student, legal metrology is nothing more than the law which is regulating weights and measures. So whenever we are buying any goods or services, we can see that over that goods ka packet there is a quantity that has been written. Remember, a customer can be exploited by two way: by charging excess price, that is why MRP is there, right? And second, by manipulating the quantity, that they can sell you less quantity in the given prices. So quantity can also be an element of conducting fraudulent or malafide activities against consumers. So legal metrology is trying to standardize the principle of weights and measures. We are the part of International Organization of Legal Metrology, which is nothing more than an international organization which is just working towards harmonization of the norms of weights and measures, a standardization of norms of weights and measures, because if you are willing to get into international trade, there should be an international standards of weights and measures. If there would be no uniformity or consistency between the weights and measures between countries, international trade would become impossible or difficult. So in order to make sure that everybody would follow the same norms or protocol pertaining to weights and measures, standardization is essential, and it is being done by OIML, and India is also the part of OIML. That's this International Organization of Legal Metrology. Is it clear? Model law, even if India is coming out with any amendment pertaining to legal metrology, we would say that that amendment will be brought in because of the recommendation given by OIML. Okay. Here two questions are very important. One is principal display panel and the second one is pre-packaged commodity. Under this act, even if you are involved in any kind of usage of unlicensed weights and measures tools, or if you are being involved in any kinds of fraudulent activity under this act, you are subject matter of criminal punishment logically, students, because if you are doing such kind of thing, it will lead toward consumer harassment, that is public harassment, right? Under this act, even inspector and other officers will be appointed who can inspect your place and can check what kind of activities you are doing in terms of weights and measures. Okay. One is pre-packaged commodity, is very important. What is principal display panel? See, whenever I'm buying a goods, there are some majority area in that particular packet that is being used for marketing, but there is one specified area where all the relevant information that need to be known by the consumer has been written, like MRP, like quantity, like ingredients, like barcode. Everything has been written in one particular area, right? If I'm buying a biscuit ka packet, almost all the area of all the area or all the aspects of the product is being covered with the full on marketing gimmicks and all, but one particular area is being carrying all the essential information which is mandatorily required to be disclosed in the product itself, and the area is known as principal display panel. So whenever we are talking about principal display panel, we are talking about that area of that package of the product where all the statutorily required information has been written. If it is an online selling, then some part can be written over the product and some part can be written on the website. That is called, the information can be divided into different area, but when it comes to offline selling of product, it should be part of the product only. So principal display panel is nothing more than the specified panel according to the requirement of law, where you are going to put all the relevant information that need to be known by the consumer who is going to buy the product. Is it clear? This is the most important question, principal display panel. compounding, I taught you so many times, compounding के norms will remain same to same everywhere. Just a minute, students. Pre-packaged commodity. A pre-packaged commodity, they are stating that whenever you are selling a pre-packaged commodity is nothing more than a commodity which is not going to be packed in front of the consumer, which has been already packed and sold to the consumer after packaging. Means it is being packed in the absence of the consumer, right? So whatever you are buying, if it is a packaged commodity, it is the duty of the trader, supplier or manufacturer who is being involved in pre-packaged commodity. If they are showing the prices in the commodity, they should also mention the quantity. If you are mentioning the price, you have to also mention what quantity include in that packet. That is the rule. Is it clear? Other than other information, if it is an imported goods from where you have imported, all other information are relevant, but if you are showing the MRP, what you will have to show is quantity. So if you are not willing to show the quantity, don't show the if you are not willing to show the price, don't show the quantity, but if you are showing the MRP, you have to show the quantity. Is it clear? See, imprisonments are there under this act. Why imprisonments are there? Because if you are being involved in any activity which is pertaining to contravention of this act, it will lead to what, beta? Ultimately consumer harassment, right? For non-criminal offenses, you can demand for what? Compounding of offenses, but three times one time in 3 years gap, and you have to pay the compounding charges. To do or not to do, it depends on officer, and once done you will be relieved from the offense, right? Now there is an Essential Commodities Act. Remember the name of the essential commodities. When it comes to essential commodity, it includes food crops, it includes vegetable crops, it includes fruits crops, it includes drugs, fertilizer, which anything which is really essential for human being for survival. So it will be related with agriculture and medicine, right? So agriculture and medicine related, transportation related, everything is being grouped together as an essential commodity. And if something will come under the definition of essential commodity, its price, quantity, supply, distribution, everything is going to be regulated by government, right? Central or state government, in order to make sure that these essential commodities should be available at reasonable quantity at reasonably affordable prices to the public in large, right? So it includes drugs, all kinds of fertilizer which is essential for the agriculture, food stuff, hang yarn, right? Petroleum and petroleum related product, raw jute and jute textile, various seed which include seeds of food crops, vegetables, cattle fodder. These will come under the definition of what? Essential commodity. I told you once, commodity will come under essential commodity. Its production, distribution, pricing, everything is going to be regulated by government, central or a state government, right? If anyone would found with unnecessary stocking of essential commodity, not supplying it at right quantity at market or selling it at black pricing, government is having all power to seize and confiscate the essential commodity, right? Done, students. We have done with one more chapter, that is Legal Metrology Act, right? So with this we have done with consumer protection law, we already done with competition law, we have already done with consumer protection law. So all the important chapters pertaining to consumer protection is pending, but I think Benami property is still pending and SEZ is pending, that I am going to cover in a while. And then part A of ECIPL is done. Then we'll have to pick the part B. In part B, I'll prefer to go ahead with the relevant topics of patent, copyright and trademark, and after that few topics or important questions of design, geographical indication, and the last one is what? Basics of intellectual property right, I would cover. Okay students, so done with two topics. Now in next lecture we'll do other part. Is it clear? Done students. Now we will go ahead with Benami property beta. Okay students. Oh, I'm so sorry. Oh, we have done with competition law, right? This is Benami property law. So what is exactly Benami property? There are certain criteria to define Benami property. Benami property means a property which is being registered with the name of a person who is not the actual owner of the property. Means if I am transferring some property in order to save taxes or in order to save some other actions, statutory action against me on you, although you are holding the property on paper, but all the beneficial interest of property lies with me, the property will be classified as a Benami property. So Benami property doesn't mean that it is not a property that has been registered with the name of any person. That is wrong. Benami property is nothing more than a property. The person who is owning that property is not holding the beneficial interest in that property. There are bipartite transaction in Benami property and tripartite transactions in Benami property. Bipartite means if I'm transferring my property to some other person, the bipartite transaction means it is also known as Farji transaction. Okay, whenever we are talking about Benami property, there are two kinds of transaction in Benami property: bipartite and tripartite. If I am transferring my property to A, although I have transferred my property to A, all the property related beneficial right lies with me. That is known as what, beta? Bipartite transaction. Okay, and tripartite transaction means if I am buying a property with the name of XYZ and I'm paying for the same, but the property is going to be held by him. So here three parties are involved: seller, buyer, and the Benamidar, right? The person who is holding the property on behalf of me by his name. I'm paying for the same, so he would become Benamidar. Okay, and if I am transferring my property to any other person, only two parties are involved, me and the other person. I am transferring my property to him, but all the beneficial interest will be there with me. Okay, he will hold the title, but I'll hold the beneficial interest. Okay, so that is called bipartite transaction. Got my point? There is a proper definition of Benami transaction. I'll teach you that. There is an imprisonment of up to 1 to 7 years in case of Benami property law, and you have to pay the penalty up to 25% of the fair value of the property involved. Okay, most important is the definition. First one is tripartite transaction. If someone is buying the property but the consideration is not paid by him, consideration is paid by some other person. Okay, second is bipartite only. If someone is transferring property, just title is transferring but beneficial interest remains with him. That is the two transaction which is Benami transaction. Okay, if you are buying a property with the name of a person who doesn't exist at all, that is called fictitious name. Even that is a Benami property transaction. When the person who is holding the property, he himself is unaware about the fact that he is the holder of that property, it is a Benami property. When the property is being bought by a person where the consideration paid by a person who is fictitious, means who is not traceable. There are 5 transactions which are Benami. First one is when someone is buying a property but consideration is paid by some other person who is not related to him and having no close or blood relationship. That is known as Benami transaction. Second, if I am transferring my property to any other person where the beneficial interest is being held by me, but only title has been transferred to him, that is called Benami transaction. Third one is if someone is buying property with the name of a non-existent person, that is called Benami transaction. Fourth, when the consideration is untraceable from where the consideration has came, Benami transaction. Fifth one is when the owner of the property himself is unaware about the fact that he is the holder of the property. That is a Benami transaction. This is very important. But there are certain exclusion. If Hindu undivided family is buying a property with the name of Karta through its unknown sources, if you are holding the property for the fiduciary capacity, like trustee and mutual fund trust are holding your units for the benefit of the beneficiary, when you are buying a property with the name of spouse, brother, sister, children, from known sources. So if you are buying a property from known sources with the name of relative, it is not a Benami transaction. Second one is, if you are buying property or you are holding property in the trust or for the beneficial interest of some third party, because of trust arrangement, it is not a Benami transaction. Okay. Here even they would have all the right to investigate, inspect, inquire, and later on during that investigation, inquiry or inspection, they can seize or attach your property. Once it will be proved, they are going to confiscate your property, right? Same protocol in fugitive economic offences, same in money laundering. Only the period may vary, but first they'll do attachment, then after, first they'll do investigation, then attachment, during investigation, then once proved they'll take over your property. That is called confiscation. Okay, the person who is lending the name is known as Benamidar. Okay, earlier the imprisonment related with Benami transaction was 3 years, but now it is 7 years. But this 7 year cannot be with the retrospective effect, because if you'll go ahead with the Constitution of India Article 22, you'll get to know that Article 20, that criminal punishment cannot be increased from the back date. So earlier Benami Property Act 1988 was applicable, and then Benami Property Act 2016 has came. So if now any act that has been done before this enactment can only be imprisoned for a period of 3 years, but after the enactment of this act it will be 7 years. Okay, for the transaction happened after 2016. Okay, confiscation, I told you, once it has been proved that the property is Benami property, it is going to become the governmental property. Along with that, you have to pay the penalty up to 25% of the fair value of the property, right? They are initiating officer. These all officers are going to conduct inquiry, investigation, inspection over the affairs of a person who is being involved in the Benami property. See, 90 days ka attachment period in both the cases, in fugitive economic offences and in money laundering. The attachment period was 180 days. Here the attachment period is of 90 days. Okay. But whenever the property is being attached, notice of attachment will be given to the adjudicating authority, right? And if you want to extend that attachment period, it does require approval of adjudicating authority, right? Once a property has been declared as a Benami property, it is subject matter of confiscation, and once it will be confiscated, any right in that property of the third party would have no enforceability, right? Third party cannot enjoy any interest on a Benami property, right? Adjudicating authority and appellate tribunal has been established under this act, and if you are unhappy with their orders, you can prefer an appeal to High Court within the period of 60 days. But remember, students, always you can approach High Court for the question of law, you cannot approach the High Court for question of fact. Okay, and special court has been found under this act, so only special court can initially entertain the matter related with Benami property. No ordinary court would have any jurisdiction to entertain the cases related with Benami property, right? The person who is actually involved in Benami property will be subject matter of 7 years rigorous imprisonment, not the general or common imprisonment, with the 25% of penalty, and the person who is supporting him will be imprisoned for 6 months to 5 years and 10% of the penalty of fair market value. Is it clear? Got my point, students? We have done with what? Benami Property Act. That is more than sufficient. Okay, students. So we have done with all consumer protection related law. In consumer protection, we have done with Competition Act, we have done with consumer protection, we have done with RERA, we have done with legal metrology and Essential Commodities Act. In money, in economic offense related series, we have done with 3: Money Laundering Act, Benami Property Act, Money Laundering Act, Benami Property Act, and Fugitive Economic Offender Act, right? Now we have to take care of only SEZ and FTP. money laundering we have done. We have done with even this, right? RERA, no, FICRA, FCRA, right? Foreign contribution and foreign hospitality, very important chapter, right? Just a minute. Now starting with a special economic zone, which is one of the important chapter when it comes to special economic zone. See, because of special economic zone, entire India can be divided into two part. The first one is duty tariff area and the second one is duty free area. Whenever I am talking about duty tariff area, it is the common area where the trades are being going on and they are subject matter of taxation. But when it comes to duty free area, these are the areas like special economic zone, 100% export oriented units are being located over there. These areas are the locations where all the manufacturing unit, all the service providers are being involved in providing services or manufacturing goods only meant for exports. Means they are only involved in the export business. As they are being involved in export business, we know the condition of India's balance of payment is negative. We are running behind increasing the exports. As they are contributing towards the export of the nation, they are subject matter of free of all the taxes. No indirect taxes are going to be applicable on them. All the taxes, if even being paid by them, will be subject matter of refund or adjustment or duty reliefs, right? So they are free of, they are operating without paying any indirect taxes over this territory. Okay, even if a unit that has been located in duty free area is getting into a transaction with duty tariff area, it will be classified as deemed import or deemed export and will get the same treatment like if you are dealing into imports or exports. Okay, so if you are buying something from SEZ unit, it will be treated as deemed import over here in India, and if you are supplying anything to the SAES unit, SEZ unit, it will be classified as deemed exports from India. So ultimately government is giving them full of convenience, autonomy and their own regulation in that location. They would not work under the supervision and control of the municipal corporation. They would have their own norms in that location. Okay, so the SEZ are subject matter of all the concession, statutory, regulatory, local laws, taxation. Multiple benefits are being provided to them because they are contributing towards exports. Is it clear? Got my point? So SEZ unit can be established under this act. As EZ can be notified under this act. Any banking unit which is working in that area will be treated as offshore banking unit. They'll get fiscal concessions. SEZ authority has been established. Even SEZ separate court is there. Anybody, government or private sector or public sector, can open SEZ. Even Adani has opened their own SEZ known as Gift City in Gujarat, right? So this is not required that SEZ need to be created by it. It is going to be notified under this act, but its development can be done by even private sector undertakings as well. Okay, being marathon, I am going to cover with only important matters. Okay, it will invite foreign direct investment, promote exports, create employment opportunity, create additional economic activity, world class infrastructure facility will be there. So these are the benefits related with what? SEZ. In SEZ area where the business will go on, it is known as processing area, and the area where the quarters, apartments will be there, it will be treated as non-processing area. And the map or layout of the SEZ need to be registered with the SEZ authority. Is it clear? First authority that has been created under this act is the Board of Approval, who will approve the notification of any area as a SEZ area. Central government will constitute Board of Approval. Its composition will be decided by the central government, and Board of Approval will be ultimately responsible for orderly development of SEZ. If you want to notify any area as an SEZ, the Board of Approval will grant the approval for the same. Board of Approval will delegate the power for administrative function to the Development Commissioner appointed under this act by the central government. If any developers or a letter of approval has been cancelled or suspended for a period of 1 year, if he is not satisfying the condition pertaining to his approval, an administrator will be appointed on behalf of that developer to take care of the SEZ activities. But minimum 3 month का advance notice has to be given to the developer before suspension of his certificate. Okay. For 1 year, all the powers of development pertaining to that SEZ location lies with administrator then. When it comes to notifying a particular area as an SEZ, it lies with Development Commissioner and Board of Approval. But when it comes to developing SEZ units in SEZ, it lies with Approval Committee. So unit related all powers lies with Approval Committee, and SEZ location related all the norms lies with Board of Approval and Development Commissioner. Okay. If you want to set up a unit, it does require approval of the Approval Committee. If you want to notify an area as an SEZ and it is any matter pertaining to development of SEZ location, it lies with Board of Approval and Development Commissioner. Is it clear? For opening offshore banking unit, it does require RBI approval. For opening IFSC in SEZ, it requires central government approval, not of the Development Commissioner, nor of Board of Approval, not of Approval Committee. They are only connected with notification of area as a SEZ area, development of that SEZ location, layout of that SEZ location, and to open SEZ units over there, it does require approval of Approval Committee. But when it comes to opening International Financial Service Center in SEZ location, or when it comes to opening offshore banking unit over there, for offshore banking unit, it does require approval of RBI. For International Financial Service Center, it does require approval of central government. Okay. There are proper code pertaining to dealing with matter related with SEZ. They will subject matter of certain concession pertaining to indirect taxes. For income tax, there would be some periodical tax holidays that can be given, but income tax would be subject matter for even SEZ units. Okay. If they are dealing with domestic entities, I told you it will be treated as deemed import and deemed exports, right? If there would be any clash between any law or SEZ law, what will prevail is SEZ law. If there would be any clash between Benami property law and general law, or with RERA or any other law, whenever there is a special law, remember 2-3 things are very common, student. First, if they will clash with general law, special law prevail, not the general law prevail, because all the special law are being provided with overriding effect. Second, if they are leading to constitution of special court, ordinary civil court would have no authority to entertain the case pertaining to special matters. Only special court will take care of the special matter. And the third and a very important thing is, no cognizance of offence can be taken until and unless there is expressly provided that authority can take suo motu action. Otherwise, authority can only take action if a written complaint has been filed. So, except Competition Act, here in the Competition Act it has been clearly written that the authority can take action suo moto, but here in all the laws authority cannot take action until and unless a written complaint has been filed. And a last and a very important thing is, students, remember, whenever it comes to all the special law, generally there is a provision of compounding of offenses, and simple principle of compounding will be applicable everywhere, same to same, whatever law it would be. Is it clear? And for offenses of company, always along with the company officer in default will held responsible. These are the common point relevant with each and every law that is the part of your syllabus. Is it clear? So let me check. We have done with FEMA, FDI, FODI, ECB has been done, SEZ done, Foreign Contribution and Regulation Act is done, Money Laundering, Fugitive, Benami, Competition, Consumer, Legal Metrology, RERA done. FTP, I am going to cover only one provision, that is related with star export houses or something, because I feel that is important. Other than that, now I am going to cover only part B, that is IPR. Okay. Now we should go ahead with the last topic of part A. Then we will start with part B, right? So once you'll get into FTP, now remember about just a minute, transitional arrangement. See, whenever it comes to foreign trade policy, it is being developed by DGFT, that is called Director General of Foreign Trade. So whenever we are talking about Director General of Foreign Trade, the foreign trade policy are going to be developed by him, and it is going to be remain valid for a period of 5 years. What happens if during that 5 year there would be some union election and the government will be changed? Then there would be a certain situation that the concession and relief that has been provided by the existing FTP may be taken away by the new ruling government. So that is not feasible for any nation. So in order to make sure, there is a clause in all the policies which is being governed by ruling government, that is known as transitional arrangement. Even if there would be a transition in the government, or if there would be a transition in new policy and old policy, whatever concession relief that has been provided under old policy will be respected by the new government or new policy, and it will continue till they expire. Is it clear? So if I am going to get any concession for a period of 5 years under existing FTP, if in future there would be transition or change in new FTP, the new FTP will allow me to enjoy that benefit for the remaining period. Is it clear? That is called transitional arrangement. Is it clear? That is foreign trade policy. IEC code number is mandatory. It is based on your PAN number. You have to make an online application in a specified form with DGFT, then you will get an IEC number. Without having an IEC number, you cannot think about getting into import and export. But for certain category of exporter and importer, like central government institution, state government institution, central government and state government itself, food foundation, these are not required to take any IEC number. They are being provided with demo IEC number. Okay, for the IEC number you have to file form ANF2A format. Okay, that is an online application. I told you certain category will be exempted, like Ministry and Department of Central and State Government, personal usage. If you are getting into import and export with Nepal and Myanmar, you need not to have IEC number. One person will be provided, or one firm will be provided with only one IEC number. Okay, this is something important. Transitional arrangement I taught you. Status holder, that is something very important. Okay, what is status holder? If they are, you have excel in the performance of exports, you will be classified as status holder. There are 1 star is export house if you have reached the threshold of 3 million US dollar in terms of your export. 15 million then 2 star, 50 million then 3 star, 200 million then 4 star, and 800 million then 5 star. Okay. This export performance has to be done in current financial year and preceding 3 financial year. But in gems and jewelry sector, only 2 financial years. Okay, current and last 2 financial year. This is the limits. Remember the limit: 3, 15, 50, 200 and 800, right? Double weightage will be provided for 1 star export house. For MSME, means if you have done with 1.5 million US dollar, it will be counted as 3 million US dollar. If you are MSME, 1 star export house, or a unit located in northeastern area or Sikkim or union territories, etc., you'll have certain privileges. You need not to have declaration signed by the authorities. You can submit your goods or get the custom clearance on self-declaration basis. You can submit your input-output norm 60 days in advance. You need not to submit bank guarantee for credits. Okay, you'll get preferential treatment. Now the state, this is something very important. Now the status holder has to make sure they are providing with skilling and mentoring support to other people. Okay, if you are a 2-star export house, you have to keep minimum 5 trainees. If you are 3-star house, you have to keep minimum 10 trainees, 4 20 and 5 50 trainees. It will be a 6 weeks training in which you will guide the people how to excel in terms of what? Export performance. Okay, this is something important. So I think 2-3 things are important when it comes to foreign trade policy. One is star export houses, and the second one is IEC number we have covered, and transitional arrangement, right? Done, students. That is more than enough for marathon. Now I'll pick up the marathon for part B. I'll focus on patent, copyright and trademark, and remaining topic I'll go ahead with exam point of view. Okay, now starting with part B, students, first we'll go ahead with the national policy on intellectual property right, which is going to be a very important question. Okay, what all are intellectual property right and all, it is not that much important, because you are ultimately going to go ahead with patent, copyright, trademark, everything is there separately in the syllabus. So intellectual property right is nothing more than the right that has been created by using the human intellect. If you are creating goodwill, it is an intellectual property right. Your reputation, right? When we are talking about singer ka singing, that is an intellectual property right. Cinematography ka film is an intellectual property right. Maggie ka formula is a patent right. These all are intellectual property rights. Okay, trade secrets are intellectual property rights. They are intangible, right? You are having all the right if they are being registered to file a suit against the person who is using your intellectual property right without taking your approval, right? If you are willing to promote creativity, if you want human development, if you want global recognition, if a country wants economic growth, they need to promote registration of intellectual property right. Copyright is only that intellectual property right which may or may not have industrial usage. Otherwise all the intellectual property rights are having industrial usage, and there is a proper agreement known as TRIPS, which is a part of trade related aspects of intellectual property right, which has been signed by India too. which is a part of World Trade Organization, providing you international protection over intellectual property right. Okay, and will provide you a proper provide the country's proper harmonious or standardized guidelines pertaining to intellectual property right. WIPO is also a World Intellectual Property Right Organization. All the international organization is running behind standardization and harmonization. Remember that, because now the people are getting into international trade, so harmonization and standardization is essential, whether it is legal metrology or whether it is intellectual property right. Okay. The most important question over here is a national intellectual property right policy. Government has came up with this policy in order to promote creativity, innovation amongst human being. This policy has been came out with a concept of promotion of registration of intellectual property rights. Okay, they're focusing on healthcare, food security, environmental protection related creativity and innovation. Because of this policy, more and more legal framework has been aligned according to the requirement of World Trade Organization and WIPO standards, and according to, because of this policy, there are a lot of IPRs being registered over here in India, and it is also promoting commercial utilization of intellectual property right. And if someone would encroach or infringe your intellectual property right, they are also running behind promotion of enforcement and adjudication of intellectual property rights. So 4 basic objective: promotion of creation and registration of intellectual property rights. Second, promoting commercialization of intellectual property right. If someone is being breaching your intellectual property right, this policy is also supporting with what beta? Enforcement of intellectual property right matters right. So 3 things are there. Got my point? So the most important question is national policy. Although institute has already asked question, you can prepare short note on national policy, you can prepare short note on TREPS and WIPO. Okay, done with what? First topic of intellectual property right. Now what is patent? Remember, whenever we are talking about patent, students, we do talk about invention which would have a scientific or technological invention which will be capable of industrial application. If any invention is not capable of commercial exploitation or industrial application, it cannot be subject matter of patented. In India, Patent Act 1970 is being applicable. According to this act, only those inventions belonging to science or technology having an industrial application can be registered as a patent. Remember, having an industrial application. Okay, patent will give you an exclusive right that you can only use that invention for industrial application. No one can use that invention for industrial application other than you. If someone will use it, it will lead to infringement of patent. You would have all the right to file suit against that person. The person who is holding the patent is known as patentee. In order to be a patentable invention, remember, it should be an invention that has not been classified as non-invention under section 3 and 4 of this act. It should carry some new or inventive step, and it should be capable of industrial application. 3 things should be there. It should be an invention which is not being classified as invention, which is not patentable under section 3 and 4 of this act. It should be carrying some new or inventive step, and it should be capable of industrial application. Then only your invention can be registered as a patent. This is the most important question of this chapter, which all are not invention. Anything which is nothing more than the frivolous claim, which is talking something, which is claiming something against the natural well established laws, anything which is against the public order or morality. If you have found out some new form of any substance, okay, that is not an invention. Method of agriculture and horticulture is not an invention. Discovery of any plant or animal or any living being is not a, it is a discovery, it is not a invention. Any mathematical or business model is not an invention. A presentation of information is not an invention. A mental game or act is not an invention. So remember 7-8 names. Anything which is contrary to well established natural law, that is called frivolous. Anything which is against the public order. Okay, if you have searched or discover any new form of any substance, animal or plant, that will not be treated as an invention, it will be treated as discovery and subject matter of copyright, not the patent. Any method of agriculture, horticulture, business model, presentation of information is not a invention, right? Any invention pertaining to atomic energy can only be registered with the name of central government, cannot be registered with the name of any other person. So even atomic energy under section 4 is not a patentable invention. Who can make an application for the patent? The concerned person claiming to be true and first inventor of the invention, or his authorized representative having special power of attorney, and in case of death of the inventor, his legal hire. These three person can make an application. Okay. True and first inventor, assignee or legal representative. In application you have to attach specification. Specification is nothing more than a document that has been specifically prepared according to the requirement of Patent Act 1970, which is carrying technical and other specification related with invention that you have made. It will carry all the full description of invention. Invention is scope of invention, methods of performing that invention. Even sometimes it is also carrying the sample of the material that has been used in order to create that invention. So earlier, because when it comes to patent registration, you are running behind time. So logically, first you have to make an application for patent registration, but by just filing a rough format of that specification. Rough format of that specification is known as provisional specification, and within 1 year you have to file the complete specification. Now what is the difference between provisional and complete specification? Both are one and the same thing. Provisional specification will be filed earlier, and later complete specification will be filed. And provisional specification is in rough format, and in fair format or according to the strict requirement of law, complete specification will be there. Okay, content of a specification I told you, right? Biological material I told you. You can even make an application for international patent, but first you have to make application in India, then only you can make an application for international patent. Remember, in all intellectual property right, no intellectual property right can be granted until and unless the application for the same has been published for objection invitation. The controller will invite objection through publication. Once the objections has been received, they will sort out all the objections. Then only after sorting out of the objection, they'll grant you patent, otherwise not. So whether it is patent, copyright, trademark, everywhere publication is mandatory. Potential infringement is very important. See, sometime your invention may be based on some other invention which has already been patented. Sometimes, or many a times, your invention is based on the already invented material. Means, like, if I can say that the tube light has been invented inspiring from bulb, right? So coolers are being invented based inspired from fans. So logically, whenever we are talking about potential infringement, if you have made invention or upgradation of an existing technology, you have to mention in your complete specification name of the technology or name of the patented material which has been used for your invention. So that mention of the mention of reference of the patent number of that already registered patent which has been used for your invention is known as potential infringement. Okay, and that is permissible infringement. Generally infringement is actionable and punishable, but here it is being permissible. Is it clear? You can make an application, international application, only after 6 weeks from the date of making application over here in India. Once the patent application has been submitted, all objections has been sorted out, if things will be okay, then they'll grant you a patent as soon as possible without unnecessary delay. And patent remains valid for a period of 20 years, and this 20 years is going to be counted from the date of application, not from the date of grant. Okay. But whenever a patent has been granted, it is being granted with certain condition that government can use these drugs or other things in their governmental dispensary without asking for from you. Any intellectual property right can be used for research and development, that will not lead to any kind of infringement. Okay, so for public health, for public welfare, it can be used by government without taking the approval of the patentee, and second, it can be used for research and development, and it will not lead to infringement. So two things will not lead to infringement, even three things, right? If you have developed some new patent based on the existing patent, you can refer it in complete specification, and it will be classified as a potential infringement, right? And that is permissible, right? Once the patent has been granted, the patentee would become exclusive owner of that concerned patent, and without his permission, no one can use it. If someone will use it, it will lead to infringement, and infringement will be an actionable right. You can claim compensation, right? And I told you it will remain valid 20 years from the date of filing the application, not from the date of grant of the patent. What is patent in addition? This is a very logical topic, and this is also important. If suppose the same patentee has upgraded his existing invention, means you are already holding a patent for X product. Okay, now you have upgraded X and it has become Y. Now you are claiming a new patent for Y. Now the patent controller will ask you to make an application for patent in addition, where you need not to pay any separate fees for the registration, and your patent in addition is going to be valid for the remaining period of your main patent. For example, crocin and crocin crocin pain relief and crocin is an existing patent held by one pharma company, right? Now if they are coming up with the new formula of the crocin, say crocin pain relief, so they can demand for patent in addition for crocin pain relief, for which they need not to pay any additional fees separately, but the validity period of crocin plus will be remaining period of the main patent, that is 20 years validity will be of the main patent. Then if it is been registered on 5th year, it will have validity period of remaining 15 years for the existing patent, okay, with existing patent. And if they'll renew the main patent, automatically the patent in addition will be upgraded. So there is a connection between potential infringement and patent in addition. In potential infringement, upgradation is done by some third party, not by the same patentee, right? But in case of patent in addition, upgradation has been done by the same patentee. That is why he is claiming what? Patent in addition. Is it clear? If your patent has been lapsed, you have to get it restored within the period of 18 months from the date of expiry. But for that 18 months ka period, whether you will get the protection or not is subject matter of facts. Generally not. Is it clear? Because you got delay, but you have to justify why it is being delayed. And even during restoration renewal, publication of your restoration and renewal application will be done. Publication will be required at every stage. You can even surrender the patent, or patent can be revoked for usage. Okay. Now when it comes to the patent, if you are being granted with the patent, it is an exclusive right provided to you that you can use it, but you should make sure that it should be reasonably available in this nation. That patented material should be reasonably available in this nation at a reasonable quantity with reasonable price. If you're not capable enough to use it at the reasonable or publicly affordable prices, or you're not capable enough to supply it to the people of India at reasonable quantity, any person can demand for compulsory license. And now what is voluntary and compulsory license? If being a patentee, I am giving you a right to use my patent, I would become a licensor, you would become licensee, and we have into a voluntary license relationship because I have given it to you. But if it has been realized by the government, people are filing complaint with the controller of the patent that Rahul is not using the patent for the benefit of people of India, he is been using it outside India, or he is not capable enough to provide the patented material which is necessary to the people at publicly affordable prices or quantity, then your licensing right, means my licensing right, will be taken away by the patent controller, and he will grant this license to some other person or to the existing licensee with the reasonable terms, so that it can make sure that the patented material would be available at reasonable quantity at reasonably affordable prices to public over here in India. Three grounds are there: not in enough quantity, not in right prices, not at all using in India. Is it clear? But this action can only be taken after expiry of 3 years from the date of granting the patent. Is it clear? So compulsory licenses, your licensing right has been taken over and given it to some other person. So it can only be happen for after 3 years, and after 3 years if the compulsory license has been granted, now I cannot grant the license because government or the controller has granted. Now the licensee will be provided with the period of 2 years. If within the period of 2 years he could not satisfy either of the three conditions for which he got the license, his license will be taken over and given to some other person, and that is called revocation of compulsory license. Is it clear, students? Non-working. Done. We have done with patent, student. It took hardly 12-13 minutes to finish with patent. Now I'll pick up the trademark, and after trademark I'll pick up the copyright. Okay. Now starting with trademark, students. So what is exactly trademark? Can I say that trademark is nothing more than a mark that has been used in the ordinary course of business of a trade or services, right, which is being used by the business in order to give identity to their product. Why I'm using my name? I'm using my name to identify, giving identification to the people, that how they can identify me, right? In the same way how they can identify a particular product. For even brand positioning, trademark is essential, right? You know Parle G because Parle G is Parle G, right? So basically, whenever we are talking about trademark, we are talking about a mark that has been used. It can be in any form. It can be in the form of combination of color. It can be in the form of symbol. It can be in the form of sign. It can be in the form of name. It can be even sound marks, right? Like Nokia ka tune is a sound mark, right? Airtel ka tune is a sound mark, right? That shows that if that tune will happen, you will got to know that they are talking about what brand. So sound mark can also be a trademark. Is it clear? So which will give you an identity, over what? Marketplace, right? So it will be used for marketing. It is being used for giving identification, right? It is being used for brand positioning, right? There are various kinds of trademark. One is well-known trademark. Whenever we are talking about well-known trademark is nothing more than a mark which has been quite very popular for the significant segment of the public, that almost everybody knows about that mark. When it then in automatic registration or recognition will be given by this act to that mark, even if it is not being registered, it is going to get protection under the law. That is called well-known trademark. Now what is certification trademark? A mark that has been used in any particular device or any particular product showing a particular degree of certification, like green mark in vegetarian showing vegetarian, red mark showing non-vegetarian, that is a certification mark. And certification mark will certify any of the attribute of the product. Okay, students. Collective mark is a mark that has been registered by the group of companies like Tata, Reliance, that is going to be used by different part of that particular group. So being registered with the name of partnership firm or group of companies, conglomerate. Okay. Well-known trademark I taught you, right? Trademark can be used for business purpose, right? There should be some business in order to have trademark, right? Names can be registered as a trademark. This is very important question. Invented words can be used as a trademark. Letter, numbers, symbols, monograms can be registered as a trademark. Colors, shape of goods, but generic shape cannot be registered as a trademark, right? 3D mark, even sound mark, I have given you an example, right? Trademark once registered, remember, even if you are making application for trademark with prescribed form, with prescribed fees, it is subject matter of publication and objection invitation. Now absolute ground for registration of trademark, refusal for registration of trademark, this is very important question. Remember, if your trademark is nothing more than the cut, copy, paste of existing mark or marks, it is not carrying any distinct character, it is not capable enough to give any kind of distinctive character to your product or distinguished identity to your product. Okay, so any mark which is devoid of distinctive character cannot be registered as a trademark. That is the absolute ground of refusal of registration. Okay, now if your trademark is nothing more than showing the characteristic or generic name or generic shape of the product, then generic shape and generic name of the product cannot be used as a trademark. Okay, anything that has been customary used in a dealing of any particular thing which is very common or usual in the trade practices cannot be registered as a trademark. Okay, anything that will lead to deception and confusion amongst the user or consumer cannot be registered as a trademark, so that is also a absolute ground. Any name which is related with which is being related with religious sentiments, okay, cannot be registered as a trademark. Any name or any object that will show some obscene thing or scandalous thing cannot be registered as a trademark. So remember, 3-4 things are there. Any mark which is devoid of distinctive character, then generic name, shape and pattern, then which is being used in customary practices of the trade related with that particular goods, which is hurting religious sentiments, right, which will lead to confusion or doubts, and which is carrying an obscene matter, right, cannot be registered as a trademark. That is called an absolute ground of refusal of registration of trademark. Relative ground is nothing more than you are copying the trademark. It is similar to a well-known trademark. Okay, so that is a relative ground. Is it clear, students? Relative and absolute ground is one of the most important question. Okay, after that, the things that can be registered as a trademark. Once trademark remains registered, it will become valid for a period of 10 years. And after that, it can be renewed for further 10 years. If someone is using your marks without your permission, that will lead to infringement of trademark. And infringement is, penalty will be applicable along with, penalty will be applicable along with compensation to be paid to the concerned person. That is going to be determined according to the fact of the cases. Is it clear how popular the name was? Now when it comes to passing of, see, if someone is using the registered trademark, it will lead to infringement of trademark. But well-known trademark is not registered under this law. They are being recognized under this law. So if you are copying well-known trademark, you can file a case in ordinary law for infringement, and that is known as what? Passing off. Is it clear? So for unregistered trademark, that is well-known trademark, if infringement would be caused, infringement is nothing more than unauthorized use, non-permissible use without taking the permission of the proprietor of the trademark, it will be classified as passing off. It will be classified as a passing off, and you can file an ordinary case of passing off under ordinary law. But when it comes to infringement will be for registered trademark, and burden of proof always lies with the plaintiff who is claiming that infringement has been happened. Okay, whenever it is related with claiming a trademark by your name, always priority of use would be the primary thing. Means the person who is using it for the from the beginning before you would be entitled for the registration of that mark. Otherwise you have to take the permission of the existing concerned person. Is it clear? Like Meta and Facebook got into clash, then the trademark registry clearly state that Meta would only be available to the concerned person who is using that trademark before Facebook. Facebook is now planning to convert its name to Meta. Then Facebook was not having any other option than paying compensation or paying agreed amount to Meta in order to get it registered with their name. Got my point? You can become trademark agent. Trademark agent is nothing more than the person who will make an application on behalf of the client and who will take care of everything. When it comes to, you should be citizen of India, your minimum age should be 21 years, or you should be an advocate or a company secretary, and you should be a fit and proper person. then you can be registered as a trademark agent. Is it clear? So company secretaries are also authorized to register as a trademark agent. Is it clear? Done with what, student? Done with one more chapter of part B. We have done with 3 chapters of part B. First we have done with basics of intellectual property right. After that we have done with patent. After that we have done with trademark. Now we have to do copyright, design and geographical indication, and your ECIPL marathon is over. Right, student? Now only copyright is pending. We will start. Now proceeding further with copyright. When it comes to copyright, it has been available for literary, dramatic, musical, cinematography, these kind of artistic work. And I told you very clearly, when it comes to other intellectual property rights, they are having industrial application, and for copyright there is no need to have its commercial exploitation or industrial application. Even registration of copyright is not essential every time. Once you will publish anything over YouTube, it will be always a subject matter of copyright. Automatic protection has been provided for the copyright. Okay, students? So there is a proper law for the protection of the same, so that if someone is infringing your copyright, they would be subject matter of legal action. You can claim compensation. Okay. It's your integrity right that if you have innovated something, if you have created something, it should be subject matter of protection. If it is not being provided, we would say that creativity and innovation will be stopped, right? For human development, even copyright protection is essential, right? This is the most important question, the validity of copyright. Generally, whenever it comes to copyright, it is having a validity period of 60 years from the date of death of the author. Okay, if there are 2 authors, then that 60 year is going to be counted from the death of the author who dies later. Is it clear? 60 days validity from the date of, for literary, dramatic, musical and artistic work, 60 year from the death of the author. For pseudonymous work, posthumous work, and for anonymous work, it will be 60 years from the date of its first publication. Is it clear? Posthumous work means a work that has been published after the author's death. Pseudonymous work is a work that has been created with the false name, and anonymous work is a work which is being created without putting the name of the author. Is it clear? Without the name of the author, anonymous; with the wrong name of the author, that is called pseudonymous, and one is posthumous, which is being published after the death of the author. Is it clear? So generally 60-year validity from the date of the death of the author who dies later, and otherwise 60 years from the date of following the year, calendar year, from its first publication, right? 60 years. Assignment of copyright means transferring the right to use your copyright material, right? You are assigning permission to some other person. Assignment should always be in writing, and terms and conditions should be very clearly mentioned in the assignment. Okay. Assignment remains valid for a minimum period of 5 years. Only after completion of 5 years it can be revoked. If there is any issues related with assignment of copyright, you can approach a commercial court, and commercial court has to resolve that matter within the period of 6 months. Compulsory license over here is same. If you have been involved in some kind of copyright which is essential to be known by the public, if you are not getting it published over here in India, the government can take over, the registrar can take over the right to give the license, and the license will be given by the government. Although you are subject matter of receiving minimum royalty made mentioned in the contract, but you would have no right to license out your work, right? What is copyright society? It is an association registered under this act. It is collective copyright, collective fighting for the rights of the copyright holder. So one category of, say, for South movies, there is a proper copyright society. For Bollywood, there is a proper copyright society. They are just getting into an agreement and forming a society which is going to let out the copyright on assignment or license to third parties, collecting their revenue after deducting the operational expenses of the society, distribute it amongst the member. The major chunk will go to the original copyright holder. The common chunk will be available for all the copyright society members. Is it clear? That will give a collective protection of rights, or collective letting out or assigning or licensing out the copyright and taking the collective advantage of the same. Is it clear? For one particular field, there would be only one copyright society, and registration of copyright society remains valid for a period of 5 years. After that, renewal is essential. Is it clear? The board of trustee appointed by the member of the copyright society will administer the function of the copyright society. They'll license out, they'll collect the license fees, they'll pay royalties, and they will keep a common chunk available for all the members, right? Copyright society is one of the very important topics, students. Broadcasting organization which is broadcasting any match or any movie or something will have a validity period of 25 years. Performer will have a performance right of 50 years. Okay, generally copyright is a subject matter of 60 years. In case of author existed, then 60 years from the death of the author. Otherwise 60 years to be counted from next calendar year from its first publication. Broadcast reproduction right is 25 years from the date next calendar year from its first broadcasting, and performance right will be for 50 years. Okay. Any copyright material being used in the process of research and development teaching will not lead to any infringement. Okay. If a copyright has been infringed, you can demand for injunction and damages. Even criminal punishment of imprisonment is being involved. 2 years is the imprisonment term for infringement of copyright. Done with copyright, students. Just a minute, one more point I have to cover about any statutory use of copyright material or any judicial use of copyright material will not lead to infringement. A public library can keep 3 copies of copyright book or material. More than 3 copies if they are keeping, that will lead to what? Infringement. This is important. Any intellectual property right can be used for education purpose. Is it clear, students? Done with what? Copyright. What is geographical indication? See, some products are having connectivity with particular geographical location. Like if I would talk about Kashmir ka kesar, saffron of Kashmir, right, is having a geographical indication, right? If I would talk about cashew nuts of Goa, right, it is a geographical indication. If I would talk about oranges of Nagpur or Ratnagiri ke mangoes, okay, these all are geographical indication. Agra ka petha, Kashmir ki shawl, Pashmina shawl. Okay, these are what geographical indication. Logically, they are also intellectual property, right? Because their quality is attributed to a particular geographical location. Now, whenever it comes to registration of geographical indication, you can logically think it cannot be registered with the name of an individual or a firm. It is going to be registered with the name of association of person who are involved in the manufacturing or production of that kind of goods at that particular location, right? So, and it is not subject matter of assignment and transfer, it can only be succeed, right? Succession is possible, that if father will dies, it will going to be succeeded to the son, right? It can be available for agriculture goods, natural goods, or manufactured goods, all. Remember, this is most important question. Any geographical indication which will lead to deception, which is against the law, which is carrying an obscene content, which is carrying religious sensitivity. See, are these all obscene content, religious sensitivities always there with trademark as well, right? So generic names, right, there in trademark, right, that cannot be registered as a geographical indication, right? Generic name, religious suspectabilities, right? Then which is prohibited by court, right? Obscene content, deceptive use, right, is not permissible registration of what? Geographical indication, right, students? Registration process of anything is not important. You'll get legal protection, no one can use it without permission, and the consumer will be protected. It is also trademark and geographical indication is always a tool of consumer protection as well, right? They cannot be dished. Validity 10 year and can be renewed for 10 year, and 10 year will be counted from the date of application. If someone is using it without being the part of that association, it will lead to infringement, right? Assignment is not possible. What is maximum possible is transmission, right? If something has been registered as a geographical indication, it cannot be registered as a trademark, right? Done with the geographical indication as well. Basically, geographical indication is a mark that has been used which shows a connection of one particular goods, manufactured natural or goods, right, or produced goods to a particular geographical location. I have given example as well. Validity 10 years. Certain geographical indication cannot be registered. 2-3 things are important. What is geographical indication? Second one is certain geographical indication cannot be registered. The third one is when it comes to geographical indication, its transmission is possible, assignment is not possible, and the last thing is trademark. Geographical indication cannot be registered as a trademark. Done. Now design, whenever we are talking about design is nothing more than the ornamental appearance of a product, right, that is being visible, right, that can make it like attractive or look good, right, that is called what? Design. We are always talking about external design. Okay, iPhone ka design is a unique design that is being registered under this act. Okay, it must have industrial application, otherwise the design cannot be registered. The person who is owning the design is known as what? Author of the design. Is it clear? Who can register a design? The person who has made that design, maker of the design, or the person who has paid for it. Is it clear? Can get it registered. In everything, any design which is not capable of distinguishing, which is just cut, copy and paste of any other existing design, or carrying scandalous or obscene matter cannot be registered. Only new and original design which is not generic in nature can be registered. Okay. Whatever intellectual property right it is, remember that every intellectual property right before granting is going to be published. Objections are going to be invited, and after sorting out the objection only you can go ahead with what? Registration, right? Validity is 10 years, but it can be renewed for 5 years. So let's compare. When it comes to patent, it is having validity period of 20 years to be counted from the date of application. When it comes to trademark, it will have a validity period of 10 years and can be renewed for 10 years. The third one is copyright, 60 years. 50 years and 25 years, right? 60 years is in case of ordinary copyright. For performer right it is 50 years. For reproduction of broadcasting right is 25 years, right? When it comes to geographical indication, 10 plus 10. When it comes to the last one, design, it is 10 and 5, right? Renovation can only be done for 5 years, right? If you have not renewed the design, you have to get it renewed within 1 year from the date of lapse. Otherwise, and for that period, no protection will be provided. Patent need to be restored within the period of 18 months from the date of its lapse, and design has to be renewed within the period of 1 year from the date of its lapse, right? Design will also bound, everything will be bounding on government, but design and other things can be used statutorily or for governmental purposes or for research and developments, right? If someone is using your design without taking your permission, it will lead to piracy, right? You know, remember, if you want to use that design without registration to be presented in international exhibition, you have to take the approval of controller. This is very important. And once you have represented it in international exhibition, within 6 months from the date of first exhibition publication, you have to get it registered, otherwise you will not get the registration. Repeating it again, can you present a design without registration in an international exhibition? Yes, it does require approval of the controller of design, and within 6 months from the date of exhibition you need to get it registered. Okay. If you are unhappy with the or any order of the controller of design, you may prefer an appeal to the High Court, and appeal can be filed within the period of 3 months from the date of order passed by the controller. Is it clear? Done. Students, part B hardly took 43 minutes to finish. I've just given you a quick revision. All important topic has been covered in the marathon. I haven't get into intense detail of all the topic. It is quick review before the examination, right? And brush up all the important concept of all the topics of ECIPL. What I'll do, I'll also cover up the amendment part. Okay, done, students.